Chapter 21. We had to go out to Cermak Hospital to visit Mr. Gacy. Mata had no idea what to expect. He had been up most of the night before agonizing over this first meeting with his new client. It is only natural to wonder a bit about what the country's worst, most prolific serial killer might be like. Parking your car and strolling into the Cook County Jail is an experience that you will never forget. You travel through several levels of chain-link fence, topped with gleaming rolls of razor-sharp barbed wire. Enough barbed wire to slice a fly in half if that fly is foolhardy enough to attempt a buzz through it. The pea gravel crunches under your feet as you approach the first of many gray, cast-iron doors that clank behind you, much as you might expect they would if you have ever watched a prison movie. Only a jail door sounds like a jail door. The clank sounds quite final, quite irreversible. The doors are guarded by uniformed men or women that block out the sun with their sighs. When they ask for your ID, it is not a request, it's a command. They smile sometimes, but you know from their tone that not one thing that they say is in any way negotiable. Mata and Gacy hit it off just fine, or as fine as anyone gets along with that unusual little man. Gacy smiles and shakes your hand, but that doesn't mean he won't talk shit about you behind your back. That depends on what suits him at the time. What surprised Bob was the level of cream puffery that he met. Gacy strikes you upon first meeting him more as the old Polish plumber who, like an old Saturday Night Live skit, exposes his butt crack every time he bends over to fix the toilet. He is not an immediately intimidating person by any stretch of the imagination. Instead, you are more likely to laugh. He is more of a wimp with a thick Chicago accent, who obviously spent a great deal of time caring for his mother. This is the monster that everybody has been talking and writing in the papers about? Bob was thinking. What Gacy did more than anything else during their first meeting was whine and bitch like a little old lady in a bad restaurant. He had complaints about nearly everything. Bob and I just looked at each other, incredulous, as if to say, "Yeah, John, it's jail." We refrained from stating the obvious. After some time, our actual mission was finally accomplished in that Gacy approved Bob Mata as my co-counsel. One problem that loomed ominously in the distant future was a simple concern about how we were going to get paid. Money was not our first concern, but we had to pay the rent, we had to eat, and we had to feed our families. Gacy had paid me a retainer when he had an ongoing business. Now, he had jobs lined up that he would never finish. He had accounts receivable that he would never collect. And most of his other semi-liquid assets, tools, vehicles, and the like, had been confiscated and were being held by the state as evidence. His primary asset, his house, was being systematically destroyed as body after body was excavated from the crawlspace. No one was suggesting that the investigation and excavation of the crawlspace be interfered with. However, there was talk about getting court approval to raise the structure to make the investigation easier. That we would have to oppose. Otherwise, how would we get paid? The case had been up in court on the 29th, and the following orders had been entered by the court. The case was continued by agreement of the parties to January 10th, 1979, where the matter would be reassigned by the chief judge. Now the case was being transferred to the Criminal Courts Building at 26th Street and California Avenue, one of the most famous courthouses in the country. Clarence Darrow, among other noted attorneys, argued cases in its hallowed courtrooms. The night before that court appearance, on the 29th, the night of December 28th, was a lesson in humility for me. I was in my office feverishly trying to prepare motions, motion to dismiss, motion to transfer, etc., etc. These were preliminary motions that I needed to file with the court. and in general I was attempting to prepare for this big, important case. I was feeling pretty full of myself. My picture had been in the paper, and I was the hotshot criminal defense attorney charged with representing the defendant in this huge case. Hell, it was going to be the trial of the century. Everybody said so. My secretary, Earlene, and I were in the office well into the evening hours. Even she was proud to be working for such a famous guy and on such a famous case. Suddenly panic struck. I looked at the clock on the wall and realized that my suit, my one and only suit, was at the cleaners. I had dropped it off to be cleaned in anticipation of this big day. If I didn't pick up that suit, I would have nothing to wear to court the following morning. I begged Earlene, "Would you please pick up my suit while I finish making copies and getting everything ready for court?" "I suppose," she said, teasing me, "but don't get used to it. I'll meet you at my house," I called to her as she hurried out the door, all bundled up in coat and scarf against the weather. Earlene had her own problems getting the suit. First, the snow and ice were making driving a chore. Then, when she finally arrived at the cleaners, it was closed. Luckily, she saw a light burning in a back room. She pounded on the door. The owner responded, shaking his head and pointing at the closed sign in the window, pantomiming his regrets. "Please, sir," she pleaded through the glass, "you have to help me. My boss is Sam Amirante, the attorney representing John Wayne Gacy, the guy in the news, that guy with the bodies under the house. He has to have this suit for court tomorrow. He needs it." Earlene was proud. The guy was totally impressed. He immediately opened his doors and made the extra effort to help. She was working for a pretty important guy. How cool. With perfect timing, Earlene and I arrived at my house at the same moment. We both pulled up to the house together. I thanked her profusely as she ran up to meet me with the suit. We stood there, on the walk, surrounded by piles of snow, both of us excited about this important case and all that was happening. The porch light came on, and my wife, Mary, appeared in the doorway. "Hi, Earlene," she said politely, smiling at me. Then she turned to me. "Honey," she said, still smiling brightly, "we need toilet paper. Go buy some toilet paper." Did you ever hear air escaping from a balloon? That is the sound that my ego was making as I dutifully trudged through the snow back to my car as the two women in my life silently giggled. I drove away. No job is finished until the paperwork is done. Bob and I huddled and began to plan strategy and assign ourselves specific areas of concentration. We began to see the path on which we would attempt to walk through the minefield that lay ahead. We immediately became a team of two, partners. The case would ultimately be assigned to the Honorable Judge Louis B. Garippo, which was a testament to the wisdom of the Chief Judge, the Honorable Judge Richard Fitzgerald. It was well known that the normal process of computerized assignment of judges was circumvented just this once by the Chief, due to the particular sensibilities and temperament of Judge Garippo. Nobody questioned this assignment, with good reason, because Judge Garippo was clearly the right man for the job. The evening before my first appearance before Judge Garippo proved to be an interesting one. The death threats and criticism in the press were increasing as more and more bodies were recovered from the crawl space beneath Gacy's house. I tried hard to ignore the onslaught, but it was wearing on me. I had always tried to keep a reasonable relationship between myself and the venerable members of the press. However, I was fielding questions that didn't sound right to me, not in a free society where a defendant's presumption of innocence is paramount. Finally, it was time to set the record straight once and for all. After being asked a particularly snotty question by a particularly snotty, faceless reporter somewhere in the back, I finally went off. I wanted the sad little anonymous commentators out there, the purveyors of the ugly threats to my kids and to my wife, hiding in their homes and fortified with a bottle, to hear me clearly. I looked squarely into the lens of the camera in front of me, pointed at it, and by extension at each and every one of the little cretins hiding on the other side of it, and screamed a tirade at the top of my lungs. I went on, paraphrasing the Constitution, railing on about how every person in the country was entitled to a trial in which he or she was able to confront his or her accusers and the witnesses against him or her, no matter what the charges may be. I talked about the sanctity of the right to a trial by a jury of our peers. I was worked up. It finally ended as follows. I will defend this man, my client, until the last drop of my blood if necessary. This is America. It is my understanding that this interview was widely disseminated. It seems that everyone saw it, and that included Judge Garippo. Therefore, when I approached the bench the following day, on my first day in front of the esteemed judge, the following exchange took place. Good morning, Your Honor. Sam Amarante, representing the defendant, Mr. Gacy. Before I could say anything else, Garippo interrupted. Excuse me. Is someone talking? Stand back a little farther so I can see you. I backed up. Yes. Back up some more, said the judge, motioning to me. Needless to say, this threw me just a little. I took another step backward and eyed the judge. He smiled down from the bench, peering through wire-rimmed glasses with what I thought to be a particularly mischievous look, a smirk maybe. Well, Mr. Amarante, I expected to see some kind of 6'4" gargantuan kind of guy, based on what I saw on TV last night. That was you, pointing and screaming into the camera, right? Now, here you are, and I could hear you talking, but I couldn't see you. You are not 6'4", are you? No, Your Honor, I'm not. I guess the camera shot on the news the night before was a head and shoulders shot, and the judge could not get a perspective on my actual size. We stood there, appraising one another for a long moment. It was a moment that I will always remember. But I had something up my sleeve that I believed would cause him to always remember the moment as well. I handed up a piece of paper, a small card, passed it up to him as he sat perched on the bench. Well, Your Honor, allow me to present our first motion. Here's what I handed to him. The card had a picture of a ball-peen hammer looming over 3 red clay bocce balls. At the bottom was written, Sir, si prega di non rompermi le pali. The translation from Italian to English is loosely this: Sir, please don't break my balls. A hidden smile flirted at the corners of the esteemed jurist's mouth and filled his eyes as he looked back at me. He kept his judicial demeanor, however, never wavering. I see. Okay, Mr. Amarante, step back. We will proceed accordingly. Any other motions? And with that, the case of the people of the state of Illinois versus John Wayne Gacy officially began. We had a judge and a courtroom assigned, a place to do battle. Of course, it would be just over a year before the actual trial would start. But the preliminary struggles would start today. Chapter 22. As it turns out, Jack Hanley was a real person, sort of. Plus, he was really a cop. It seems that Gacy and Officer Hanley had met sometime while John was working at Bruno's, a restaurant where he worked for a short while as a short-order cook after he was released from prison in Anamosa. Of course, Officer Hanley's name wasn't actually Jack, but in John Gacy's wandering, lost mind, it was. Officer Hanley was not a homicide detective either. However, if you asked John, he would tell you that he was. Without explanation, John Gacy would occasionally use this name when cruising Bughouse Square. He always believed that it was much cooler to say he, John Gacy, was a homicide cop named Detective Jack Hanley. a suave badass who solved the unsolvable crimes, rather than the truth that he was a dumpy, boring, small-time contractor who lived with his mother in the suburbs. Now, in his defense, John Gacy was not the first guy in the world who has told a little white lie in an attempt to get laid. I have seen a lot of multimillionaires with really bad shoes and worse haircuts in meat markets and watering holes. Most of these stories fade with the morning sunlight as the alcohol is metabolized and eliminated from the body. For some unexplainable reason, though, John Gacy decided that it would be in his best interest to claim that Jack Hanley was his alter ego, his second personality. Unlike other men who have lied in pursuit of poontang, John seemed to adapt Jack as a second persona. So when John was flitting from cop to cop and prosecutor to prosecutor, confessing his awful crimes like a bumblebee goes from flower to flower, he was telling many of them that John Gacy did not commit these grotesque acts. Jack Hanley did. Now, please keep in mind that Gacy did not mention the name Jack Hanley during the endless drunken ramblings that spewed forth during his soul-searching confession at my office with Leroy Stevens. However, he suddenly had a second personality buried deep inside when he told his story to the police. This was simply Gacy being Gacy. John always knew best, or so he thought. These were self-serving statements, a silly, uninformed attempt to set into motion some sort of flimsy departure from reality. What this accomplished, together with the fact that Mr. Gacy could not simply just keep his mouth shut, was to set in stone the only defense available to him. Mata and I would have no choice in the matter. We would be required to assert the insanity defense at trial. It was John himself that left us no other alternative. Oh yeah, there was one other reason why we were limited to asserting the insanity defense. John Wayne Gacy was certifiably, without a doubt, with all certainty, batshit, bonkers, cuckoo, crazy, insane. This fact would become painfully obvious over time. Bob Mata and I had our work cut out for us. We solidified as a team and began the process of representing America's most hated man. It has been said that when the prosecution builds a case in court against a defendant, it is like building a wall one brick at a time. Each brick has to support the bricks laid on top of it in order to support the wall. If the defense can chip away at a particular brick, or at several of them, this can cause the whole wall to come tumbling down. Bob and I sat in the office, spitballing, looking over some of the evidence that the state had against our client, tracing the steps that they had taken that brought us all here. It was our job to challenge each and every one of those steps and then to devise some sort of affirmative defense based on our client's inability to understand his actions or to conform his behavior within the confines of the law. We started at the beginning. The very first search warrant that, among other things, turned up the photograph receipt that first tied Gacy to Rob Piest. The original item of evidence that put Rob Piest inside Gacy's home. Look at this. I was waving the very first complaint for search warrant around, which had been drafted by Lieutenant Kozenzak and Terry Sullivan. There is nothing here about a photograph receipt. When a complaint for search warrant is presented to a judge in an effort to procure an actual search warrant, it must be quite specific. The items that the officers and the assistant state's attorney wish to recover must be delineated in the complaint. Representatives of the state cannot enter a suspect's home and simply look willy-nilly for just any old thing that they think might help their case. That would fly in the face of the Constitution. If, during the course of a legal search, the officers conducting the search come across items that are on their face illegal and those items are in plain sight, then those items can be legally confiscated. However, items not delineated on the warrant, which are not per se illegal, are not subject to confiscation. There is nothing illegal about a photograph receipt. Why would they have a right to grab that item out of the house? Bob asked, with full knowledge of my answer. They shouldn't be able to, I said. Even if this photo receipt document was in plain sight, it is not contraband. It is not something they can just grab. This item should be excluded. Where did they find this? They found it in the garbage in the kitchen, in the garbage bag. They cannot go snooping in the guy's garbage, can they? They may be able to, once it is thrown out by the curb. There are cases that say that at that point it is discarded, abandoned. You know all those cases where private detectives go snooping on celebrities? But this garbage was still in his house, under his control. It may not even have been garbage. Maybe it was just a bag of items that he intended to keep. But we don't have to get to that issue. This item was not delineated in the warrant, and it could never be considered contraband. So they cannot seize it, right? What possible theory could they use? And look at this. Bob was now looking at the second search warrant. They got a warrant based on a smell? A smell? Geez, the smell of putrefied bodies? How can anyone tell the difference between a decaying human body and the decaying body of any other kind of animal? Hell, of an old moldy piece of half-eaten steak in the garbage, for that matter. Decaying flesh is decaying flesh. And so it went. We picked through the documents and each item of evidence that we knew about through every single move that was made in the collection of the evidence. Every day and night, we would pore over the minutiae of the case. We were back and forth to Cermak to interview Gacy. Sometimes Bob would go out and talk to Gacy. Sometimes I would do it. Often, we would go together. We told Gacy to write down every thought, every memory, anything and everything that came to his mind that could help us to better understand the case, to better understand him. On one of our visits, he gave us this. Number 1. John Wayne Gacy Life Highlights, High, H, and Low, L. 1942. Born March 17, 1942. Edgewater Hospital, 12:25 a.m. 1943. Nothing. 1944. Nothing. 1945. Nothing. 1946. Olsen girl took my clothes off. Going to Springfield. First train ride. Getting whipping from Dad. Messing up car parts. 1947. Starting school. Being afraid of fire engine siren. 1948. Having stitches in right hand. Being scared of the black hand. Kids game. 1949. Getting beating from Dad for messing with Roberta Ritchie. Didn't like contractor taking me for rides. Messing with me. 1950. Changed from public school to Catholic. Dad is operated on. Back injury. L. Mother scared us kids that she was leaving. L. 1951. Dr. Barrows tells of my heart condition. L. 1952. Moved to 4505 North Marmora. H. Happy adventure. 1953. Going to Wisconsin fishing with Dad, alone. L. Blame for anything wrong. 1954. Nothing. 1955. Cutting school a lot. H. Failing. Sickness. L. 1956. Changed to vocational school. H. Dad putting me down. L. Started working. H. First job, IGA store. 1957. Sickness. 2 operation. L. Hit with a swing in the head. L. Working and going to school. 1958. June graduation. Number 1 in my class of 79 students. H. Received American Legion Scholastic Award. H. Starting high school. H. Sickness. L. 1959. Hospitalized a lot. L. Number 2. 1960. Sickness. L. Accident. Fell from second floor of building, spine injuries. L. Got my first car with Dad's help. H. 1961. Asked to leave high school because of health risk. L. Sickness. L. Dad down on me. L. 1962. Fought with Dad. Ran away from home in May. L. Depressed. Lonely and lost, returned after 3 months. L. Older sister got married. H. 1963. Traveled for Nunn Bush Shoe Company as manager. H. 1964. Jan, younger sister, got married. H. Parents' 25th wedding anniversary. H. Moved to Springfield. H. Girlfriend Maureen died. L. March engaged to marry. H. September I married Marilyn. H. Ran largest Xmas parade in Central Illinois. H. First male sexual experience. L. 1965. Great married life. Marilyn pregnant. H. Honored as Man of the Year, Springfield, Illinois. H. Chosen Outstanding First Year, JC Local District. And third place in Illinois out of 13,800 member. H. 1966. Michael John was born. My son. H. Moved to Waterloo, Iowa. New job. H. 1967. Honored as Man of the Year in Waterloo, Iowa. H. Unhappy working with father-in-law. L. Hated him. 1968. Sodomy conviction. L. Prison. L. Divorce. L. 1969. Completed schooling. H. Sick. Heart attack. L. Dad died Christmas Day. L. December 25th. 1970. Honored Man of the Year. Anamosa, Iowa. 1969. H. Declined parole March. L. Granted parole May. H. Returned to Chicago. Start new life. 1971. Moved to 8213 Summerdale. Number 3. 1972. Got married to Carol. H. Self-made family, 2 beautiful little girls. H. 1973. Problem with mother-in-law. L. Sickness. Hospitalized. June. L. 1974. First yard party. Luau. H. 1975. Problem marriage. L. Second yard party. Western barbecue. H. Appointed to county board. H. Lighting district. Divorce. L. Director of Polish parade. H. Became Pogo the Clown. H. Business good. H. Confused, not happy. L. 1976. Divorced final. L. Depressed. L. Third yard party. Spirit of 76. H. Polish parade director. H. Business booming. H. Not happy. L. 1977. Business skyrocketing. H. Lonely, confused, not happy. L. Fourth yard party. Southern Jubilee. H. Polish parade director. H. Engaged to marry third time. Broken off. L. 1978. Business peaking. H. Lonely, depressed. L. Carol pregnant. Not by me. L. Fifth yard party. Italian festival. H. Polish parade director, President Carter wife visit, in charge. H. November, Carol married. L. Arrested December. Confused. L. 1979. Lost, lonely, confused, no will to live. December 25th. Died. As Bob and I reviewed this disjointed document, we were perplexed. John had included some of the oddest references that no one would expect, together with many of the most obscure moments from his life. He also included his most hated activities, his first sexual acts with men. However, he failed to include any reference whatsoever to one very important aspect of his life, the fact that he had killed over and over again. Mundane, minute details from his life were there on each and every page. Yet, according to this document, John Wayne Gacy had never taken a life. Was he still attempting to hide this part of his life, even though he had confessed it to me and to others? Or was it something deeper? Chapter 23. While Bob and I were preparing and filing stacks of preliminary motions and investigating the case during its early stages, and while these various motions were being set for hearings in the months to come, another true emergency arose that required our immediate attention. This turned out to be an emergency of epic proportions because it involved money. Our money. Our own money. The excavation process that was necessary to recover the bodies was ongoing. Day after day, the body count rose. The staggering number of bodies, together with their location, was causing significant damage to the structural integrity of Gacy's house. However, at least so far, the process had left the building intact and standing. In the wind was this nagging assertion about a plan by the sheriff's department to raze the house entirely, thereby making it easier to search for and recover any bodies not yet found. There is absolutely no question that the excavation process was made more complicated by the fact that a house stood over the hideous burial site, and Bob and I could certainly understand why the guys working on the tedious recovery process would love to work without a house overhead, but we could not stand by and let this plan come to fruition without a fight. A serious fight. There were constitutional issues at stake as well as other issues of great concern: money. It was true that our client, Mr. Gacy, had been charged with crimes more grotesque than any in recent memory. Some would say that the charges were unparalleled in all of history. There is a tendency, when an alleged crime is particularly horrifying, to forget the rules or to attempt to bypass those rules altogether. The idea that the sheriff's department could simply tear down a man's house in order to make it easier to reach undiscovered bodies was a classic example. There is talk that they want to tear down Gacy's house. I got this from a reliable source inside the sheriff's department. They want to tear the whole goddamn thing down and cart it away in trucks, I said excitedly as I burst into the office, shaking and stamping off wet, melting snow. I threw my overcoat on the couch. I was freaking out. This time, I think they're really going to do it. Bob was alone at the desk we shared with a single lamp burning, buried in books and paper that continued off the desk and onto the floor all around him. He hadn't even noticed that it had gotten dark outside. He was researching issues that had to do with all of those previously filed preliminary motions. Motions to dismiss, motions to quash, motions to suppress. He looked over the top of the mounds that covered our one desk with an incredulous look. If it wasn't one thing, it was another thing. We had heard talk of this motion, this rumor, in days past, but now it seemed to be imminent. At least, that was the buzz. They can't do that, Bob was shaking his head in disgust. We still have a constitution in this country, right? They didn't do away with it while I wasn't looking, did they? I think there is something in the Fifth Amendment that has to do with not depriving persons of life, liberty, or property without due process of law. I'm sure I read that somewhere. Maybe it was in law school. Sarcasm dripped from the walls. Oh yeah, I think it goes on to say something about no private property being taken for public use without just compensation. So, there's that too. Have these people lost their minds? I hate to admit this because I'm as idealistic about the Constitution as anyone on the planet. You know that. But that's not the worst part. That house is our fee. Our fee is in that house. Nobody is going to pay this guy for work that he has already completed. So his accounts receivable are worthless. He has basically nothing to speak of in his bank account. His cars, trucks, and virtually any other big-ticket items he owns have been confiscated. That house is Gacy's only asset. It's the only thing that he has left to pay us with. This was serious. The thought of starvation hung in the air. I had 2 little kids and a wife. Bob had a child, an ex, and child support. Plus, we had to eat. That's not being selfish, is it? That's not too much to ask. We needed sustenance in order to have the energy necessary to defend this guy. We would pass out right there in the courtroom if we didn't eat, right? That would never do. That would be a bad thing. We had no savings. Public defenders aren't paid enough money to save any of it. Both of us were fresh from the PD's office. We could barely pay the day-to-day bills, let alone save. Now we were on our own, which was worse. We had no other clients, and Gacy had sucked the air out of any other potential ones. We didn't have time to do anything else but work on this case. Just ask my wife about that one. We barely saw each other anymore, and she was none too happy about that, by the way. Wait until I got home and tried to explain to her that we were destitute. Fireworks were in my future. So, like I said, this was a bit of an emergency. What we did not know was that the rumor that I had heard was actually much more than a rumor. It seems that a notice of a court appearance had actually been sent to Mr. Gacy and to his civil lawyer, Mr. Leroy Stevens. A pending court action had already been filed, and a hearing was scheduled on Tuesday, March 27th, in Housing Court in front of the Honorable Judge Richard H. Jorzak. Bob and I were completely unaware of this pending court date. The petition before the court alleged that the excavation process had rendered the structure unsound, that the whole structure was on the verge of collapse, and that it was a danger to the men working as part of the excavation process and to the residents of the neighborhood. For some unknown reason, Leroy Stevens failed to appear at that Tuesday morning hearing. As a result, Judge Jorzak entered an order that the house be razed, having heard no evidence whatsoever opposing such an order. Huge yellow bulldozers, a towering crane, together with several imposing dump trucks and other items of demolition equipment, had positioned themselves in the front yard and in front of the house on Summerdale Street. Our client, Mr. Gacy, was about to become financially insolvent. Wednesday morning, Bob and I appeared before Judge Jorzak on an emergency motion to stop the demolition. We explained that we had not been informed of the hearing that was held the previous day and argued that the demolition of the structure was an unconstitutional taking of property. We insisted that a full hearing be held to determine whether or not the structure was actually unsound. The judge agreed. He would not have entered his original order if someone had only stepped up to represent Gacy's interests. Armed with an order of court, essentially a flimsy little piece of paper, we careened through traffic at dangerous speeds and slid to a stop in front of Gacy's house amid the hulking trucks and bulldozers. There were always gawkers in front of Gacy's house, curiosity seekers huddled behind yellow police tape. Today, however, the crowd was unusually large and included at least one camera crew. The demolition of the Gacy house was big news. We waded through the pack of onlookers and ducked under the police barricades, waving the court order and hollering a single word: "Stop!" Hard-hatted construction workers holding clipboards and screaming over the rumble of diesel engines were pointing and planning where to begin the teardown. Bob and I slogged through the mud and slop that was once the meticulously manicured yard and circular drive in front of our client's house, looking for the guy who seemed to be in charge. We presented the order to the foreman on the job, who shrugged, shook his head vigorously, then zipped a flat hand back and forth in front of his throat, signaling the guys in the bulldozers and trucks to cut their engines and stand down. This disappointed many in the crowd and the boys with the TV cameras. A collective groan could be heard. As the crowd groused and grumbled and then slowly dispersed, and the camera crews packed up and went on their way, Bob and I silently basked in our minor victory. You really have to stand in front of a huge wrecking ball hanging from a crane, feel the earth rumbling under your feet from many idling diesel engines, smell the burning fumes, hear the deafening sound of it all, and confront a big, burly man in dirty dungarees and wearing a hard hat who is totally committed to his mission, with an 8.5 by 11 piece of paper before you can fully appreciate the feeling. It was a feeling that says that this country and the people in it still live pursuant to the law, pursuant to a constitution, which was more powerful than all the swinging wrecking balls, all the huge towering cranes, and all the rumbling dump trucks. It had nothing to do with Bob or me. This was much bigger than a couple of young lawyers. This was the best parts of our system of government, of our laws at work. We were proud to represent that system that day. A victory, yes, but a hollow one, as it turned out, because on April 4th, just 8 short days later, the date on which the matter was set for full hearing, we appeared with our expert witness, Paul Gordon, an independent private structural engineer. The state's primary witness was William Harris, the Cook County Building Commissioner. There, a battle of the experts took place, in which Harris testified that the structure posed a hazard to the health and safety of the public, in that the house could collapse or flood or both. Gordon testified that the particular clay-laden soil that existed below the house had stiff characteristics, and that due to this, the excavation had resulted in no damage to the footings, foundation walls, or the concrete piers that supported a steel I-beam, and therefore the structure was sound, in spite of the extensive damage that had been done to it. The judge ultimately ruled in favor of the state and ordered the razing of the house. Again, our system of laws had worked. We just were not on the winning side. This presented a huge problem for Bob and me. We hit the books. In the state of Illinois, as in many other states in which the death penalty is available, if a defendant is indigent, the presiding judge may appoint outside or private counsel on behalf of the defendant, and that counsel is paid by the county, essentially as a public defender, although the private attorney is not an employee of the county or the state. The hourly rate is set by statute and is far less than that which a private attorney would normally charge. However, a private attorney would pay many of his or her own expenses out of the fee that would be charged to a wealthy or well-off client. Subject to court approval, a private attorney that is appointed by the court may apply for the payment of certain expenses, including the sometimes rather exorbitant fees charged by expert witnesses. After a great deal of research, many long hours, gallons of coffee, and several packs of cigarettes, we emerged from the office with another emergency motion to present to Judge Garippo. This was becoming routine of late, nothing new. However, this time it was quite personal. We must have done our homework because, without much fanfare, we were appointed as counsel for the defendant, Mr. Gacy. We breathed a collective sigh of relief. We would now be able to continue on the case and feed our families, which was a good thing. I don't think I would have stayed married very long if I had come home and announced that although I would still be working 20 hours a day, I would not be getting paid for it. Appointment as counsel had other very positive results. I say positive because it was positive for our interests and the interests of our client. There are those individuals that held the opinion that any funds spent by the state or the county on Gacy's defense was a travesty, a waste. Money spent in the devil's defense. We would now be able to proceed to provide our client with a proper defense. In the long weeks and long months that followed, Bob and I would turn over every rock, every stone to ensure that our client had that proper defense. As those days became weeks, and those weeks became months, an entire year would pass before both sides of the case would be prepared to collide in a battle that would be reported worldwide and cause the very tenets of our democracy to be tested, nearly to its breaking point. Passions would flare at each and every turn. Criticism of our efforts was relentless. Gacy was the most hated man in America, and by proxy, so were we. He was the monstrous clown killer that did not deserve to breathe the same air as normal folks. He certainly didn't deserve to be defended. Chapter 24. The year 1979 passed in the blink of an eye, a whirlwind of day-to-day investigation and preparation blurred together like a pipe dream. The Gacy file, a small cluster of papers, written interviews, a few court documents, and various notes written on a yellow legal pad, all of which once fit into a single file jacket and could be carried under my arm or in my briefcase, had ballooned into a mass of paper, documents, exhibits, photos, and paraphernalia that filled an entire corner of our small Park Ridge office. Boxes stacked haphazardly on top of other boxes threatened to push the ceiling tiles through the floor of the office above. Suddenly, we had a trial date staring ominously, stubbornly at us from the calendar on the wall. Gacy had consumed our existence for an entire year. We were both totally committed to the defense of this man's life, and now it was time to lay it all on the line. Every waking moment had been dedicated to the investigation and preparation of this case. Don't get me wrong, Bob and I did not spend all of that time cloistered in a dark office with our noses buried in law books. A large part of the job was spent very much out in public. We were being stalked by the print media and interviewed on TV almost nightly. We had meetings with psychiatrists and psychologists, investigators, jury consultants, and witnesses from every walk of life and from all parts of the country. Our small, shared office space was a bustle of activity and excitement, which included a few extra members of the team. A young, freshly graduated female paralegal, Julie Weiss, had volunteered as an intern, and the public defender's office had assigned us 2 investigators, Nick Matusas and Lindy DiDomenico, to help with the overwhelming workload. Nick and Lindy had traveled all over the country interviewing witnesses and taking statements from any and all persons that had ever had a connection to John Wayne Gacy. This included all the people who knew him in Springfield, in Iowa, in Las Vegas, any out-of-state job on which he ever worked. Anyone anywhere that had met Gacy was sought out, contacted, and statements were taken. We were looking for anything that could lead to a better understanding of our client, to help in his defense. Boxes were filled and stacked with the results. We left no stone unturned. Our days and nights were chaotic. Flashing camera bulbs and shouted questions often began in the morning on the way out to our cars and our driveways and didn't end until we locked our doors behind us at night. It was fun, for the most part. If you love the law and the insanity that accompanies a high-profile, internationally reported press case, if you didn't mind giving your life over to the scrutiny of the public eye, if you didn't mind being associated with America's most hated citizen and being personally scorned and hated for it in some circles, it was great fun. We were the center of attention in all of Chicago. Not everybody hated us. After all, we really were becoming local celebrities, hell, national celebrities. We got along with all the press people who followed us around all day and night. Most people had stayed awake in civics class. They knew that everyone is entitled to a defense and a trial. We were just lawyers doing our jobs to the majority of folks, just lawyers being lawyers. There were even Gacy groupies, women who were interested in us just because they had seen us on TV. Of course, that didn't matter to me. I was married. But Bob wasn't. Bob was quite single, quite available. So, if you viewed it from a distance, it probably looked fun. In truth, it had its ups and downs. Nobody likes to be relentlessly vilified, especially when you know deep in your soul that the job you are doing is absolutely necessary to the administration of justice. Wives and family members were involuntarily swept up in the tornado of activity that came with the territory. They hadn't signed up for this level of crazy. The death threats and late-night telephone calls from the truly stupid and cowardly became part of our lives. Members of the press at times bothered my wife and even my parents. Our kids were occasionally teased and chided at school. Everybody on the planet seemed to have an opinion on what we were trying to do, and they were none too shy about sharing that opinion, sometimes at the most inconvenient times and in the most inconvenient places. People would stop us in the supermarket or the church parking lot on Sunday morning to let their opinion be known. We actually could not take a piss in a public restroom without hearing the well-reasoned pontifications of some drunken expert on the subject of John Wayne Gacy. But all in all, considering that both Bob and I had always had dreams of being retained on that really big, important case that made a difference, that mattered, the whole experience was exciting. And yes, it was fun. However, in spite of the mind-numbing roller coaster ride that we had been on, this was only the beginning, the preparation stage of the case. Now, we had to try that case in a court of law. A man's life was at stake. And the true gravity of it all grabs at you when you look at that calendar and see those days ticking off. Had we done everything? Had we turned over every rock and every stone? Did we interview every witness, search our client's past, hire the appropriate experts, categorize each and every piece of evidence, take every available step in the furtherance of our client's cause? Were we ready? The resounding answer to each and every one of those nagging questions and 100 more was quite simply, yes. Bob and I had done our part. In spite of what the world thought about John Wayne Gacy, in spite of the efforts and the protestations of the cuckoos and the crazies and the uninformed, Mr. Gacy was going to receive a fair trial in accordance and in keeping with the dictates of our Constitution. Then it would be a jury of his peers that would decide his fate. It was a tumultuous year, and it started off with a bang. On Friday, January 12th, 1979, it started snowing blizzard style, and it didn't let up for 2 full days. On top of approximately 10 inches of already accumulated snow, there fell another 20.3 inches of freshly fallen white stuff, setting new records in our fair city. By the end of January, there was an approximate accumulation of 47 inches of snow and compacted ice covering all of Chicagoland and making travel next to impossible. Every time you left the house, it was an adventure. Amid this external chaos, Bob and I were sinking our teeth into the specifics of our task. After researching, preparing, and filing the numerous preliminary motions, we began the search for some of the best psychiatrists and psychologists in the country. Gacy had confessed to his crimes. His crimes were hideous and unprecedented. He had painted himself into a very small and very specific corner. And he was caught holding a very wet paintbrush. His one and only course of action, aside from simply pleading guilty, was to enter a plea of not guilty by reason of insanity. After having spent a great deal of time with John in recent weeks, I was convinced that this plea was not only his best and only course of action, and in his best interest. It was absolutely true. As far as I was concerned, John Wayne Gacy was bonkers. He was clearly insane. I had watched him go to places in his mind I had never seen anyone go. I had represented hundreds upon hundreds of criminals during my years as a PD, and this guy took the cake. The disjointed and rambling tale of horror that he had disclosed to Stevens and me on that eerie, crazy night in my office, the night before he was arrested, was evidence enough. On that night, when Gacy spoke, it was as though he was not even present, like he was not even there. I saw his eyes flutter, and it seemed as though he became a body inhabited by another, something unholy. He didn't even remember telling us about his endless, disconnected dissertation of the grotesque events of his life over the past 2 years. Of course, I'm no shrink. As far as I was concerned, this determination was a job for professionals. Bob wholeheartedly agreed on both counts. Bob was quite sure that our client was crazy as a bedbug, and he thought a professional head shrinker should confirm his diagnosis for the record. What began as a rather routine, offhanded statement of fact by a couple of young lawyers about their client, "We will have to start looking into who are the best psychologists and psychiatrists in this field and line up some interviews and examinations for him," turned out to become a major preoccupation of the field of psychology. Every local member of the fine profession of men and women who were involved in the field of study of the human mind wanted a crack at him. It was not hard to find shrinks to become involved in the case. During that year, our client was subjected to psychological and psychiatric probing and poking on a level beyond the imagination. While incarcerated, he was drunk, drugged, hypnotized, interviewed, and cross-examined. He saw charts, graphs, ink blots, storylines, and forms of all color and description. He drew pictures, looked at pictures, analyzed pictures, and became a picture. They talked to him while he was standing, while sitting, and while lying down, while sleeping, waking, half asleep and half awake, while in conscious, semi-conscious, and unconscious states. All this in an effort to determine that which Bob and I knew in an instant. Gacy was nuts. The big question, however, still remained unanswered. Was he nuts enough? Could John Gacy appreciate the criminality of his conduct and conform said conduct to the requirements of the law? That was the question for the jury. When all was said and done, there were almost as many opinions on that issue as there were psychologists and psychiatrists who were studying it. One fact unearthed during all of the interviews and interrogations by the various renowned shrinks that hit home for me, and which always anchored my belief that my client was insane on a level sufficient to have him found not guilty by reason of insanity, was this. When John Wayne Gacy was 5 or 6 years old, he developed a fetish for his mother's silk undergarments. He said he liked the feel of them. He would fondle his mother's lacy panties and rub them on his little body. When he was done doing what he did with these items, and this made the hair on the back of my neck stand up straight when I heard it. He would bury them under the house. When John's mother began looking for several pairs of underwear that she thought she had lost, she found a small bag filled with panties, partially buried under the porch of the Gacy home. John was punished by his parents, and his mother's panties stopped disappearing. However, by the time John was a teenager and reaching puberty, he had graduated to stealing those coveted items from neighborhood clotheslines. He was now old enough to use these items during masturbation, which he regularly did, and when he was finished, he would revert to his original behavior and bury those items, often under the house. This simple revelation, especially when taken in conjunction with everything else I knew about this sad, sad excuse for a human being, which appeared in report after report from doctor after doctor who had interviewed him, basically cinched it for me. John Gacy, my client, was on a psychological choo-choo train that went off the tracks many years before. The destination of that train had been predetermined. The normal synapse that happens in your brain and my brain and the brains of everyone else we know just did not happen in the brain of Mr. Gacy. He had, in fact, been miswired at the factory. He had a broken brain, and that brain had been broken long ago. That was my opinion then, and it still is, and I sleep very well at night while holding it. The theory that allows me to comfortably hold this opinion is surprisingly simple and has been stated in many ways throughout time. Here is one. If a person who has reached the age of majority becomes angry with another person and says, "I'm going to kill you," then that person methodically walks into another room with plenty of time to think about his actions, grabs a loaded shotgun from the closet, and walks back into the first room where the other person is standing and proceeds to blow this person's brains all over the wall behind him. We call that murder. However, if the same set of circumstances occurs and the perpetrator is a minor, let's say he or she is 7 years old, it becomes a terrible, tragic accident, like lightning striking or a collision in traffic. Why? Because we don't blame small children for their actions, no matter how sad and terrible, no matter how horrific the results may be. We know that 7-year-old children are not responsible for their actions. This is not a hard concept to grasp. Their little brains have not matured enough. They cannot understand the consequences of their actions. Hell, the Catholic Church takes the position that they cannot even commit a sin. Everybody understands this. Where the waters become muddy, where understanding becomes fleeting, is when the child is 6 feet tall, weighs 200 pounds, and has a 5 o'clock shadow, or has long blonde hair and big perky breasts and chain smokes. That is when the problems arise. However, the brain of an adult can be so broken, so dysfunctional, that it is of no more use to that adult than the brain of a 7-year-old child. It just does not work properly. It's broken. And it causes the adult to act in ways that are unacceptable without the willing consent of its owner. Chapter 25. In spite of the very serious nature of the matter at hand, the trial of a man accused of the murder of 33 young boys, when you live with something every single day, no matter how serious the subject matter, one must break free of the solemnity on occasion just to remain sane. At the outset, in any trial where the mental health of a defendant might be an issue, a determination as to whether the defendant is mentally competent to stand trial must be made. Counsel for the defense usually makes a routine motion, and the judge will then order that basic psychiatric and psychological evaluations be administered to determine whether the defendant is mentally capable to assist in his own defense. Bob and I made the motion early on in this case, and the judge immediately ordered the tests, all quite routine. When the results of the tests were completed and were available, Judge Garippo called in the lawyers, both defense and prosecution, because he intended to make a ruling as to the competency of the defendant, nothing unusual. What the judge didn't know, but what everyone else in the room did know, was this. A very special report had been transmitted to the esteemed Judge Garippo. Another judge and dear friend of Judge Garippo, a person that shall remain unnamed because Judge Garippo still doesn't know who was ultimately behind the ruse, and I refuse to be the one to break the silence, had a phony report prepared and delivered to Garippo in place of the real one. The delivery was made in the normal course of business and in a manner that would lead the judge to suspect nothing. The sealed official envelope, embossed with the characteristic markings of the Psychiatric Institute, Circuit Court of Cook County, R.A. Reifman, M.D., Director, was lying on Judge Garippo's desk in his chambers. It was the normal practice that the report remain sealed until opened in the presence of counsel for both sides of the case. So, there we were, 6 lawyers with straight, solemn faces. And the judge, whom everyone in the room respected greatly, he opened the envelope and pulled out letterhead stationery indicating that the letter was from Robert A. Reifman, M.D., Director. It read, Dear Judge Garippo, pursuant to your Honor's order, the above-named defendant was examined by the undersigned psychiatrist. Based on the above examination, it is my professional opinion that the above-named defendant is competent to stand trial. Further, it is my professional opinion that the said defendant was legally insane at the time of the alleged offenses. He did not have the substantial capacity to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law. However, the above defendant is now legally sane and in no need of further treatment at this time. Very truly yours. The judge stared at the letter in front of him for a very long time. He seemed to be reading it over and over again. He looked up at all of us with a look that none of us will ever forget. This can't be right. Something is wrong here, he mumbled, shaking his head slowly. He put the letter down on the desk. He looked back at us. It says that he is competent to stand trial, insane at the time of the offense, and sane now. We watched as he contemplated what that meant. He seemed to be somewhere else as we watched him trying to imagine just what it was going to be like to declare that he had no choice but to find the defendant not guilty by reason of insanity, but that because the defendant was now sane and in need of no further treatment, he was free to leave the courtroom. He was a free man. Well, Judge, in that case, I think we will opt for a bench trial, I said with complete sincerity. We watched as the judge saw the headline in the Chicago Tribune and then the New York Times flash before his glassy, bespectacled eyes. Garippo frees Gacy. We all felt the laughter welling up inside. We fought it as long as we could. Then Garippo said, with a slowly creeping smile, You guys are in on this, aren't you? Lawyer jokes. You gotta love them. I tell this story as a prelude to the truth, which was that Dr. Reifman found just the opposite when it came to Gacy's sanity at the time of the offense. He found him sane. Of course, this was only one man's opinion. However, it did guarantee a jury trial. We also knew at least one of the experts who would be testifying on behalf of the state. As the weeks and months passed one by one, the judge ruled in favor of the state on the majority of our pretrial motions. We challenged the indictment, the warrants, we challenged each and every step the police and the state attorney's office took during the initial investigation, the collection of the evidence, and ultimately the arrest of our client. During a hearing on one of our motions to quash the warrant and suppress evidence, Judge Garippo threw us a bone when he declared from the bench that many of the warrants had been inartfully drawn, by which he meant that the warrants were, in some cases, flimsy. However, he allowed the evidence into the case in spite of the weakness of some of the warrants. While we were having hearing after hearing on our motions, body bag after body bag were being dragged out of Gacy's house. All of this in front of TV cameras, which broadcast their gruesome tale to the world. The brighter the light that shines on a case, the harder it becomes for a judge to exclude evidence that is found, whether that evidence is found legally and in keeping with the Constitution or not. Although I would strenuously argue, and Bob and I did so argue, that this should not be a consideration, sometimes it cannot be helped. Judges are human beings. However, in my humble opinion, if the constitutionality of a search of the residence of a United States citizen is at issue, the Constitution should always win. Always. No matter what. If the Constitution says one thing and our emotions say another, the Constitution should be followed rather than the emotion. Every single time. It is that very Constitution that protects those rights that we like to call inalienable. Too often, when a defense attorney wins a case on constitutional grounds, it is offhandedly described in the press and sometimes even by our society in general as a loophole. This is always done so in the pejorative sense, as in, that scumbag lawyer got his terrible client off on a goddamn loophole. It's a travesty of justice. Unfortunately, this statement, this sentiment, is completely ass-backward. When a defendant is convicted of a crime in spite of his or her constitutional protections, that is the loophole. That is the true travesty. Otherwise, why have a constitution? Why don't we just revert to mob rule, mob lynchings? Why is it so often accepted practice in the minds of some in this country that the police can break the law in their efforts to get the bad guy as long as they get the bad guy? How silly is that? The police can break the law in order to arrest a person who broke the law. What? Every oath that is administered to our leaders invariably includes the sacred phrase, to preserve, protect, and defend the Constitution of the United States. Perhaps we, as a people, should decide if we really mean that or not. So when Bob and I argued that the second warrant, the warrant that unearthed the first body, was insufficient at law because it was based on the claimed presence of an odor that was indistinguishable from many other odors, and a photo receipt that was not listed in the original inventory from the first warrant and was illegally taken during the execution of that first warrant, and the judge ruled against us, we were disappointed, to say the least. However, we were very pleased when Judge Garippo, with the wisdom of Solomon, ruled in favor of our motion for a change of venue, but kept the trial in Cook County. A motion for change of venue is filed when it is believed that a defendant cannot receive a fair trial in the jurisdiction where the crime was committed due to a predisposition on the part of the entire community, especially the jury pool, which is usually the result of an oversaturation of press coverage in a given area. When that press coverage is particularly biased, or the crime is particularly grotesque, or both, the judge must consider whether or not a fair trial is available to that defendant in that jurisdiction. No case has ever stood as a better example of this concept than the Gacy case. Judge Garippo knew this, and he was faced with a difficult problem. How would he protect the rights of the defendant to a fair trial without dropping this monumental case in the lap of some poor, unsuspecting judge in some other jurisdiction? The answer was a stroke of genius, and surprisingly simple all at once. The judge granted our motion for a change of venue and ordered that the jury would be picked from another county where less press coverage existed. And then the jury would be transported to Cook County and sequestered to protect them from the ongoing press coverage in this county. You didn't need to transfer the entire case to a different county, because the only persons that mattered in the case, the only persons that would actually be judging the case, were the 12 men and women of the jury. Studies were commissioned by the court to determine a county in the state where press coverage was less pronounced. Winnebago County was chosen as the county from where we would pick our jury. Rockford, Illinois, its county seat, a bustling city of approximately 150,000 residents, is closer to the Wisconsin border than it is to the city of Chicago. It boasts of its almost equal proximity to Madison, Wisconsin, Milwaukee, Wisconsin, and Chicago, Illinois. At about 90 miles away, it was close enough yet far enough away from Cook County. Of course, no jurisdiction on the planet existed that had never heard anything about the Gacy case. However, Rockford was a city unto itself with its own radio, TV, and newspaper outlets, and all parties agreed that it would serve well the purpose of a change of venue on the Gacy matter. As the trial date approached, every person involved in the case temporarily moved their entire operation, lock, stock, and barrel, to the fair city of Rockford, Illinois. The night before jury selection was to begin, everybody met for drinks at a local watering hole not too far from the Winnebago County Courthouse. I don't think that this little get-together was planned, it just happened. Rockford is quite cosmopolitan, but it is small compared to Chicago. Therefore, only so many hotels existed that were conveniently situated near the courthouse and could accommodate the number of lawyers and staff that descended upon that poor, unsuspecting town. The Clock Tower Inn turned out to be the place that everybody involved in the case stayed. So the bar at that fine establishment, with its walls completely covered by vintage clocks of every description, was packed to the rafters with people that were involved in some way with the Gacy matter. The place was packed. The bar was elbow to elbow and knees to knees, and the tables throughout were full. Everybody was taking a well-deserved and short-lived break from the grind. It's funny, most people believe that prosecutors and defense attorneys are mortal enemies. That is just not true, usually. Many people thought that William Kunkel and I actually hated each other. Nothing could have been farther from the truth. When you work with someone on a case, an occasionally grudging mutual respect grows, if it is deserved, of course. As a result, often, just the opposite is true. Prosecutors and the defense counsel can be quite close friends. Some are even married to each other. The relationship is much more akin to the members on opposing sports teams. Even as kids, it will sometimes happen that your best friend is on an opposing team. Of course, from time to time, even the closest of friends or colleagues have the occasional minor disagreement. It can happen to anyone, right? In the heat of the battle and all. I am not a big drinker, never was. I am that guy who is still drinking the first beer that he ordered 4 hours after arriving at the bar. Only my closest friends know this about me. I party with the best of them, so it is not obvious. I just never liked to drink much, not even in college. Bob, on the other hand, enjoys his beer. Bob never does anything half-assed. If he walks into a bar to have a few, that is just what he does. On this particular night, however, I don't know, maybe it was the tension of the moment. Everyone was realizing that we were all actually, finally, after all those many long months, on the verge of one of the biggest trials of our lives. Once the jury was selected, we were all headed back to Chicago to put on this case. The day of reckoning had arrived. Whatever the reason, everyone may have had a few more drinks than usual that night. Even I was not immune. Pitchers of beer, shots of booze, mixed drinks of all colors and concoction were being passed around like candy on Halloween. Prosecutors, defense counsel, their staff members who took the trip, investigators, police officers, and, let us not forget, the venerable members of the press, everyone who was involved with this tough, high-profile, high-pressure monster of a case was blowing off a little steam in a very big way. It was fun. No one really knows or remembers just exactly how the brawl began. It's fuzzy at best, no matter whom you ask. Many of us have tried to reconstruct the events of that night in the days since, but to no avail. All I can say about that particular night is this. As barroom brawls go, this was a doozy. I have heard errant speculation that my partner and dear friend, Bob Motta, may have had some involvement with the first salvos of the melee. Perhaps he and Bob Egan or Jim Varga, or one of the others were having words, and maybe that discussion became heated. But no one really has ever confirmed that, at least not in public or out loud. You see, Bob has always been the type of guy that has never taken a grain of shit from anybody, ever. So it stands to reason that it would be unlikely that anyone would publicly blame him for such a thing, at least not without very clear and convincing evidence, and certainly not to his face. What does it matter who started it anyway? By the time it was over, every single person in that bar was involved, whether or not they were participants in the case, save two. Glasses flew and smashed against walls, chairs were thrown, tables were tipped over, things of all shapes and sizes were broken or used as weapons. The place looked like a good old-fashioned Irish wedding or funeral. By some miracle, no one was seriously injured. I said everyone was involved, save two. Who were the two that remained above the fray, you ask? Well, by the time the fight broke out, most of the members of the press had either gone back to their rooms or moved on to another dram shop. One lonely reporter remained. I believe that his name was Galloway. I think he was with the Chicago Sun-Times, but don't quote me on that. Let's call him Galloway, though, just to give him a name. Let's say his name was Paul Galloway. Mr. Galloway was passed out, mouth agape, drool glistening on his chin, head hanging askew over the back of a wooden bar chair, snoring, while chairs and bottles flew over his head. He never moved a muscle during the entire conflagration. He slept like a baby throughout. Therefore, the rare and rather embarrassing departure from professionalism was never reported in the newspapers. Thank God. Number two was even more unusual. While the gates of hell were opening up all around him, while glass missiles zinged past and various items of furniture and the odd human being flew by his person, Bill Kunkel, who never drank anything stronger than Diet Coke, sat engrossed in a game of solitaire, or some sort of game that he had been playing all night long. He sat in his chair, as if in a bubble, with Armageddon occurring all around him, and never looked up, never threw a punch, never took a scratch. As for the rest of us, we all did our best to obscure our bumps, bruises, and minor cuts, and to caffeine away our hangovers as we dutifully appeared to question prospective jurors the following morning. Chapter 26. The Rock River lazily snakes its way through downtown Rockford, Illinois, the county seat of Winnebago County. A block away from its banks stands the Winnebago County Courthouse. Life is noticeably slower there than in the chaos and clamor of the sprawling city of Chicago and its environs. However, don't get me wrong, Rockford is no small town. It is a vital, bustling city with a long, proud history and a tough, professional criminal justice presence in an area that is surrounded on three sides by rolling farms and just south of its counterpart city, Beloit, Wisconsin. The Chrysler Corporation has a huge automotive manufacturing plant in nearby Belvidere, Illinois, and many of Winnebago County's citizens work at the plant or in Rockford as merchants. The rest of the population is dedicated primarily to farming in the surrounding open miles of the northwestern part of the state of Illinois. This cross-section of people provided an eclectic and interesting mix to the members of the jury pool. Jury selection has gone from the gut-based art form once practiced by country-style lawyers like Lincoln or Darrow to a science where lawyers are often assisted by elaborate, targeted firms dedicated solely to that purpose. These firms test mock jury after mock jury meticulously and scientifically study human behavior, particularly as it pertains to everyone's favorite civic responsibility, jury duty. We were consulting with a firm from Minnesota. No one from the firm would be there at the defense counsel table with us. However, we would be armed with their reports and recommendations, together with their graphs and charts and professed expertise. Ultimately, it would be up to Bob and me to pick the jury that would sit in judgment of our client, Mr. Gacy. Today was the day. Monday, January 28th, 1980. I came to, from what was for me an uncharacteristic alcohol-induced coma, in my room at the Clock Tower Inn, and was immediately filled with a memory of the previous night's antics. You know, I'm Italian, and I believe that you can be excommunicated from the Italian-American population if you openly disagree with anything that Frank Sinatra has ever said. But just this once, and just between you and me, I have to state categorically that I part ways with one of the long-held and widely quoted positions of Old Blue Eyes, the chairman of the board. Sinatra always said that he felt sorry for people who didn't drink, because if you don't drink, the way you feel when you wake up in the morning is as good as you're going to feel all day. I have to say I don't agree. I rather like waking up in the morning without a hangover, and I swore that I would never pull anything like that again. Sorry, Frank, just this one time, you were wrong. It's amazing how healing a long, hot shower and a fresh, crisp suit and tie can be. If that doesn't do it for you, then you should try walking into a totally packed courtroom where it is your job to pick the jury that will sit in judgment during the trial of the century. That will clear up any lingering cobwebs from your brain right quick. Every available seat was taken in the smallish courtroom in the Winnebago County Courthouse, and when all of the seats were occupied, people stood and crammed the aisles, craning their necks to get a glimpse of the proceedings and at the alleged monster from the big city. Extra uniformed bailiffs had been brought in, and they stood at parade rest at the edges of the crowd to ensure order. To many in that room, it was a silly exercise to have moved the jury selection to their county. It was not as if they hadn't all heard every gory detail that the strange, portly little man seated at the defendant's table was supposed to have committed. It was 1980, not 1880. This was Rockford, not the moon. News traveled fast. I think, however, that in spite of the smattering of criticism, the general consensus among Rockford residents was that they were excited to be in the bright spotlight, to have us all in their town for a while, and to have the jury that would sit in judgment of this monumental case selected from its citizenry. With the help of a uniformed sheriff, Bob and I pushed our way through the sea of bodies in the gallery and past the soft murmur of voices and the pointing fingers. We seated ourselves at the defense table and smiled knowingly at our opponents. Gacy was brought out from custody wearing a pale, lime green polyester suit, off-white button-down shirt, and a printed burgundy tie. It was the first time that he had put on civilian clothing, worn anything besides prison garb or a hospital gown, in over a year. All he needed was a cigar, and he would have looked like the cheap Pole that he fancied himself to be. He looked around the courtroom in amazement, like a child. The names of each prospective juror, together with minimal pertinent information about them, had been placed on 3 by 5-inch index cards, which were being shuffled by each member of the prosecution team as if in a riverboat poker game. This time-honored practice assures a random selection of prospective jurors. The cards were passed to us. I picked up the stack, cut them, shuffled the deck twice like an old pro, and handed it off to Bob. He held up the deck dramatically, ran his thumb along the side of the stack, split them, cut them, shuffled them, and set them on the table in front of him. The order of selection had been chosen. A bailiff swooped in and scooped up the deck. Then those familiar words from the head bailiff rang out and filled the silent courtroom. "All rise." Judge Louis B. Garippo entered the courtroom with a flourish and glided up the short steps to his perch atop the bench, black robe flowing behind him. Once seated, he nodded to his bailiff. 16 names were slowly called out by the bailiff. As each name echoed throughout the courtroom, a man or a woman that had been previously seated in the first rows of the gallery stood up and tentatively walked to the jury box and took a seat. When the 12 spots in the jury box were filled, the remaining 4 took their seats next to the jury box as potential alternates. Judge Garippo folded his hands in front of him on his desk. His favorite tie peeked out from the top of his robe and splashed the only color against his serious black presence. His prominent gold-rimmed glasses reflected the lights above. He had been a judge for 10 long years. He had been here many times in the past, and he knew better than most exactly what to do, how to handle the intensity of such a scenario. He smiled a quick, calming smile at the nervous members seated in the jury box. His firm but kindly, somewhat fatherly manner immediately put the jury members at ease. "Ladies and gentlemen, good morning. You have been selected as prospective jurors in the case of People of the State of Illinois versus John Wayne Gacy. John Gacy has been charged with 33 counts of murder in indictment number 79-69 to 75 and 79-2378 to 79-2403. Garippo looked up, expressionless, at the prospective jurors. He paused for just a beat and continued. Because of the nature of the offenses of which Mr. Gacy is accused, he is eligible for the death penalty. You really have to be in a courtroom where the penalty of death is at issue to feel how the gravity of the moment pounces upon every single person in the room. There is something about hearing those words spoken out loud from the bench that does it. In spite of the fact that everyone in attendance knows full well in advance what is going to happen, there is a lightning bolt, a charge of electricity that fills the air. An imperceptible collective gasp happens out of nowhere and out of no one. This isn't a movie. This is real. Hearts pound, pupils dilate, ears perk, attention focuses. Judge Garippo reached for a glass of water and took a sip. He adjusted his glasses and went on. The state of Illinois has elected to seek the death penalty. Again, Garippo paused to let this sink in. A couple of the prospective members dared to look at the oaf sitting next to me. Gacy looked like he might have to pee or something. He wasn't there. He wasn't present. His mind was somewhere else. The rest of the panel purposely avoided looking at the defendant and the defense counsel. Many had suddenly found something interesting on their shoes or on the ceiling. I made some notes. The matter before the court is a capital offense if Mr. Gacy is found guilty beyond a reasonable doubt and is legally eligible for the death penalty. The state's attorneys, representing the people of the state of Illinois, will ask you to impose a sentence of death. Just when you might think it impossible, the electricity in the room intensified by a power of 10. This time, many of the panel members, both in the jury box and in the front rows of the gallery, locked their gaze on William J. Kunkel, Terry Sullivan, Robert R. Egan, and James M. Varga. They didn't seem to mind, although they each shifted slightly in their chairs. Garippo continued. The indictment in this case is the formal matter of charging Mr. Gacy with the offenses. It is not to be considered as evidence and carries no inference of guilt. Mr. Gacy, under law, is presumed to be innocent. Again, the seasoned judge gave his audience a moment. This, of course, was important information that everyone already knew, yet they needed to hear it directly and specifically from him and on the record. This presumption remains with him throughout the proceedings and may be overcome only by proof of guilt beyond a reasonable doubt. Garippo sipped more water. He wanted his words to sink in as if they were being heard by every person in the courtroom for the very first time. It was working, too. He had the entire room. He certainly had me. I couldn't hear those words enough. He began again, as he looked at each of the prospective jurors in the jury box and at those seated in the gallery. The state has the burden of proof. That is, they must prove beyond a reasonable doubt that Mr. Gacy committed the crimes as charged. I hoped that everyone in the room felt the lump that I felt in my throat. It appeared every time I sat in that chair at that table. It didn't matter in what courtroom that chair and that table were situated. It didn't matter if my client was charged with a traffic ticket or the worst of all crimes. To me, this was like church. And Garippo was reciting gospel. I believed those words and believed in those words to my very core. I searched the faces in the jury box for a time, then looked out into the others in the gallery. I knew what I would find. I'd seen it before. There they were, the men and women that would sit in judgment of my client. Most had the look that I needed to see, the look in their eyes that betrayed the same feelings that I felt, that feeling of pride and love of country, that misty-eyed reverence for the best system of criminal justice on the planet. There, too, were the others. There were the dolts, the pinheads, the adult human beings, U.S. citizens, all that Washington, Jefferson, Adams, and Franklin hadn't counted on. At least 2 were sound asleep. Several were so distracted that you could only imagine the silly cartoons playing in their useless minds. There was the blonde bimbo, playing with her hair and cracking her gum. They fidgeted and daydreamed. They stared out into space or down at their fingernails. They wished that they were not missing their daytime soaps and had made specific arrangements with a friend to take notes so they could catch up after this stupid nuisance of having to serve on a goddamn jury was over. There were also the scary assholes, the ones that had already made up their minds. After seeing 1 or 2 reports on TV, they couldn't wait to cast their vote to string the bastard, my client, a human being, by the way, from the highest tree in the county. Evidence be damned. So that they could brag about it to chicks in bars. These were the people, mostly guys, who took some sort of sick pleasure in the revenge death of another human being. And these fucking people have the vote, I thought to myself. I wanted to stand up and go out there and shake them. I think Garippo saw the same thing that I did. He suddenly stood up, and in a loud, resonant voice he asked, "Are there any among you that because of the nature of the crime cannot be fair and impartial to the defendant?" He continued standing, looking at the entire panel, first at those seated in the jury box, and then at the rest seated in the gallery. That snapped them all to life. Something must be happening. The judge was standing. What's up? Even the snoozers were wide-eyed and paying attention, wondering what they had missed. I had to chuckle silently. "Please raise your hands if your answer is yes." The judge had the attention of everyone in the room once again. He stood there waiting. Slowly, tentatively, the first hand was raised by a woman seated in the gallery. After her, others seemed to have permission to do so. 2 more followed in the gallery, then 3 more went up in the jury box. The judge waited. Every other person in the courtroom waited. After several minutes, 8 hands were raised. When the judge was reasonably sure that he had coaxed every hand up from the panel, he addressed a woman who was seated in the front row of the jury box. He had her name. He had the 3x5-inch cards with the names of all the jurors in his hand. "Your name is Mrs. James Labuda, correct, ma'am?" The names of the jurors have been changed. She was clearly very nervous. She began to nod her head in the affirmative before she spoke. Her bottom lip trembled. Then came a very timid, "Yes, sir." The judge sat down. He had achieved his purpose, and now it was time to lower the level of intimidation and tension. Everyone in the courtroom was motionless. Nobody made a sound. "As a juror, your responsibility is to be fair and impartial. Can you meet that responsibility? Can you be fair and impartial to Mr. Gacy and to the state of Illinois?" You could see the inner conflict raging. It was there in her facial expression, in her demeanor. She sat silent, not wanting to voice her true feelings, but unable to deny them. The petite woman simply blinked and shook her head. Her eyes glistened with emotion. "Please, Mrs. Labuda, you must answer audibly for the court reporter," the judge gently prodded. "Well, I just think it's too horrible." She paused and took a breath. "I mean, what he did to those boys. I don't think I can be fair," she admitted. If the judge let this go without further comment, the rest of the panel would become convinced that if they simply said that they couldn't be fair, they would all be able to walk out and go home. He couldn't have that. At the same time, the frail but determined little woman seemed on the verge of a nervous breakdown. A single tear dripped from the corner of her eye as she trembled in her chair. "Can you agree that a defendant is presumed innocent until proven guilty beyond a reasonable doubt?" The seasoned jurist was pushing her a little further. Mrs. Labuda fidgeted and shifted uncomfortably in her seat, but she was not about to relent. "Yes, I do, sir. But I just don't think I can be fair to him." Garippo had been a judge for a long time. He had questioned hundreds of jurors in countless trials. In his opinion, this prospective juror was not malingering. She was sincere. He felt he had to excuse her and did so. Mrs. Labuda stood and hurriedly walked out of the room. It had been a trying experience for her. As the courtroom door closed behind her, the judge turned to the next panel member who had raised a hand. This time, an elderly man with gray tufts of thick hair poking in errant fashion in all directions. The man did not seem to be as affected by the proceedings as the first woman. He voiced his concern, said that he thought the whole matter was quite horrible, but admitted that he could reserve judgment until he heard all the evidence. He remained seated for the next phase, the lawyer's questions. And so it went. The judge continued his preliminary questioning of the 8 persons who had raised their hands. The answers that were elicited had a common theme. The subject matter of the case was horrific. The newspaper and TV stories had been shocking, but they would listen to the evidence before deciding. Garippo's gaze settled on an overweight, middle-aged white man with a ruddy farmer's tan, a scowl, and a buzz cut. The man wore a long-sleeved hunting shirt, buttoned to the neck, which strained and stretched to cover his huge, rotund beer belly. The judge pointed at him. "You, sir, in the second row of the gallery, please state your name," he called out. "My name's Vern Bergquist," the man grudgingly offered. The judge proceeded. "Can you be fair, Mr. Bergquist, to the defendant and to the state of Illinois?" "He should be hanged." The answer was mumbled and trailed off. The judge couldn't hear any of it, but I had heard enough. I leaned over to Bob, whispering urgently. I pushed my chair back and began to stand. "Please speak louder, sir, so that the court reporter can hear you." The judge was now stretching in his seat to better see past the first row of the panel. "I think they should take him out and hang him. He doesn't deserve—" The guy was no longer mumbling. I'd call it screaming. He was raising his huge form up out of his chair, pointing at Gacy. I shot to my feet. "Objection, Judge. May we have a sidebar?" I was trying unsuccessfully to make my voice heard over the rising clamor. Bergquist bellowed at the top of his lungs. "He doesn't deserve a trial. They should do to him like he did to those kids." He pointed at Gacy and shot daggers of pure hatred at him. The courtroom erupted. Garippo pounded his gavel. Uniformed sheriff's bailiffs descended on the man, causing the disruption. Bergquist continued in a frenzy, waving his arms and spewing venom. A few others in the gallery stood and began to join in as the rest cringed in disbelief. This was life imitating art. Hadn't I witnessed this very scene being played out in the movie adaptation of some legal thriller? I was beginning to wonder if Bergquist was about to pull out a secret pouch of animal blood and smear it all over his chest. Tension grew. Bob was on his way to the bench, as were Kunkel and Sullivan. I momentarily put a hand on Gacy's shoulder, looked at him, and then joined the rest, screaming for a sidebar. For the first time, Garippo raised his voice, and with a final bang of his gavel, he commanded, "Ladies and gentlemen, please, may we have order in the court while I confer with counsel." The room immediately quieted. Bergquist stood flushed and glaring at Gacy and at Bob and me, surrounded by wary bailiffs. It's always the most patriotic asshole in the room that has absolutely no concept of what patriotism actually means. By the look of him, I was willing to bet green money that he had an American flag plastered somewhere on the back of his rickety old pickup. The mood of room changed from momentary chaos to a buzzing calm. People whispered excitedly to one another without making any noise. The prosecution team, the defense team, and the court reporter huddled at the side of the bench with the judge, out of earshot of the jury. Mata was screaming a whisper through his teeth. "Judge, this jury has contaminated the entire venue." Bob had his hands on the corner of the bench and was leaning forward toward the judge, insisting that a new panel be chosen. I continued on the theme. "I asked the court to discharge the entire venue." I believe it was Kunkel who leaned in close to the judge, trying to express his urgency in a whisper that could only be heard by the judge, the lawyers, and the court reporter. A sidebar is an art form in and of itself. You have to learn to yell your argument while whispering. "Your Honor, you should simply admonish the prospective jurors to disregard the comments of Mr. Bergquist. It isn't necessary to discharge this venue. Simply excuse Mr. Bergquist and instruct the jurors." The prosecutor may have had more to say, but he was being upstaged by Mata's feisty presence. "That won't do," Mata hissed. "The comments were so inflammatory, the jury will not forget or disregard them. They are poisoned." Bob was adamant, as usual. He stepped it up a notch. "And further, I request that all voir dire of jurors concerning the death penalty be conducted individually out of the presence of the other prospective jurors. These requests by Bob and me were perfectly reasonable from our perspective and had precedent in other cases where the death penalty was at issue. The court must take every precaution to ensure that one juror is not significantly influenced by the words of another and thereby tainted. However, a judge has a great amount of leeway in these matters. He can use admonitions to guard against undue influence of jurors. Plus, Judge Garippo had no intention of requiring the entire cadre of court personnel, the lawyers and their staff, and all others involved in the case, to take up residence in beautiful downtown Rockford for a month or more, which were the logistical ramifications of such requests. Motion for individual voir dire will be denied, Garippo calmly said. I will admonish the jury to disregard the comments of Mr. Bergquist and excuse him from duty. Objection, I strenuously interjected. Our client is prejudiced by this prospective juror. The court has just begun voir dire. It would not unduly delay the trial to impanel a new venue. If the court refuses to impanel a new venue, the defense is compelled to request a mistrial at this early juncture. Garippo was unmoved by my brilliant argument and unimpressed that I was demanding a mistrial. I wasn't exactly surprised, but I had made my record. I had barely gotten the words out of my mouth when he cut in. Objection denied. Motion for a mistrial denied. The players returned to their respective places, and all was returned to normal. The tenor of the trial had been set, however. The barroom brawl of the night before at the Clock Tower Inn, now a distant memory, would seem insignificant and paltry and pale in comparison to what was to come. Judge Garippo focused his attention on Mr. Bergquist. He explained to this nincompoop that we had a Constitution in the United States of America, maybe he had heard of it, that it was this very document that guaranteed his right to stand up in a courtroom and make an absolute fool of himself, screaming and yelling his silly opinions about not having a trial. That in many countries, he would be on his way to jail right now, or worse. However, because of the document that he sought to usurp, he was simply going to be excused from jury duty and sent on his way. The judge didn't say it quite that way. I said it that way. Garippo was much more diplomatic, but his message was the same. Mr. Bergquist slithered from the courtroom, escorted by an enormous sheriff's bailiff. 4 days later, 12 members and 4 alternates had been selected as jurors to sit in the matter of People versus John Wayne Gacy. The judge explained some of the logistics regarding transportation and lodging during what would prove to be a 6-week sequestration. He gave them a couple of days to make their arrangements and pack. He scheduled the trial date and told everyone that he would see them all back in Chicago. After a year of toil, sweat, and arduous and meticulous preparation by all parties, the trial of Mr. John Wayne Gacy had, at long last, begun. Chapter 27. The Criminal Courts Building at 26th Street and California Avenue in the city of Chicago, Illinois, had been a place of legend long before the trial of John Gacy. It has a rich and storied history. Many famous, high-profile attorneys have argued many famous, high-profile cases in its hallowed courtrooms. However, there is no question that the Gacy case was the trial of the century of its day. Judge Garippo's courtroom on the 6th floor of the old building could have been the set of a Hollywood movie. An aesthetic mix of dark hardwoods and smooth marbles, built by proud craftsmen and intended to stand forever. One enters through heavy 8-foot oak doors that open into a cavernous room with 25-foot ceilings trimmed by ornately carved crown moldings high above. Rows of church-like pews serve as seating and end abruptly at the bar between the gallery and the well of the court, where long tables for the defense and prosecution are clearly marked and positioned before an imposing bench where the judge presides high above all others. 8-foot windows, cut into the stone on the room's south wall, reveal streams of morning sunlight that streak the room in the early hours. A green desk lamp sits next to a brass nameplate on the bench, which proclaims that the courtroom belongs to and is presided over by just one man. This was Garippo's room, his court. For several weeks prior to the trial date, workmen had been busy making minor alterations to accommodate a trial of this nature and scope. The jury box was expanded to allow seating for the 12 jurors and the 4 alternate jurors who would sit and hear all the evidence, in case they were needed. Sections of bulletproof plate glass were erected to separate much of the gallery from the well of the court. Other minor changes were made so as to accommodate press coverage. No cameras would be allowed inside the courtroom, but reporters would be positioned and able to report on the proceedings without disruption or distraction to the court. Outside the courthouse, areas were set aside for press and cameras, and the streets surrounding the courthouse were dotted with the cumbersome white trucks crammed with the equipment that would immediately beam the news of the trial to the world, each of which had the call letters and logos of their respective television networks emblazoned on the side, advertising their presence. Electricity filled the air for miles around. If you read the papers or watched TV, you would think that nothing else was happening in Chicago or the world. All that was needed were a few balloons and a few barkers, and we would truly have had us a circus. The lawyers met with the judge in the days prior to the actual start of the trial to work out preliminary matters and actual logistics for the trial. It was decided that we would all work 6 days a week with full days on Saturdays. Garippo fully intended to plow through the truckloads of evidence and exhibits and the unending lists of witnesses that may or may not be called depending on the particular twists and turns of the trial in a timely manner. He had no intention of dragging out what we all knew would be a protracted trial any longer than was absolutely necessary. We fought long and hard over whether the state should be allowed to use certain exhibits. They had prepared a huge easel on which the pictures of 22 identified victims and 11 question marks appeared and were easily removable from the slots that held them to use during testimony. Bob and I argued that having the easel in plain view of the jury throughout the whole trial would be inflammatory and prejudicial. The judge ruled that it could remain in the courtroom, out of the way, unless the state was referring to a specific victim. The upshot of this resulted in our having to sit with the state's gallery of grief, sometimes with all of these pictures on this huge board behind us in the courtroom, day after day, during the entire trial. There was also an argument over the state's plan to bring into the courtroom a huge chunk of the flooring from Gacy's house, which included the trapdoor that was the access to the crawl space. Essentially, they were bringing the damned crawl space right into the goddamn courtroom. I had to admit to myself that if I were prosecuting this case, I would want to do the exact same thing. Of course, I never said that to anyone, not even to Bob, and we forcefully argued against it. However, the judge ruled that it was simply demonstrative evidence and would be allowed in for that purpose. After 2 days of preliminary fighting and informational meetings, we all looked at one another and agreed. We were ready. On Wednesday, February 6, 1980, opening statements began in the case entitled People versus John Wayne Gacy. The courtroom was packed to capacity and then some. People sat and stood and crammed into every available space. Judge Garippo swore in the members of the jury, and the entire courtroom fell into utter silence. Bob Egan, who had been chosen by the team to give the opening statement for the prosecution, stood and walked before the jurors. The long-awaited moment had arrived. "May it please the court, ladies and gentlemen of the jury, I want you to picture, if you will, a young boy. He is 15 years old. He is a sophomore in high school. He is a gymnast at the high school. And in the evening, he works at a pharmacy." Egan began. "He works at a pharmacy because he is 15 and he wants to buy a car when he is 16. So he is saving his money. His name is Robert Piest. I want to take you back 14 months to a place called Nissan Pharmacy. Nissan Pharmacy is in the suburb of Des Plaines, Illinois, a suburb northwest of Chicago. You passed it on your way in as you came in on the toll road." Egan slowly and methodically told a story about a cold December evening, just over a year previous, when a local contractor kept an appointment to give a quote to the owners of that now famous pharmacy in Des Plaines, Illinois. He covered every gruesome detail that the state felt they could prove. The chance meeting between Rob Piest and John Gacy, the ride to Gacy's house, the murder of young Rob, the disposal of the body, all of it. Bob listened as Egan stood in front of the jury and set forth the state's case in a sometimes dry, sometimes emotional dialogue. We will prove this and we will prove that kind of dissertation of the facts, spun exclusively in the manner in which the prosecution viewed the evidence. That was his job. He did it well. This was an opening statement and not an argument, although most lawyers attempt to stretch the definitional bounds of such a mission. Attorneys rarely miss a chance to argue, even when their antics are subject to objection by their opponents. It has happened that a lawyer will break into crocodile tears, sobbing out his or her version of the facts and evidence, and when the opposing counsel finally stands to rightfully object, it's all apologies and earnest assertions of how greatly affected he or she actually was by this particular case. That assertion is itself, by any definition, an argument, but it gets by many judges, simply because of the waterworks. Mata was not interested in such theatrics or distractions, and he respected Egan for his lawyerly presentation and professional manner. Egan did, however, refer to Gacy as the most evil man that ever walked the face of the earth, thus setting up a theme that the prosecution was expected to use: good and evil, or, better stated, good versus evil. They would paint Gacy as evil, and therefore not insane. When Egan finished, the judge broke for lunch, and the courtroom emptied. Mata stayed back. He couldn't eat anyway. He sat alone at the defense table with his notes and his thoughts. He flipped through pages without really reading the words. Then he stood up and approached the jury box. He had been here many times before, standing solo below the 25-foot ceilings in front of the assembled ladies and gentlemen of the jury. Looking at their somber faces and pleading a case was nothing new to him. However, there was no denying it. This was different. This was, after all, the trial of the century. Unlike me, Bob was publicly against the death penalty. He had a deep philosophical aversion to the whole concept. I didn't. I was fine with the concept. But he had always thought it barbaric, wrong on so many levels. Although this was a capital case, the death penalty was being sought. He knew he had to stay clear of any such argument. That was not our defense. He had to steer clear of his deep-seated personal feelings and stick to the specifics of the case. He thought of the hundreds and hundreds of hours that he had spent with a man on trial. A review of that cumulative experience made it simple for him. if he could convey to this jury what he knew about John Wayne Gacy. He believed that a not guilty by reason of insanity verdict was a foregone conclusion. Nobody on the planet was surer than Bob that his client, our nut job of a client, was damaged. He had a damaged, defective mind. He had been miswired. Gacy had killed, yes, but his actions were as a result of an overwhelming compulsion over which he had no control. In what seemed like seconds, Bob was approaching a full jury box. The throngs had returned from lunch and reassembled, filling the courtroom beyond its true capacity once again. All the jury members and their alternates were seated in their assigned seats with what Bob perceived to be openly skeptical, hostile faces. Many seemed to be unconcerned or uninterested. It was Bob's unenviable task to attempt to begin to pull together what would prove to be weeks of varied and confusing testimony and make it all understandable in a cohesive way that supported our theory of the case. No place on earth is quieter than the quiet in a courtroom just before a lawyer begins an address to the jury. Whether it is opening statements or closing arguments, everyone in the room seems to be on the edge of their seats. An innocent cough from the gallery sounds like an echoing gunshot. Nobody breathes. Such was the case when Bob Motta stepped forward to begin his opening statement for our case. This would be the first glimpse into the inner workings of the mind of the man who was accused of being the nation's most prolific serial killer. The waiting masses would finally have the opportunity to hear what kind of defense this monster would put forth. Bob began by asserting that something had gone sadly wrong during the development of John Gacy's mind. He was controlled by an insidious, rapacious illness. He told John to stand. "I will show you this man," Motta asserted, pointing at his client. "He is a human being. He was born, held in his mother's arms, nurtured, loved. Now he is the most despised man in the world. Every man's death diminishes me," he said, quoting John Donne, the man who famously said, "No man is an island." Bob felt very much like an island. He named each of the 22 identified victims. "The lives of those young men," he said, pointing to the state's gallery of grief, "cannot be replaced. The pain of families cannot be measured or abated." Bob was gripping the railing of the jury box, leaning in. A couple of feet away from the jurors in the front row. "Nothing is more precious than human life," he pleaded. "But hatred and sympathy cannot play a part in the decision you must make. Only clear, rational thought and the strictest objectivity can guide you, a very difficult task." Bob retreated a bit from the jury box. He began to pace and stalk the area in front of the bench in the well of the courtroom. Incomprehensible illness compelled him to the most horrible ends. Motta's voice bounced off the intricate crown molding high above his head in the ornate old courtroom and reverberated throughout its confines. "He understood, he planned, and he routinely killed again and again and again." These words hung in the room like a dense fog. "Free will is of what I speak. Something was missing in Gacy, missing from his heart or his mind, some vitally important element that provides the ability to make choices of right over wrong, morality over immorality, life over death." All eyes were on Bob. He knew that this concept, which was at the root, at the very core of our case, which he expertly espoused, was all too tough to accept for many people. In some cases, it was simply beyond them. It is so much easier, more comfortable, to understand human nature in simple terms, biblical terms, the struggle between good and evil, the devil and the angels. Unfortunately, this sadly uninformed approach leaves out an explanation for so many of life's common conditions. The unfortunate sufferer of cerebral palsy or Tourette's syndrome, the epileptic, the stroke victim. The brain controls our every action. We know that. Even unconscious activities like the pumping of the heart, like breathing, would not occur without the steady support from the computer in our head. When the brain is broken, when the connection between our bodies and our brain fails, we no longer have the choice to do that which we so deeply wish we could. The stroke victim would love nothing more than to get up and walk. Hell, many would be content just to stop drooling. But they can't, because their brain is broken. An epileptic would rather not pitch a fit on the floor of a downtown department store at noon on a Saturday in front of 100 shoppers. It's embarrassing. But no matter how hard they wish it wasn't so, or try to pray it away, or valiantly attempt to fight against it, the inevitable happens, because their brain is broken. These people do not choose to do what they do. They do not choose to have their debilitating malady. They are just plain stuck with it, because their brain is broken. Mata just hoped that his understanding of the natural order of things, the physiological truths, the psychological facts that exist whether we as a species like it or not, could be transmitted to the 12 good men and women sitting, fidgeting, in front of him. He could not have cared less about what another person in that courtroom thought. Just those 12. But that was Bob. Gacy didn't choose to kill, he told them. He was unable to choose. There was no choice to be made, Bob said, adding that the choice had been made years ago. We have doctors. They will tell you in medical terms that Gacy is crazy, and that he is controlled by the darker side of human nature, the basest part of man, that in normal people either never surfaces or is entirely absent. They will tell you of disease that causes the vilest of human behavior, uncontrollable and savage. Men of common decency fear to admit it can exist in the human heart. Men fear such horrors. They have been warned not to look into the abyss, where they may themselves become what they see. You must not succumb to fear. You will not be condemned for saying the truth. And if you believe Gacy is crazy, then say so. Fear will be a powerful force dictating that this man be excised from humanity, cut out like a cancer. Mata pointed at our client as he strode closer to the jury box. He approached the railing between him and those 12, grasped the rail, and leaned in. Use all your strength to fight the fear, he screamed in a soft whisper. He looked at the strange little man that we were both representing. He stole a glance at me, and then returned his gaze to the jury. I ask you to look into the abyss. If Gacy acted out of chronic mental illness, then under our law he is not responsible for his acts. If the disease stripped him of free will and he killed, he must not be destroyed. Is there not one among you that can see past this shroud of death and come to grips with what you must do? You won't like it. The darker side of you will demand revenge despite his illness. You must not allow this to happen. He closed by saying, Don't see through anger. See clearly. Use cool, sound judgment. Because if you decide that he must be punished rather than treated, that will be far more irrational than any act he has committed or could commit. I thank you. As Bob Mata took his seat next to me, I realized that he had failed to elaborately thank the jury for their attention, a common courtesy that lawyers usually extend. Instead, just the simple thank you. Lawyers will usually go on and on about how much they appreciate the jury's service, etc., as they probably should. I looked at him. I knew him. I could see that he wasn't convinced that these jury members, our jury members, were capable of seeing past a very powerful emotional desire that is in us all, the desire for revenge. He wasn't concerned about his opening statement. He had covered every base, addressed each and every issue, every point of order. He was concerned about them, that disparate group that had been plucked from their lives in distant Rockford to sit in judgment of our client. What he saw on the faces of that distracted and seemingly disinterested panel worried him. It would be a tragedy if those people had already made up their minds, like much of the rest of the world have. Chapter 28. The morning of February 7th saw the first witness for the prosecution walk to the witness stand, sit, and face the jury. Judge Garippo, quite uncharacteristically, ended the previous day's proceedings early, immediately after Bob finished his opening statement. This would not happen often. The circus atmosphere, the crowds, the unprecedented attention given to this case continued unabated both inside and outside of the courtroom. TV trucks and reporters had taken up residence on every sliver of available real estate and on streets surrounding the outside of the courthouse, and cables connected to men and women with microphones filled the halls inside. Marko Butkovich, the father of young John Butkovich, was the first person to testify in the Gacy case. He was also the first person in a long parade of life and death witnesses called by the state. A life and death witness is usually the person who last saw the victim alive. One after another, relative after relative, friend after friend, person after person, walked up to the stand to testify about the last time they saw their lost loved one. As you might imagine, there was a significant amount of tears flowing. This is, of course, perfectly understandable. What else would the family members and survivors of a young boy do? The pain that they must have felt is unimaginable. Bob and I always considered this as one of the toughest aspects of the case. Nobody wants to cross-examine grieving family members about such a tragic event. It is hard enough to do just once. Imagine doing it over and over again. However, we had a job to do, and do it we would. We asked a precious few questions of most of the immediate family members, but other persons, friends, for example, were considered more or less fair game. After all, we had offered to stipulate to all of the life and death witnesses and the evidence to which they would testify. But the prosecution team would not agree to the stipulation. Let me state that in another way. Bob and I, as the attorneys for the defendant, offered to forego any right to challenge any claim made by the life and death witnesses. We agreed to stipulate to their testimony, thereby alleviating the need for any of the family members to testify at all. That would have saved them from that painful experience. After all, our defense did not hinge on that testimony. We were admitting that the victims were dead and that our client killed them. The prosecution team would not stipulate, however, that they would not agree to any stipulation of any kind regarding this phase of the trial. They insisted on the live testimony of the witnesses. Why? Well, the answer to that question is quite simple. They wanted those poor people to cry on the stand in front of the jury. They wanted the sympathy that would be elicited by their testimony. Don't ever let anybody tell you that a murder trial isn't a war, that it isn't pure, unabashed hardball. And don't let anyone ever tell you that one side is more sensitive to the feelings of human beings than the other. A trial is an all-out battle, no holds barred. Each side fights to win, and each side has its casualties. That is why I didn't have a problem with the cross-examination of Donita Gannon. As a courtroom brawler, I know from experience that if you can bring into question the credibility of any one of the witnesses that your opponent puts forth, it casts a shadow of doubt on the credibility of all the witnesses that your opponent puts forth. It stands to reason that if your opponent is willing to knowingly put one person on the stand that you can expose as an obvious liar, he or she might be willing to put others up on the stand that are willing to lie as well. Makes perfect sense, right? Let's face it, I didn't come up with this theory of trial practice all on my own. It's a time-honored tactic that has been used by trial lawyers for centuries. So, when Donita Gannon sashayed through the huge oak doors at the rear of the courtroom, and every head in that courtroom turned to watch this stunningly attractive Asian woman approach the witness stand, I was ready for her. She was clearly aware of the attention that was being paid to her. You could see it in her walk, in her eyes, in her overall demeanor. Every eye in the room followed her as she strutted her stuff toward the jury box, outfitted in a standard issue little black dress and black patent leather high heels. Her long black hair with an extra high glossy sheen bounced behind her. She was a piece of work. She seated herself on the witness stand. John Gacy nudged me, whispering frantically. "Itza," he started to hiss. I gave him a stern look and a quick shh. After the witness was sworn in, Bob Egan stepped up to conduct the direct examination on behalf of the state. He began, "Would you state your name and spell your last name for the court reporter, ma'am?" "Donita Gannon. Gannon." She smiled demurely. Egan took her quickly through questions that elicited testimony that she and Timothy O'Rourke, one of the victims, were close friends. That they lived together in an apartment on the north side of Chicago, and that she had last seen her friend in front of their home on Dover Street and Lawrence Avenue. It was all quite touching. When Bob Egan said, "No further questions," everyone in the courtroom was left with the impression that they had just heard the testimony from a grieving girlfriend about her deceased boyfriend. Judge Garippo turned the witness over to us for cross-examination. I approached the witness and asked the following questions, and received the following answers. Q. Miss Gannon, is it Miss or Mrs.? A. Miss Gannon. Q. How long has your name been Donita? A. Since... Bob Egan was immediately on his feet. Objection, Your Honor. I don't see how this is relevant. I shot back. That is relevant. I was glaring at Bob Egan. He knew where I was heading. Garippo looked down at both of us with a scowl. Lawyers were supposed to know that they were not to address each other. They should address all arguments to the court. They rarely remembered this rule. The objection is overruled, the judge said sternly. I returned to Miss Gannon. Q. How long has your name been Donita? A. Since March 1977. Q. What was it before that? A. Don Ganson. Q. Don. A. Yes. It actually took several seconds for the inhabitants of the courtroom to absorb what they were hearing. Suddenly, it seemed to communally sink in. The beautiful woman that everyone in the room had been openly ogling was a man, a he-she, as Gacy had eloquently called Donita. There was a collective, silent gasp. Q. What was your name when you met Timothy O'Rourke? A. He started knowing me as Donita. Q. He knew you as Donita. A. Yes. Q. You say Don. Is the long name of that Don or Donald? What name did you have, Don or Donald? A. Don. Q. Don. A. Yes. Q. When did you meet Timothy O'Rourke? A. May 1977. Q. How long have you been a female? Egan shot to his feet once again. I don't see the relevancy here. I will object. Garippo had a look of total fascination. He waved his hand, as if to sweep Egan aside, without even looking at him, and said, Overruled. I could tell he wanted to hear the answer. He was riveted on the witness, as was everyone else in the room. I asked the question again. Q. How long have you been a female? A. I am in the process of becoming a woman. Q. So when you met Timothy, you were not a female, were you? A. That is right. Q. Where did you meet him? A. I met him at a party. Q. Where was the party? A. The party was on Broadway and Surf Street. I went on to ask questions about their meeting, general background questions. The jury and the gallery were paying attention now, if they weren't before. Everyone in the room had realized that it was true. Black could be white, up could be down. An original perception could be just plain, flat wrong. That was my purpose. I wasn't interested in embarrassing this poor little woman, or man, or whatever. For obvious reasons, I needed to show how wrong an original perception could be. Where was he the last time you saw him? I asked. He was in front of our house on Dover and Lawrence. Miss Gannon was angry with me by now. Her eyes shot poison. You were living with him, I continued. Yes, she spat. Did you plan to marry him? He was just a friend, she stated with emphasis. So, you were not in love with him? Egan had had enough. He wanted this to stop. He jumped up. Objection! How is that relevant? Garippo agreed. Sustained, he said, with a look that told me to move on. Were you in love with him? I persisted. Egan raised his voice. Objection! Garippo glared at me. Sustained, he said again. I began walking toward the bench. Egan was right behind me. May I approach the bench? I said quickly. While Egan, the judge, and I were having words, Miss Gannon answered the question, ending our discussion. I was not in love with him, she exclaimed. I continued to ask questions pertaining to a statement Miss Gannon had made to some investigators. No new or significant information came to light. I was wrapping up my cross. Have you had the sex change operation yet? I wanted to ask if she still had a dick under that pretty little black dress, but I thought better of it. Objection! Egan was standing. Sustained, ruled the judge. No, I haven't, Donita Gannon, or Don Ganson, again volunteered. That means you are still a man, I shot back. Objection again! Egan was apoplectic. Sustained, Garippo stated. You don't have to answer. Say that again, the witness was saying. You don't have to answer the question, Garippo reiterated with a sharp look in my direction. I felt that it might be time to change the subject. Did you ever hear of a bar called Blinkers? Miss Gannon had calmed down some. Yes, she answered. What kind of bar is Blinkers? I asked. Again, Egan was on his feet. He was not going to allow me any slack. Objection to the form of the question, he said. She may answer, the judge ruled. What kind of bar? I prompted. I was almost done. It is predominantly a gay bar, she responded. No further questions. I hoped I had made my point. Nothing further. Egan had no redirect. He then said, Thank you, Miss Ganson. He called her Ganson, her old name, her man's name. I thought that was funny. You may step down, the judge said, without expression. As Donita Gannon walked back down the aisle and out through those huge swinging oak doors, she seemed to have lost a bit of the swing in her step. Once again, every eye in the courtroom was glued on her, but I am not so sure it felt as good as it did during her grand entrance. If she was embarrassed, I'm sorry, but like I said before, this was hardball. That woman had stood there at the outset of her testimony with her hand on a Bible and sworn to God that she would tell the truth, when in fact, she was living a lie. Although it was not her fault, it was probably just a cruel trick of nature, like hurricanes, tornadoes, pestilence, or the like. Her life was one confusing, tragic, incomprehensible lie, just like my client. I hoped someone on the jury got that. Chapter 29. Testimony in the trial continued. One after another, crying, devastated witnesses testified on the stand. A couple of them became so emotional that the judge had to momentarily stop the proceedings for fear they might collapse. Those fears were all at once realized when a woman named Bessie Stapleton, the mother of 14-year-old victim Samuel Stapleton, fainted dead away upon being shown a bracelet that had belonged to her son by Mr. Egan. She uttered the words, "God, why?" exhaled loudly, and slid like a piece of wet spaghetti toward the floor of the witness stand. The woman was helped from the courtroom by the sheriff's deputies, and order was restored, but not before the incredible heartbreak and grief of this aspect of the proceedings had been amply demonstrated. Many of the witnesses' names were the same as those represented on the state's gallery of grief: fathers and mothers, sisters and brothers of the deceased. Some, however, were close friends. Often, it was a close friend that was the last person to see the deceased. There was a reason for this. The largely unspoken truth that hung in the air like a thick, silent haze was this: many of the victims had long ago left their homes or, in some cases, were kicked out of their homes due to conflicts with their families over their perceived lifestyle choices. The majority of the victims were homosexual. Not all, but most of them were male prostitutes, and the others clung precariously from the fringes of society. The incredibly enormous and truly tragic elephant in the room were the 11 nagging question marks posted as victims on the gallery of grief. There they sat, below the pictures of the identified victims. From time to time throughout the entire trial, 11 unidentified victims. One can't help but wonder why. There was not a nook or a crevice or an isolated burg or tumbleweed-swept town at the very end of a long, lonely road in the farthest reaches of this nation that had been immune to the relentless press coverage that was attendant on this case. For month after month, every newspaper, radio, and television outlet across this land and abroad reported the horrendous events that took place in the obscure, unincorporated Chicago suburb. They couldn't help themselves. The story was captivating. 29 young bodies in a crawl space, a strange, gregarious minor politician, contractor, and part-time clown, the suspect. Pictures of him and the First Lady, male prostitutes as victims, killings that took place over a span of 2 years, 33 victims in all. How the hell could they possibly resist? Mata and I were interviewed almost nightly, the prosecution team as well, the police, the mayor, the neighbors, former co-workers, prison mates, fellow JCs, girlfriends, wives, friends, foes, you name it. The press considered it an angle on the story. You could not hide from this news story if you actively tried to do so. On top of all that, forensic pathologists and scientists had actually reconstructed the skeletal remains of the unidentified victims in such a way as to recreate their facial structure. And through computerized technology, they created computer-generated likenesses of these victims. you could see what these kids had looked like. These images were broadcast night after night on the national television networks and reprinted in newspapers from sea to shining sea. So, the nagging question remained, unspoken and unexplained. Was there not another set of parents out there that looked up from their morning paper or their evening news broadcast and asked each other, "I wonder if one of those kids is our Johnny?" That question remained unanswered, and remains unanswered still. This sad fact led Dr. Robert Stein, the Cook County Medical Examiner, to state publicly that these unidentified kids were not runaways, they were throwaways. This whole unspeakable facet of the case served to further muddy up and complicate the issues. We couldn't touch this at trial because we felt it would look as though we were trying to imply that the victims in general did not warrant the attention they were getting. They were all just society's outcasts. Of course, nothing could have been farther from the truth. We believed that every human life was sacred and had merit, including our client's life. We were fighting for that life with everything we had. That was the truth. Yet, we had to sit and watch the prosecution drag in every available tearful face to yank on the heartstrings of every member of that jury, and we really couldn't do very much about it. However, somewhere toward the end of this heart-rending parade of life and death witnesses, the state wheeled in a wheelchair-bound accident victim straight from the hospital. Her name was Mary Jo Paulus. I always thought that they had gone a little too far with her. She was in agonizing pain, both physically and mentally. She cried on cue during her testimony, but on cross, Mata got her to admit that the state had purposely withheld pain medication with some excuse about how she should not be under the influence of drugs on the stand. Bob also pried information out of her that some other person named Weedle was the last to see the deceased victim, William Kindred. So, what was she doing there in the first place? Why did she have to be there at all, considering her condition? Where was Mr. Weedle? Wasn't Mr. Weedle pathetic enough as a witness? I don't think that played well with the jury. Like I said, this was hardball. Don't ever let anyone tell you different. After the life and death witnesses, the state began to put on persons that were involved in the case at the very beginning. Phil Torf, Kim Barnes, Linda Mertes, and others told the jury about the earliest moments of the story as it unfolded back at Nissan Pharmacy. Gacy's construction estimate, the forgotten appointment book. Jurors were transported to the night of December 11th, 1978, and into that now infamous drugstore in Des Plaines, Illinois. Linda Mertes spoke about how Rob Piest talked to her regarding his interest in the construction job. Kim Barnes testified about the photo receipt and how she had stuck it into the pocket of the blue down jacket that Rob had let her wear because she was cold at the cash register. The story progressed as the state began to call to the stand the police officers that had investigated the case, the detectives that had followed John Gacy undaunted for days on end, the men that, through diligent effort and tireless hard work, had brought the defendant down. Through these witnesses, the jury began to hear the story that they were promised in Egan's opening statement. Only this time, they were hearing it from the stand and under oath. The crying seemed to be over, and the actual participants were setting the nuts and bolts of the case forth methodically and dispassionately. As the story progressed through the officers' testimonies, you could see in certain jurors' eyes that they were fascinated by tales of how the police had chased Gacy all over the northwest suburbs at high speeds, how Gacy had begun telling the officers in advance when and where he was going, how he would invite them into his house for drinks and food, and, especially, how the police and Mr. Gacy sometimes drank together in bars, with John introducing them as his bodyguards. Mouths dropped when they were told that Lieutenant Kozenzak and Officer Pickle were in Gacy's house while Rob Piest's body rested silently in the attic. And many of the jurors looked upon John with disdain and bewilderment when they heard about his indignant statement to Kozenzak. "Don't you have any respect for the dead?" A week of trial had passed in the blink of an eye, with more drama promised in the weeks to come. Chapter 30. The jury continued to hear the story unfold during week 2 of the trial. Early Monday morning, they were treated to the rather gruesome story of the disposal of young Rob Piest's body, together with the events that occurred on Gacy's way back from that bleak, eerie bridge. If they had not decided this already, this morning's testimony may have informed them to keep their future breakfasts light. Minor sparks flew when the tow truck operator, Robert Kirkpatrick, recounted the entire incident concerning Gacy having run off the road on Interstate 294. But he could not make an in-court identification of John, who was seated in the defendant's chair right next to me, as the man that he had seen in the big black Olds 98 that night. The state called witness after witness intended to fill in the blanks for the jury regarding how they saw Gacy. Business associates were called to testify that he ran a successful business. Others testified that he was a competent worker. The state was offering their theory that Gacy was a normal guy without an apparent mental defect. They also put on some evidence regarding our client's drinking habits and his drug use. It was their theory that John did not do drugs or drink to excess, and there was some testimony offered to support that proposition. Various Gacy acquaintances testified that Gacy was not a big drinker, and that although he smoked pot, took Valium occasionally, and maybe popped a pep pill from time to time, these habits did not interfere with his ability to do his job, pay his bills, or live his life. The state was building up to the testimony that they intended to offer from both Mike Rossi and David Graham. These two individuals were considered key to the state's case. Both of these men had worked for Mr. Gacy for years. They had each lived with John at one time or another, and they were his trusted friends and confidants. Prior to that testimony, the state quickly called two young men who said that Gacy had propositioned them in a sexual way. The first, Robert Zimmerman, was an employee at Gacy's favorite Shell gas station. The second was Anthony Antonucci. He testified that Gacy had used handcuffs to restrain him while he made unwanted sexual advances toward him. Antonucci was successful in resisting John's advances, which John then dismissed as just a joke, just horsing around. The testimonies of Cram and Rossi were revealing. These were the two individuals that had spent the most time with Gacy over the years previous to his arrest. When Cram was called to the stand, we objected strenuously. Every effort that we had made, either personally or through our investigators, to interview Cram before trial had been unsuccessful. He was dodging us. We argued that the state had not allowed us proper preparation for this witness. Garippo overruled the objection. However, he recessed the court and allowed Mata and me to conduct an impromptu grilling of Cram prior to his testimony in a small adjacent room. With David Cram on the witness stand, the jury learned how a chance meeting where Gacy picked up the young Mr. Cram while he was hitchhiking down Elston Avenue in the city of Chicago turned into an extended working relationship and friendship that blossomed during the following years. For a period of time, Cram lived with Gacy at the Summerdale address. David was on the stand for hours as Sullivan skillfully directed him through the areas that the prosecution team wanted covered. During his testimony, Cram described events that had an eerie similarity to other events that the jury had heard about from the stand regarding Rob Piest. Sullivan asked Cram about his birthday in 1976. Calling your attention to your birthday, 1976, were you at Mr. Gacy's house on the evening of your birthday? Yes, I was. At that time, had you been drinking at his house? Well, yes or no? Yes. During this time that you were drinking, was Mr. Gacy drinking with you? Yes, he had a couple with me. Did anything unusual occur that evening? Yes. When I came in, it was my birthday, I believe, and I came into the house, and he had a clown suit on. He said that he was preparing for the next day. He had some kind of benefit charity to do with some kids with the clowning, and he thought it would be rather cute if, seeing it was my birthday, that he leave the uniform on, and he was showing me some of his puppets and so on and so forth, and then he came up with a handcuff trick. And what do you mean, a handcuff trick? Well, how you can escape from handcuffs. Did he, in fact, demonstrate how he demonstrated them, and he took them off? I was so plowed, I didn't, really pay attention to it. Did he ask if he could perform the trick on you? Yes, he said to me, maybe sometime I'll need it. Were you sitting down at the time? Yes, I was. In the family room? Yes. Did he, in fact, put the handcuffs on you? Yes, he did. Were they in front of you or in back of you? In front of me. Were you able to escape from the handcuffs? No, the trick was you needed the key. At the time you were handcuffed, did Mr. Gacy say anything to you or do anything to you? Well, I held the handcuffs up and I told him, get them off. And he grabbed me by the chain and swung me around the room a couple times. I just, said, get these off me, Did he say anything to you at that time? Yes, he said, I'm going to rape you. And I kind of freaked out, straightened up a little bit. Did you do anything at that time? Yes, I ended up kicking him in the head. You what? Ended up kicking him in the head? Did Mr. Gacy then take the cuffs off? I did. How did you get them off? With a key. Where did you get the key? Out of his pocket. Because they were lying on the counter, or one of the two. You needed a key to get out. Is that correct? Oh, for sure. No one in the courtroom could escape the skin-crawling feeling that they had heard a story that was creepily similar to that one before. We could not avoid the sting that was left in the air. Some jurors looked down their noses at Gacy. They hated him. I had to remind the jury that my client was crazy, that he was insane. I had my opportunity on cross-examination of Mr. Rossi later that day. Rossi's testimony was limited because he had retained counsel. He was being represented by Edward V. Hanrahan. Mr. Hanrahan had served as the elected state's attorney of Cook County prior to being defeated by the now sitting state's attorney, Bernard Carey. He was a good lawyer and had already demanded immunity for his client. The state was just plain stingy with offers of immunity because they had been burned while doing this in the past. When on cross-examination, a jury finds out that a witness is testifying pursuant to an agreement to grant immunity from prosecution, they tend not to believe the testimony of that witness. They think they are just testifying in exchange for the deal and will say anything. Therefore, the state would not agree to a deal for Mr. Rossi. As such, Mr. Rossi was more or less uncooperative, and the state did not use his testimony as extensively as they might have, had he been more cooperative. However, I was able to use some of Mr. Rossi's extensive knowledge of Mr. Gacy to show the jury how truly insane my client was. Rossi had been at John's house when Lieutenant Kozenzak and Officer Pickle went out to confront Mr. Gacy for the very first time. I had to remind the jury that my client was crazy, that he was insane. This was my chance. On the night of December 12th, Kozenzak and Pickle had been out to interview Gacy regarding the PS disappearance. After they had gone, Mike Rossi came in screaming about the police. I directed his attention to that night. After they left, you went into the house. Is that right? I was in the house. And Mr. Gacy went up into the attic? Yes, sir. Where were you when he did that? In the hallway. In the hallway below the attic? Yes, sir. What was Mr. Gacy wearing? I believe he was wearing blue pants and a leisure shirt. And when he went up in that attic, he went up there to get Christmas tree ornaments? Yes, sir. How did he appear to you? Did he appear to be normal at that time? Anything unusual? Well, there'd been a death in the family, but outside of that, he was okay. He was upset. Who died? An uncle or something. He was upset about that. Slightly. But that seemed to be all that bothered him, right? Did he seem bothered when he went up into the attic? Or was he his old self, bringing the ornaments down? Normal. I looked at the jury for a long minute or two. I couldn't say it out loud, that would be testifying, but I wanted to psychically transmit to them the memory of the other testimony that they had heard about that night. If John Wayne Gacy was retrieving Christmas ornaments from the attic in his house on the night of December 12th, he had to reach over the naked, dead body of Rob Piest to do it. Michael Rossi was standing at the bottom of the ladder while Gacy nonchalantly got the ornaments, probably humming Christmas carols as he reached for the box. No one, except a person that was filled with madness, that was clinically and permanently insane, could perform such a task and arrive back at the bottom of that ladder looking normal. Day after day, Saturdays included, the story of John Wayne Gacy unfolded. Slowly, carefully, the state filled in the details. Officer David Hackmeister and Assistant State's Attorney Lawrence Finder both testified to the continued impromptu confessions by Mr. Gacy, including the hair-raising tale about his demonstration of the rope trick on Larry's arm. The jury heard from Dan Gentry, the evidence technician that unearthed the very first bone of the very first body and uttered the now somewhat famous declaration, "Charge him." In a trial, you cannot simply point to a picture and say, "That's victim number 1, Butkovich. He was strangled by the defendant." A painstaking and elaborate process is necessary to establish the identification of bodies and the cause and manner of death. Forensic dentists and forensic doctors must be called to the stand to offer grotesque and mind-numbing testimony as to each and every little aspect of the process. When doctors testify, the room usually goes to sleep quickly, not always figuratively. Dr. Robert Stein, the Cook County medical examiner, was one of the doctors called to testify regarding cause and manner of death. We had been concerned about his testimony from the very beginning, because he had been the doctor that was interviewed on NBC when Bob first became involved with the case. He gave the hypothetical opinion that a man who killed 33 kids could be sane. We had to ensure that he stayed far away from any kind of testimony like that on the stand. Although he was a doctor, he really wasn't qualified to make that assertion. But because he was a doctor, if he made such an assertion, the jury might believe it. The lawyers and the judge wrangled over this in chambers and outside the purview of the jury. Stein primarily testified that the victims were strangled. Many were found with ropes still around their necks when they were removed from the crawl space. Many had some kind of cloth stuffed into their throats, The testimony was gruesome and graphic. However, he stayed away from giving his opinion as to the sanity of Mr. Gacy. The state filled in whatever holes they believed were left to fill with their remaining witnesses. The issue of sanity was for us to raise in our case. Once raised as an issue, the burden of proof shifted to the state to prove beyond a reasonable doubt that the defendant was sane at the time of the offense, or in this case, offenses. Therefore, the prosecution would not call any doctors to testify as to Mr. Gacy's sanity until their rebuttal case. Everybody in all of Chicagoland and the world knew that there would be doctors called to argue over John Wayne Gacy's sanity. But that is just the procedure. That is how it is done. So with no further witnesses to testify regarding this phase of the case, after 3.5 weeks of testimony designed to prove that John Wayne Gacy was a murderer, the state of Illinois rested its case. The lawyers retired to their corners to lick their wounds and prepare for round 2 of the battle. Chapter 31. On Thursday, February 21st, 1980, Bob and I presented our first witness on behalf of the defense of our client, John Wayne Gacy. I never knew what to believe regarding most of Jeffrey Rignall's tale of woe regarding the night that he and Gacy met. The story from my client and the story from Mr. Rignall diverged on many points. However, that is often the case when a lawyer puts a witness on the stand to testify. We, as lawyers, were not there at the time of the occurrence. We only know what we are told by our witnesses. Many times, memories fade, and agendas fill in the blanks. We have to trust that when a witness is sworn before God to tell the truth, he or she takes it seriously. In Jeffrey Rignall's case, he had already published a book regarding his expected testimony and appeared on several talk shows and radio broadcasts to tell his sad story. John Wayne Gacy had made him famous. Bob and I both felt that to call on one of Gacy's most vociferous accusers was a risk. But we felt it would show that we were not afraid of the horror that this story would unfold. There was no question that our client was seen as a monster by most of the country and the world. We had to show that in spite of the horrific nature of the crimes committed, our client was unable to control his actions. Jeffrey Rignall dutifully related his now famous nightmare, exactly as he described in his book, with all the gory details about chloroform and a bleeding rectum. Either he was a very good actor, or he was still quite shaken by the experience that he had endured nearly 2 years earlier, because he broke into tears at one point and suddenly vomited. The judge recessed court. When all was returned to normal, after the cleaning crew had gone, Jeffrey returned to the stand. The following very important testimony was elicited. "Sir, you are Mr. Jeffrey Rignall." "Correct." "You are the same Mr. Rignall who testified earlier in this trial, right?" "Correct." "And you realize you are still under oath, correct?" "Yes." "Okay now, Mr. Rignall, I want to once again ask you if you recall the early morning hours of March 22nd, 1978. "Yes." "And that is the morning to which you testified earlier, is that correct?" "Correct." "Okay. Based on your own personal observations, all the surrounding circumstances involving those personal observations, do you have an opinion as to whether John Gacy, at that time, during those attacks, could conform his conduct to the requirements of the law?" "Kunkel, objection!" "Court, overruled." "Do you have an opinion?" I asked, disregarding Kunkel and his objection. "Yes." "What is that opinion?" Kunkel, objection! Court, overruled. Mr. Kunkel did not want Jeffrey to say the words that he knew were coming. I raised my voice over his. "What is that opinion?" I persisted. "Could he conform his conduct to the requirements of the law?" "No." "How did you reach that opinion?" "By the beastly and animalistic ways he attacked me." I continued with my voice at high decibels. "Do you have an opinion as to whether he could appreciate the criminality of his acts at the time?" Kunkel. "Objection!" Court. Overruled. "Yes," Rignall answered over the din of lawyers and judges sparring. "And what is that opinion?" Kunkel. "Objection!" Court. Overruled. "No," Rignall said, shaking his head vigorously. He was telling the court that our client could not appreciate the criminality of his acts at the time, answering my underlying question. "And how did you reach that opinion?" "By the way he attacked me, in the beastly manner that he did it. What he did to me." I was praying that this kid was not going to puke again. He was shaking and quite upset. Kunkel had lost that little volley. I calmed down and asked a few more questions about Mr. Rignall's ongoing medical treatment and his ongoing therapy. Then I said, "I have no further questions." Mr. Rignall was excused from the witness stand, and he tentatively and carefully escaped the courtroom, shaking frailly as he walked. Bob and I gave each other a knowing look. Our first witness had given his personal opinion from the stand, based on his personal experience, his encounter with the defendant. And his opinion was that John Wayne Gacy could not conform his conduct to the requirements of the law, nor could he understand the criminality of his actions. In his humble opinion, Gacy was nuts. We wanted to show the erratic, changing nature of our client. Gacy would act pleasant and charming one minute, and then without warning, he would be somebody else the next. So we called Lillian Grexa, Gacy's longtime neighbor. She told the jury that John was warm and generous, always smiling, that he had wonderful block parties. He was a good daddy and good neighbor, but he kept his bushes too high, didn't trim them. Other than that, he was a great guy. This woman looked like the lady that lives in every neighborhood, on every block, in every city. A nice little old ethnic lady that smiles and bakes cookies kind of woman. The jury knew her. The jury believed her. And so the dichotomy appeared. Apparently, Mr. Gacy was not just the monster they had all heard about. He was something else, too. Now these fine men and women of the jury would actually have to think, to listen to the evidence. We put on a couple of other witnesses that testified regarding the good side of John Gacy. Then we ended the day with testimony from Mickle Reed. Mr. Reed had lived with John years earlier and had actually considered John a dear friend. "Sir, could you please state your name and spell it for the court reporter?" "Mickle Reed. Mickelried. Where do you currently reside?" 1349 West Toohey. "Are you married?" "Yes." "Do you have any children?" "One." "What is your business or occupation?" "Welder." "Are you currently employed?" "Yes." I continued asking perfunctory questions before I got down to the point. "Mr. Reed, do you know the defendant, John Wayne Gacy, in this matter?" "Yes, I do." "Is he here in court?" "Yes." "Point him out, please." "Green suit." Mr. Reed pointed at John. "Could you please tell the ladies and gentlemen of the jury where, when, and under what circumstances you met Mr. Gacy?" "I met John 1971. "Would it have been around November 1970? "Could have been. I'm not sure about the date." Mr. Reed testified that he and Gacy had become friends, that he moved into Gacy's house, that he got to know him as a good person, a good father, and a good family man. Now, while you were living with him, do you remember when you moved out of the house? I think it was September. September of, like, fall. 71, I believe. 1971. Uh-huh. And why did you suddenly move out? Did you suddenly move out, or did you plan to move out? Had another place to stay? Well, I just suddenly moved. Now, calling your attention to, I believe, the day before you moved out, could you please tell the ladies and gentlemen of the jury if you observed anything unusual about John Gacy? Well, we came into the garage one night. It was dark. We went to unload some of the equipment, and we got out of the car, and the lights went out in the garage. And John told me to get some fuses under the workbench. So, as I was doing that on my hands and knees, I got hit on the head with something. Did you later learn what that was you got hit on the head with? Yeah, hammer. What, if anything, happened to you when you got hit with the hammer? I stayed down for a couple of seconds, and I kind of stood up and saw John was looking like he was going to hit me again. Now, when you say, backtrack just a little bit, did anything happen physically when you got hit with the hammer? Well, I hurt my head. Did you bleed at all? Yes. You say you did get up then? I did. When you got up, what was John Gacy doing? He had his arm back with a hammer in it. Looked as though he was going to hit me again. What kind of look did he have in his eyes? Well, kind of strange. Had you ever seen that look before? No. Had he ever done anything to you like that before? No. Before that, did you threaten him or try to hurt him? Or did you try to strike him or anything? No. Did you threaten him with anything at all? No, I didn't. Any kind of extortion? No. You say you got up and looked at him, and he had a strange look in his eye. What, if anything, did you do? I put my hand to stop his hand from coming back down, and at the same time, I asked him what he was doing or why he wanted to hit me. It was calm, like that in an instant, or did it take a long period of time? He hit me, I stood up, grabbed his arm, and asked him what he was doing or what he thought he was doing. What, if anything, did he say to you? He just looked at me and then put the hammer down. Did his expression change at all? Yes, it did. How did it change? He seemed like he was sorry he hit me. He put the hammer down? Yes. What, if anything, did he do to you at that point? He told me that he didn't know what came over him, but he felt like he wanted to kill me. Now, after he said that, and he put the hammer down, what, if anything, did he do? Well, I guess he patched up my head. Patched up your head? Yes. Where? Right in the garage or in the house? No, we went into the house. And what was he doing or saying? He was sorry that he did it. And then you moved out the next day. The next day. Now, as you look back at that, Mr. Reed, have you formed or do you have an opinion as to that particular time with the hammer in the garage? Do you have an opinion as to whether John Gacy knew or could conform his conduct to the law? Do you have an opinion? Yes. What is that opinion? I don't think he knew what he was doing. Do you have an opinion as to whether or not he could appreciate the criminality of that act at that time? No. You don't have an opinion? I do. I don't think he knew what he was doing. Was that behavior different from the John Gacy you had known for those 6 months? Yes. Other than that behavior, what kind of guy was he? Well, he was like a brother to me. He treated you good? Yes. No further questions. Thank you, Mr. Reed. I looked at the prosecution table. Your witness. As we closed in on the end of week number 4, we believed that we had successfully upset any plans by members of the jury to politely listen to what was said from the witness stand and then quickly vote to convict this bastard. They were going to have to really give the case their serious consideration. At least, that's what we thought. On Friday morning, we put on several more character witnesses to testify to the various sides of Mr. Gacy. Finally, it was time to break out the shrinks. The testimony of the men and women on which the entire case would hinge, would turn, would be ultimately decided. The doctors that would make it simple for the jurors to understand the case and the defendant, John Gacy. Right. Chapter 32. Before Dr. Timothy Leary was known as the LSD guru, and he coined the phrase, tune in, turn on, and drop out, he was a very well-respected man in the field of psychological sciences. He was a member of the team at Harvard University's Department of Social Relations and a frequent speaker and writer regarding psychiatric and psychological research and study. He was credentialed. He was a big-time, hotshot shrink. I read something that he said, which was quoted in the popular book I'm Okay, You're Okay, many years ago, that has stuck with me ever since. Here's the quote. I would like to share with you some of the historical background of my immobilization as a psychological scientist. As I look back, I can see that there were 3 stages of my own ignorance. The first, which is by far the most happy, you could call the stage of innocent ignorance. When I was possessed with the notion that there were some secrets of human nature, there were some laws and regularities, some cause and effect relationships, and that through study, through experiences, through reading, someday I would share these secrets and be able to apply my knowledge of these regularities of human behavior to help other people. In the second stage, which might be called the period of illusion of non-ignorance, came the disturbing discovery that, although on the one hand, I didn't know what the secret was, suddenly I discovered that on the other hand, people were looking at me as though they thought I might know the secret or be closer to the secret than they. None of the research that I did worked, nor did any of my activities provide any secret. But again, I could always say, well, we didn't have enough cases, or we must improve the methodology. And there were many other statements, which I'm sure you are familiar with. One can postpone the painful moment of discovery, but eventually the unhappy truth finally becomes apparent. That although many people may be looking to you and listening to you, you have patients and students, and you're going to PTA meetings, and they are looking to you for the secret. Still, eventually you begin to think maybe you don't know what you're talking about. By no means am I trying to imply that psychiatrists or psychologists or others in their field do not know what they are talking about. I would never say that, and I do not think that. Heaven forbid, perish the very thought. What I can say is this. Of the 7 major psychiatric and psychological experts that testified either on behalf of the state or on behalf of the defense, doctors and PhDs all, no 2 of them diagnosed the defendant in the same way. They all said that he was crazy. On that, there was a consensus, but nobody seemed to know why or to what degree. They did, however, have plenty to say about the subject of John Wayne Gacy. The standard issue testimony of an expert witness in any field begins with an hour or so of credentials. Every school, every degree, every treatise, every book, every speaking engagement, every teaching position, all of it must be painstakingly and carefully testified to from the stand. Otherwise, what the heck are they doing up there, right? They are experts, after all. After they are through with the accolades and everyone in the courtroom has gone somewhere else in their minds, they begin to expound. That's where the fun really begins. Let's just say that for days and days, the jury learned more about the field of psychiatry and psychology than they ever planned to know. This knowledge came to them from the stand in a foray of $50 words and 10-cent examples. They did, however, hear some incredibly interesting nuggets about our client interspersed between the mumbo-jumbo. Let's give credit where credit is due. And, truth be known, the testimony was absolutely essential to the defense. Bob and I would not have been able to make our case without them. Let me try to encapsulate days of testimony into sound bites that set forth their primary message. Dr. Helen Morrison, probably our best expert witness, shocked the jury with the information that Mr. Gacy, as a child and adolescent, would steal silk women's underwear, use them for private sex, and bury them under the house. That information will kind of take your breath away when you first hear it. It does lend itself to the possible interpretation that maybe the defendant went off the proverbial rails long before he had a fighting chance to change directions. That story was repeated by other shrinks as well. The fine doctor used many big words to explain to the jury that John Wayne Gacy was insane. The big question remained, however, was he insane enough? Was he insane at the time of the crimes? Her testimony was clear. Now, doctor, based on all that you have reviewed, your clinical evaluation, your expertise in the field of psychiatry, do you have an opinion based on a reasonable degree of medical certainty as to whether John Gacy, as a result of the mental disease you have described, lacked substantial capacity to conform his conduct with the requirements of the law at this time of each of the alleged acts? Yes. What is that opinion? That because of the continuous mental disease, he was unable to conform his conduct at the time prior to and during each of those acts. Doctor, did you further have an opinion based on a reasonable degree of medical certainty as to whether or not Mr. John Gacy, because of the mental disease that you have described, lacked substantial capacity to appreciate the criminality of his conduct? Yes. What is your opinion? Her opinion was the same as her original report. According to this highly respected woman, whose field of study was specific to serial killers, whom she considered a special breed of individuals, persons that did not fit the standardized molds of human behavior, or the ways in which these persons are categorized, it was this. Although superficial evaluation could not permit the development of other than an almost simplistic view of the mental disease of the defendant, a continuing evaluation shows a complexity of profound psychopathology not limited to one diagnostic category. Indeed, there is an incomplete recognition in the psychiatric diagnostic literature of the complexity and exact nature of the psychopathology. At least, he may be said to be suffering from a psychosis with paranoid, intermittent delusional thought processes that is layered by a borderline syndrome of extremely low-level functioning. As such, the above results in a profound impairment that severely affected his ability to appreciate the criminality of his conduct and to conform his conduct to the requirements of the law. Dr. Richard Rappaport had a different diagnosis, a different take entirely from Dr. Morrison's. However, he seemed to arrive at the same place. Gacy was crazy. This after hours of testimony containing information like this. An electroencephalogram is a brain wave test which enables one to get a rough idea or approximation of whether or not there's any gross pathology in the brain tumors or space-occupying lesions in particular. And an hour later, he was saying this. The first characteristic under sensorium is orientation. Is the person oriented as to time, place, and person? And he was. He knew where he was, what time it was, who I was, and who he was. An individual with organic brain illness or psychosis might not be able to differentiate himself from another person. Finally, thank heaven, he said the following to Bob Motta on direct examination. Q. Now, doctor, based on your examination, everything that you have reviewed in this case, your diagnosis, your expertise in the field of psychiatry, do you have an opinion based on a reasonable degree of medical certainty as to whether John Gacy suffered from a mental disease continuously and interruptedly prior to and including the date of January 1st, 1972 through the present? A. Yes. Q. What is that mental disease? A. Borderline personality organization. Q. Now, based on a reasonable degree of medical certainty, was he suffering from that disease at the time of the alleged acts? A. Yes. Q. Do you further have an opinion based on a reasonable degree of medical certainty as to whether John Gacy, as a result of that mental disease, lacked substantial capacity to conform his conduct to the requirements of the law at the time of each of the alleged acts? Kunkel. Objection. Court. Overruled. A. Yes. Q. And what is that opinion? Kunkel. Objection. Court. Overruled. A. He did lack substantial capacity to control his behavior at the time of each of those crimes. Q. And conform his conduct to the requirements of law? And to conform his conduct to the requirements of law. Q. All right. Now, doctor, I want to ask you a few further questions. Would it change your opinion in any way if John Gacy had, prior to his arrest, told the police that he had no knowledge of the missing Piest boy? A. No. Q. Why not? A. Well, it is consistent with his ambivalent way of expressing his feelings. Sometimes he has knowledge. Sometimes he has no knowledge. Sometimes he denies. Sometimes he acknowledges. His wavering and inconsistency is a great part of his disease. And so it went. So, thank you, doctors. Thanks to everyone. I guess that pretty much cinches it. All questions about our client have been answered. He's nuts. Just like we've been telling you. I guess we can all pack it up and go home, huh? I mean, if a doctor testifies that a guy has a broken leg, he has a broken leg, right? So if a doctor, hell, 2 doctors, testifies that our client has a broken brain, I guess that does it. Game, set, match. Let's go. Don't you people miss your wives and kids? Apparently, I was jumping the gun a bit. It seems that all shrinks, although they are all doctors studying the exact same thing, don't always agree. Plus, Kunkel wasn't done with Dr. Rappaport. He cross-examined that man for over an hour. He actually tried to bring the fine doctor's opinion into question. It wasn't pretty. He especially liked it when Dr. Rappaport described Gacy's personality as being like an onion, many, many layers, which had to be peeled back, and Gacy's alter ego as Swiss cheese with many, many holes. Therefore, he had no conscience. Kunkel had a bit of a field day with that on cross. All in all, however, the fine doctor held his own against Kunkel. The state had their doctors as well, of course. Sparks flew during the direct examination of one of the state's experts, Dr. James Lewis Kavanaugh, Jr. Again, Bill Kunkel was asking the questions. During opening statements in this case, Mr. Mata referred to his desire that the defendant would be put in some mental institution or hospital for the rest of his life. Is that possible in Illinois, Doctor? I stood up. Objection, I said. The judge asked, Is what possible? He was looking at Kunkel. I continued my objection. As to what is possible? Kunkel continued without a ruling. Is it possible to guarantee a person not found guilty by reason of insanity and then committed to a mental hospital, Department of Mental Health in Illinois, will remain there for the rest of his life? Kavanaugh answered with the following words. Absolutely impossible, I guarantee. The whole thrust of legal impact changes on the ability to keep individuals many times, in my opinion, who need to be in hospitals. Has been so extensive that we find it very difficult to keep people in hospitals who in fact need to be there, because of concern, which I can understand, that to hospitalize is a deprivation of civil rights. And we live in a... He had gotten these words out. Then a small version of hell broke out. What the fine doctor was saying was that there was no guarantee that if Gacy was found not guilty by reason of insanity, he would stay in an institution. He was implying that Gacy might walk out of court a free man. Obviously, this was a terrible problem for us. Actually, for everybody. This could be grounds for a mistrial. We all might have to start this whole thing over. If the jury thought John was going to walk out of court, they would never vote for a not guilty by reason of insanity verdict. Hell, would you? The only other problem with the testimony, aside from it being told to the jury, was this. It was not true. This was the voice of an airhead academic spouting puffy, fluffy academic theory and speculating about his civil rights, not an area of his expertise. Even the puffy, fluffy academic theory was wrong. Mata jumped to his feet. Objection, Judge. Can we have a sidebar, please? Mistrial, I said, as all the lawyers headed for the bench. As we surrounded the judge and frantically whispered, tempers flared a bit. I am objecting to the materiality, I began in hushed but heated tones. I went on. He's talking in terms of possibilities, talking in terms of civil rights, and none of it is material to the case. It creates an inference for the jury that may or may not be true. A guy like Gacy, I think, should spend the rest of his life in a mental institution. Garippo said, Well, I don't know. Judge didn't get to say anything else just then. Nobody knows, I hissed. How can he testify to that? If you're going to let him testify to that, then I'll call back every one of our doctors. The judge ruled that for now, the testimony would stand. Kunkel said, All right. He was just trying to calm things down. Mistrial, I said, but this argument would have to be shelved for later. We had a jury staring at us. We returned to our corners. Kunkel continued questioning the witness, staying clear of the speculation that had been said. When Mr. Kunkel was through with his witness, Bob stood up to cross-examine him. Q. Dr. Rappaport. Oh, this is Dr. Kavanaugh, I see. Is that a Freudian slip? Dr. Kavanaugh, do you think that Mr. John Gacy needs to be in a mental hospital? A. I don't believe he would benefit from treatment. Q. Do you think he needs to be in a mental hospital? A. No, I don't. Q. You don't. Could you describe the procedure regarding commitment after a finding of not guilty by reason of insanity? Kunkel. Objection. The judge has already instructed the jury as to that. Judge. Well, he may repeat it. Q. He asked the question, Judge. Bob was pointing at Mr. Kunkel. Judge. He may repeat it. Q. We'll find out. A. The procedure is identical to that of any other patient when the issue of potential and involuntary commitment is raised. In order to involuntarily commit, the individual must demonstrate imminent danger to himself or others, or has to be in such a state as to be adjudged essentially unable to care for himself or herself. Q. Do you think that John Gacy presents an imminent danger to himself or others? A. Imminent danger. Q. Right. A. No. Q. All right, if he is found not guilty by reason of insanity, do you think he would pose an imminent danger to others? A. I believe if he was found not guilty by reason of insanity, he would not meet the state's involuntary commitment standards. Q. Would you say that Mr. Gacy would be released? A. If the law were followed, I believe he would have to be released. Q. You would testify he was not a danger to other people, Dr. Kavanaugh? A. I would testify that he were not eminently... Q. Do you call killing one person after another a danger to people or society? A. It is certainly a danger to society. The standard... Q. If he were released, Kunkel. Objection. Q. Would there be an imminent danger? Judge. Should we go off to the side? Chapter 33. We were both concerned about the lingering sting left over from the battle over Dr. Kavanaugh's testimony. It was devastating to think about how that information was going to affect the jury's collective thinking. It was an easy issue to obsess about. It could have put us off our stride. However, we had forgotten one thing. We were the attorneys for Mr. John Wayne Gacy, and where Mr. Gacy was concerned, there was little time to obsess. There was always something new on the horizon. On Friday morning of week 5, Gacy decided to be Gacy and add to the theatrics. Unbeknownst to Mata and me, Gacy had written a letter to the judge from jail 2 weeks prior. The judge gave it to us, and we read it and pretty much dismissed it. We had better things to worry about. Evidently, Gacy had not forgotten about the letter, and he had sent word to the judge that he wanted to discuss it. Judge Garippo came out of chambers first thing Friday and explained that he had some matters to attend to before the jury was called. You can't make this stuff up. Over 2 weeks ago, the record should show that Mr. Gacy wrote me a letter with a few complaints. I gave that letter to his attorneys and was assured that there was no problem. Today, I have received another letter from Mr. Gacy. Mr. Gacy, if you will step forward. Gacy tentatively stepped up to the bench. Is there anything you wish to say before this court? No, Gacy answered. Garippo couldn't believe his ears. Pardon? Was all he could say. After all, it was Mr. Gacy who had contacted him. Gacy stood there, arms at his side, shoulders slumped. No, he repeated. The judge simply stared at him. With respect to the letter, he prodded. Gacy was a study of befuddlement. He looked like a 12-year-old boy that didn't want to admit that he broke the window. Well, he said, it's written to you. The letter is between you and me. Garippo actually smiled ever so slightly and shook his head. Well, under the law, there can be nothing between you and me. It has to be on the record. Gacy was downcast and slouched. I expected him to kick the toe of his right shoe into the heel of his left, the classic aw shucks move. You could do what you want with the letter, he mumbled. Do what I want with the letter? Garippo's eyes twinkled. Yes. All right. Here's what I will do with the letter. First, the letter will be made part of the record. The judge raised the letter to eye level and peered through his gold-rimmed glasses. It reads, Over 2 weeks ago, I asked that my trial be stopped, and I haven't heard from you. When I asked my attorneys as to why we are not putting on more witnesses, I am told that we don't have money to bring in an expert. I also asked for a mistrial. As never before has this court allowed a professional witness plants a seed in the jury head like it was done yesterday. I think that you can give them instructions until you're blue in the face, and you won't take that out of their heads. When Kavanaugh said John Gacy would not qualify for commitment to a mental institution and would have to be set free if he were found not guilty by reason of insanity, as you know, other than so-called statements made by me and given in a self-serving manner by officers for the prosecution, there is only evidence that I own the house that was used for bodies for their safekeeping. Until something is done to correct this injustice, I will no longer have anything to do with my attorneys, and I am taking back my word in regards to not saying anything in the courtroom. The prosecution continued to tries to make me mad while the trial is going on with the taking of my PDM contractor labels and putting them all over the place. That's receiving of stolen properties. As I have never given my permission, and when yesterday Greg Badeau came up to me in open court and told me that I should stop smiling and swore at me, I don't have to take that. I don't think anyone should come forward to the prosecution tables until I am out of the courtroom. I await to hear from you, and I will abide by your word. Judge Garippo declared. Well, first, with regard to the mistrial, I have made my ruling on the question of a mistrial. As far as your bringing in experts, at no time have you been denied the opportunity to bring in experts. Any expert that was requested. The court has allowed any expert requested to come in and make examinations and testify. As far as reimbursement, I have indicated that each expert will be paid a reasonable amount. So that is clear in your mind. At no time have you been prevented from obtaining any witness because of expense. Then the judge leaned forward on the bench. His eyes bore a hole in Gacy. You said you would no longer have anything to do with any of your attorneys. Is that your position? That's correct, Gacy answered. Garippo seemed exasperated. He wanted this to be over. I will continue, for now, the balance of the trial, he said. And we will take that up. Why won't you have anything to do with your attorneys? Because I'm not running the trial. Are there any tactics that the defense is using, that your attorneys are using, that you don't agree with? I was against the insanity defense from the beginning. You were against the insanity defense from the beginning. That's correct. While I may not be capable of defending myself, I was against the insanity defense. I'm sure Mr. Amarante and Mr. Mata will both tell you that. Have a seat, Garippo said. Gacy moped off and sat down at the defense table. Garippo looked at me. Do you have any statements to make, counsel? I could barely talk. The only statement I could make was, Mr. Mata and I have been indicating to Your Honor, since prior to the inception of this trial on the record, I think, we have just had an example of the problem with the degree of a defendant's mental illness addressed in our laws right now. Mr. Gacy should have been committed prior to trial. He should be committed now, and because of the degree of his mental illness, we wind up with problems like this. Explain yourself, Garippo said. I went on to explain that it had been my position from the beginning of trial that, although Mr. Gacy complied technically within the competency statute, the statute itself was unconstitutional as it applied to Mr. Gacy. Obviously, Judge, based on what you just saw and heard, he's actually not fit for trial. The judge allowed us to make our record, during which Gacy blurted out from his seat at the defense table, I did not commit the crimes. However, the judge was not about to end the trial and rule that Gacy was unfit. After an impromptu hearing ensued outside of the presence of the jury, in which Bob and I argued the merits of our contention that the competency statute was unconstitutional as it applied to our client. The judge began to nudge the trial back onto the tracks from which it had been derailed. "All right," he declared. "I make a further finding that based on my observations of the defendant in the courtroom, his demeanor, and all of the evidence in the trial, I would enter a finding right now. In a hearing as to fitness under Section 1005-2-1, I would enter a finding that the defendant is, in fact, fit to stand trial. Now, with respect to the question of dispute with his attorneys, is there anything you wish to say, Mr. Amarante or Mr. Mata, with respect to that?" Bob said, "No." I said, "Nothing." Both of us looking behind us at our client. "Mr. Gacy, if you will step forward again." Gacy trudged up to the bench like a surly teen. "Do you stand by your statements relative to your disagreement with your attorneys?" At that point, Bernard Carey, the elected state's attorney of Cook County, Illinois, a very high-profile and powerful figure in Illinois state politics, had wandered into the courtroom to check on the progress of his trusted assistants and to check on the progress of the biggest and most widely publicized trial his office had ever prosecuted. He had heard about the commotion that Mr. Gacy was causing with his letters and his craziness. When John Wayne Gacy saw Bernard Carey, he went off. "What the hell is he doing in here?" Gacy screamed, pointing and turning toward Carey. Immediately, the sheriff's deputies came off the walls and out of seats, their designated positions, and moved closer to Gacy. "You have no business in here. Leave this trial to the guys that know how to handle it, who know what they're doing. You aren't qualified to be in here. You have 3 of the best attorneys in your office working on this case, real attorneys, not political hacks like you." Bernard Carey was a Republican. To see an actual Republican in a Chicago courtroom was a rarity. John Gacy was a lifelong Democrat, a Democratic precinct captain for his voting district. I guess John didn't like Mr. Carey. By now, the sheriff's deputies were closing in on Gacy. The judge put an end to the disturbance right quick. He waved off the uniformed deputies. The whole exchange had lasted only a few seconds. Gacy had turned back to face the bench. "John," he said, "you will be the Democratic precinct captain till the end." The judge was waiting for an answer to his previously posed question. Finally, Gacy complied. "I don't know," he said sheepishly. "You don't know." The judge just shook his head, bewildered. "All right, have a seat." Gacy shuffled off back to the defense table. As he walked, the judge went on. "While we are on the subject right now, between now and the time—" Gacy stopped. Garippo pointed at the defendant's chair. "You may sit right there. I will address you, Mr. Gacy. Between now and the time your attorneys rest your case, you have to decide whether or not you wish to testify before this jury. Do you understand that?" Gacy had sat down. "Yes," he said from his chair. "Okay," said Garippo, always the protector of the record. "Call the jury." After the jury was seated, and for a very short time, the courtroom was treated to more mind-numbing testimony from a doctor. This time, Dr. Tobias Broker was called to sing everyone a lullaby. I shouldn't say that. He was our witness, but doctors bore me. Thankfully, it was almost lunchtime. Over the lunch break, the entire courthouse was abuzz with the rumor that Gacy had fired Bob and me. It has always been amazing to me how a story like that can be felt in the air. It's like static electricity. People look at you differently. Some avert their eyes. Others come up and pat you on the back and say things like, "Tough break," or "You're better off," and walk away, leaving you wondering what the hell they meant. Outside the courthouse, the talking heads could hardly contain themselves. They barely even took a breath while reporting the breaking news. Everyone wanted to scoop everyone else. They broke into soap operas and afternoon game shows with bulletins. It was hilarious to Bob and me. Funny that we were not informed. When Gacy heard about the news in prisoner holding, he was flabbergasted. He had already forgotten all about his earlier miff over his own lawyers in favor of his shining moment with Bernie Carey. He wanted to hear the judge's compliment about him being a Democratic precinct captain to the end on the air. Where was that story? After lunch, Gacy called us back into prisoner holding and told us he wanted to make a statement concerning the morning's brouhaha. We informed the court. Upon reconvening, the entire courtroom was treated to a little piece of insanity. Compliments of John Wayne Gacy. All right, before the jury comes out, do we have a statement to make? Garippo was sitting tall on the bench with that familiar twinkle in his eye. He went on. Mr. Gacy wants to make a statement. You wish to make a statement, Mr. Gacy? Gacy simply said, yes. I believe the words, Your Honor, stuck in his throat. He could never seem to get them out. Then a miracle occurred. The judge said, all right. And Gacy said, Your Honor. And then he was off. His statement was priceless. It seems to me, like as with everything else in this whole case, everything I seem to say has been misconstrued in the press, and I would like to set the record straight that I did not fire my attorneys. I did not ask for their leave from this case. It's just that I stated, and will state again, that I do not understand everything that is going on, and I am against the insanity defense because I lack the understanding or the appreciation of it because I don't truly understand it myself. I stated earlier that I do not feel I committed the crime, and anything I say is considered self-serving. All the statements, in retrospect, that I've given are confusing enough to me that at the time that I made the statement, I believe I would have confessed to the St. Valentine's Day Massacre if it was put to me. I believe in this courtroom, you have probably 5 of the finest attorneys that there are in the country, and I listen to them work as if it's a pretzel factory twisting every which way other than the truth. The papers, the newspapers especially, have taken everything out of context and have actually run everything one way or the other without ever bringing out the whole truth and nothing but the truth. And I thought that's what you are after. I can see with the seed planning done yesterday before the jury that no matter what you do or how you instruct the jury, you will never reverse what you have told the jury. I had stated before we started the trial to my attorneys that I would like to know myself if I committed the crime. I had talked to Dr. Friedman for a long time. As you know, I have seen doctors for over 300 hours, and in so doing, I have been still left in the same confused state that I am right now. While I am not denying the commission of the crime, I don't understand it. I don't understand why it happened. And that is why I don't understand the proceedings. I have been called every name under the sun in this courtroom, and half the time I leave the courtroom here not even knowing who I am. From an onion to a piece of Swiss cheese to somebody that is sane and somebody that is crazy, and quite frankly, I'm completely confused as to what has been going on. The state puts on a witness who claims to be my best friend. And in all actuality, it's just a person that I felt sorry for because of his illiteracy. Mr. Rode took the stand and claims he was my best friend. He was just a business acquaintance of mine. You put on different officers from the different varying police departments, and they all do self-serving statements. I'm at a point where I don't know what is right and what is wrong and what is truth and what is not the truth because of the mass confusion that has been going on since the thing started. I believe I have been tried and convicted and sentenced in the news media already. However, I understand they are not the ones trying me, but I also feel that nowhere in this land can I get a fair trial. Before this started, and even now, I think it's more prejudicial now than it was before. And again, I don't blame, like I say, the counsel, because I think, as well as for my own defense and for the prosecution, I think you have got some of the finest lawyers here in the country. I can see why Bernard Carey is not here, because he is not qualified. But the thing of it is that, be that as it may, everybody is going to twist everything to their own liking and to me. And it's just like they're playing a chess game. One move, and then another one moves, and I'm totally confused as to what's going on. That's why I told you I would abide by your decision and go on with the case. Garippo, very seriously, but still with a twinkle in the eye, responded. Well, he said, apparently, from your statements, your attorneys are doing an excellent job of presenting, I think, the feelings that you have expressed here in open court. The biggest problem, Gacy continued, I have had with my attorneys is that I have not been able to help them because I cannot remember. It's not that I am denying anything. I have never denied any of it. It's just that I don't know if, when it happened, was I aware of what I was doing. Garippo had seen enough of the Gacy show. All right now, all right. You may be seated, he said, dismissing Mr. Gacy. All right, call the jury. The rest of the trial went pretty much without incident. The state called Dr. Jan Fawcett, the last of their shrinks. He thought Gacy was crazy, but not crazy enough. Dr. Fawcett testified that John Wayne Gacy was able to understand the nature of the crimes committed and that he could have conformed himself to the law. Gacy, according to Dr. Fawcett, was quite sane. This testimony was given with the sound of Gacy's letter and statement still ringing in the jury's ears. All parties rested their case. It was time for closing arguments. Bob and I had returned to feeling that our case was strong. The state had to prove, beyond a reasonable doubt, that the man sitting next to me was sane. Was that possible? Chapter 34. Terry Sullivan had shepherded this case through each phase of the investigation from the very beginning to the present. Ever since Terry moved himself and his personal coffee pot into the makeshift command office in the Des Plaines Police Department, he had been the representative from the Cook County State Attorney's Office and the supervisor that kept the investigation on the straight and narrow. His closing argument in the Gacy case was the culmination of long hours, dedication, and hard work, on which he had spent just over a year of his life. This was his baby, and his passion was apparent as he spoke. He approached the lectern in front of the jury box, grabbed it, leaned forward, and began. Judge Garippo, Mr. Kunkel, Mr. Egan, Mr. Varga, counsel for the defense, ladies and gentlemen of the jury. Today is March 11th, 1980. On Thursday, March 13th, 2 days from now, John Mowry would have been 23 years old if he had been allowed to live. Instead, his body was uncovered from John Gacy's crawl space. On Sunday, March 16th, Robert Piest would have celebrated his 17th birthday. Instead, his body was recovered from the Des Plaines River, the very river that he had volunteered to clean to become an Eagle Scout. On Monday, March 17th, John Gacy will celebrate his 38th birthday. Before that, you will have the opportunity to decide whether or not John Gacy is allowed to be sitting somewhere in an easy chair with his legs propped up, in his casual clothes, puffing on one of his big cigars and making another one of his famous phone calls. Before that, you will decide whether or not he is allowed to tell a friend, such as Ron Rode, on the telephone on Sunday or Monday, "Ron, didn't I tell you? Didn't I tell you I'd be out? I'd beat the system again." Or you will be the ones to tell John Gacy, in a loud and clear tone, a message that says, John Gacy, your cruising days are over. Young boys need fear you no more. You didn't have to study the jury to determine if they were paying attention. One quick look, one passing glance, and anyone could see that Terry had captured the rapt attention of each and every jury member. He was painting a picture. He began to pace and move about the well of the court. You will have the opportunity to tell him, John Gacy, you will not manipulate us. You will be able to send him a message. You are guilty. You people have served a long trial, and in a very unselfish manner. On behalf of my partners, on behalf of the people of the state of Illinois, whom we represent, I wish to thank you. Terry was settling in, finding his stride. After having lived with this case every day of his life for such a long period of time, he knew what he wanted to tell this jury. He had been preparing for this moment for over a year. Terry began by reminding the jury of the initial questions asked of them back in Rockford, when they were being selected as jurors, bringing them back to the beginning, reminding them how it felt to be told that they were going to be sitting on a jury where a man who was charged with 33 counts of murders would be judged. He reminded them that this case was not a single incident, not just one single massacre like a berserk person who maybe would take a machine gun and fire into a grade school for an hour. That is not what we saw here for the past month and a half. This wasn't a single incident. This went on for years. I believe that the evidence has shown you that these killings were carefully planned, that they were calculated, and then that they were carefully covered up. That evidence should have shown you people that John Gacy could make conscious, responsible choices. I'd like you to recall through your lifetimes that there have been other mass murderers, but seldom, if ever, has anyone been so cold, so cunning, so calculated over such a long period of time as John Gacy has. Terry was about to slice very thinly the primary issue in the case. He knew he had to do it. He also knew it was a risky move. He took a breath and continued. Now, I am not going to stand here for 1 minute and tell you that he is normal. No, I couldn't do it, and I wouldn't expect you to believe it. I'm going to tell you, right up front, that we consider him to be abnormal, not normal. You folks probably consider yourselves normal. You have never killed anyone before, let alone 33 people. He is abnormal. The very dictionary says that abnormal is a nonconformist, someone who is peculiar, bizarre, one who infringes the law, one who doesn't conform to what society dictates, someone who puts himself above. Yes, that is abnormal. That is John Gacy. But because he is abnormal doesn't mean he doesn't know the difference between right and wrong. If he does, he is legally responsible. There is quite a difference between being abnormal and legally insane. Nobody who murders is quite normal. So there it was, the crux of the case. The basic question, that searing question that had landed in the lap of this jury. It seems that everyone could now officially agree that John Gacy was crazy, that he was nuts, that he was abnormal. But was he nuts enough? Here was Terry Sullivan, arguing that our defense was right, agreeing with our basic premise that John Wayne Gacy was insane. He just didn't think he was insane enough. It would have been nice if he took a seat at that point, thanked the jury and left it at that. Of course he didn't. He had plenty more to say. We must stress to you people the concept of responsibility. The concept upon which our laws are created, that concept of criminal responsibility, that a person must be held responsible for his acts. Just because a person has a personality defect doesn't mean that he is insane. And just because he has a complex personality doesn't mean that he has a mental disease. Criminals don't make our laws, ladies and gentlemen. He is abnormal, but he is rational and he is sane. Now, you were instructed, and His Honor will instruct you again, that we had a burden to prove the defendant guilty beyond a reasonable doubt. We had that burden on two issues. Number one, we had to prove the defendant guilty beyond a reasonable doubt of 33 murders. And two, we also had to prove that he was legally responsible beyond a reasonable doubt. I feel there is no doubt but that we have proven both of those. As to the former, the fact that he has murdered 33 people, 27 of those individuals, those young boys, were found under John Gacy's house. One was found under the driveway, one under the back of the garage, 29 on his property. 4 were found in the river. Robert Piest, Tim O'Rourke, Frank Landigan, James Mazzara. You may recall that he said there were 5 that went in the river. We may even be missing someone still. That is, by his own statement. In addition, Robert Piest's jacket was found in his home. In addition, Frank Landigan's bond slip was found in the defendant's house. And in addition, he talks about the Mazzara boy as Joe from Elmwood Park. He has admitted to at least 30 murders. He said 30 or more. Subsequent to the recovery of the identifications were made. You heard Dr. Pavlik, the dentist, advise you on how he made identifications from teeth. You also heard Dr. Fitzpatrick, the radiologist, testify about certain X-rays in which he said he based his identification. I'm not going to bore you with all of that testimony, nor am I going through all of that again. We have proven that he has killed 33 people. I think we have also proven that the defendant has also taken other advantages, with which he is charged, with Robert Piest. As to the second point, the defendant being legally responsible, His Honor has told you before, and I will advise you of this again right now, that the only definition for being legally responsible is the one that has come from the court in Rockford, and the one that will come to you again. And that is simply this. Terry paused for effect. He eyed each and every member of the jury. A person is not criminally responsible for his conduct if at the time of such conduct, as a result of mental disease or defect, he lacked the substantial capacity either to appreciate the fact that his conduct is criminal or to conform that conduct to what is required by law. Those are the words that you are going to get again later from Judge Garippo. That is the only basis upon which you should make a decision. I suggest that the evidence here does not show that the defendant was not criminally responsible. In fact, when you look at all of the evidence, it shows that he did have the capacity to appreciate what he was doing and to conform his conduct to what the law requires. It shows further that the defendant was for years and is sane and calculating and premeditating and cunning and manipulating and evil and rational. His acts and words, ladies and gentlemen, show that. The evidence shows that. I think it further shows that the defense of insanity, as used by John Gacy, is a fraud. Plain and simple. Now, As we talk about the evidence, what I would like for you to do, if you can, is to keep in mind certain of the categories that have been gone over and over again. But maybe during the evidence, they haven't been all drawn together into neat little niches. Some of those categories that the psychologists and psychiatrists base some of their decisions on, things that they were looking for, things that you should have been looking for, using your common sense as to what makes a sane or an insane individual. Some of those things that I would ask you to consider again would be intelligence, his memory, his ability to manipulate or con people, his credibility or lack thereof, his self-control, the emotions that he may or may not have had, his use or misuse of alcohol or drugs, his work and sleep pattern, his physical acts or strengths, and finally, a category that I call consciousness of choice. That is, during his life, could he make conscious decisions? Now, back when this case first started, Mr. Mata, Mr. Gacy's attorney, made certain statements to you. In his opening argument, Mr. Mata said certain things that I would just like to reflect upon for a minute. He said that the evidence will show that John Gacy is insane under any standards. Whether it be that standard of your own good conscience or your common sense, the evidence will show undeniably that he could not control his conduct. Well, now, I'm not sure which courtroom Mr. Mata was in during this court case, but I don't think that the evidence has shown that at all. He said that our psychiatrists, that is, their psychiatrists, will testify that Mr. Gacy is incapable of forming an intent because his intelligence and thought processes were helpless. Incapable of forming an intent. Well, I think the evidence shows quite the contrary. It does show conscious choices. Terry went on to give an extensive restatement of how the state interpreted the evidence. He went through the witnesses he thought important and tried to emphasize testimony that he thought pertinent or helpful to his case. He talked for hours. Sometimes he had the jury's attention, and sometimes he did not. But he covered the evidence and related that to the story that was John Wayne Gacy. He did his job. He rarely looked at notes, except when he wanted to offer a direct quote. He was leading the jury to a place where he wanted them to be. Then he began to sum up. His passion for this case was unleashed. Finally, ladies and gentlemen, thank you for bearing with me. I know you're probably very hungry. Finally, I ask you only, what was the evidence that we have seen? What picture do we now have after all this evidence? We have a man who has led a life with no regard for the law or people in general. A man who has shown a consistent pattern of antisocial conduct from as far back as Iowa in 1965. He's intelligent. He's cunning. He decided that he enjoyed having sexual relationships with males, and in particular with boys. And he went about setting up, like a hunter, ways in which to lure and trap his prey, and then ways in which to disarm them, then to use them for his own gratification. He got caught once, but there were too many other boys in the future. Only henceforth he was to be more careful. Shows he thought those who would later cause him trouble he would kill, keep them out of his way. So like the tumbleweed that just keeps rolling along, John Gacy rolled through Iowa, being stopped only for a short time by prison walls. And then he rambled to Illinois and rolled and rolled and rolled through some of our youngest citizens, making sure along the way that nothing got in his way and being ever so careful to think before he acted, and then to cover up when he was done. And he left a path of destruction in his way. 33 boys were dead, and the lives of parents, brothers, sisters, fiancés, grandmothers, friends were left shattered. Mata couldn't take it anymore. He half rose from his seat. "Objection," he said. The judge didn't respond. He let it pass. Sullivan continued. "Even though technically he left some of the surviving victims, they were little more than void shells. You saw them. And perhaps described best as living dead. John Gacy has accounted for more human devastation than many earthly catastrophes. But one must tremble, I tremble, when thinking just how close he came to getting away with it all. Further, the evidence shows that his intention was to concrete that entire crawl space in the very near future, a move that certainly would have kept him from detection. John Gacy's freedom would no doubt have meant for others, somewhere, more shattered lives. And it surely would have meant that Rob Piest would have died in vain. John Gacy had caused misery and suffering enough to last a century. Thank God he's been stopped. John Gacy is either evil or crazy, said Mr. Mata in his opening statement. I submit that beyond a reasonable doubt, he is evil. He is vile. He is base. He is mean. He is diabolical. And he is a murderer who must be held responsible for his conscious acts. He used all of his victims, both the dead and the living victims, for his own selfish, egocentrically physical pleasures. Terry pointed at Gacy. He walked toward him. John Gacy, you are the worst of all murderers, for your victims were the young, the unassuming, the naive. Gacy, true to form, totally unable to act appropriately, laughed nervously at Sullivan. You truly are a predator, Sullivan went on. John Gacy, you have pilfered the most precious thing that parents can give, that of human life. John Gacy, you have stolen the most important thing that any person has, his very life. John Gacy, you have nipped in the bud 33 young lives, and you have deprived them of everything that this country, based on laws and justice, stands for, and guaranteed to those people their lives, their liberty, and their right to pursue their own happiness. Finally, John Gacy, you have snuffed out those lives like they were just candles. You have snuffed out the very existence of those 33 young boys forever. Those candles can't be lit again for all eternity. Terry turned back to the jury. He walked to the jury box and placed his hands on the wooden dividing railing. He peered at each juror. Ladies and gentlemen, the decision of guilt or innocence is now yours. You have the opportunity to prevent the future slaughter of other young men and boys by that sadistic animal. You saw him laugh at me. You are the only ones who can tell him loud and clear, we refuse to be used or manipulated by you, John Gacy. The snows of winter are fleeing, and the miracle of spring will soon arrive here, folks. But you can tell him that you, John Gacy, will not partake in that annual miracle. Not this time, because we find you guilty. Terry paused. He walked to the prosecution table. He picked up the stack of 8.5 by 11 pictures that the state had compiled for their gallery of grief, which they had been using throughout the trial. He had a plan for those pictures. He walked over to the empty easel, which stood in plain sight of the jury. You have, on the other hand, the chance of finding John Gacy not guilty, he said quietly. He paused again. If you find him not guilty, that is your choice. If you find him not guilty, then do so. Do so, remembering that 11 unidentified male bodies are still in the Cook County morgue. As he said this, Terry placed 11 pictures that were mere question marks, with the only known vital statistics of those victims into slots that secured them to the board. These were the unidentified victims. He then turned back to the jury. He went on, "If you do so in spite of body number 2. Medical examiner number 1065 found with a cloth-like material on his throat. Male, white, 5'9", 150 pounds. Last seen July 29th, Chicago, Illinois. Identified December 29th, 1978, as John Butkovich." Terry placed John Butkovich's picture into the slots that secured it to the board. "If you find him not guilty, do so in spite of body number 29. Medical examiner number 494, cloth-like material on throat. Male, white, 5'5", 140 pounds. Last seen April 6th, 1976 at Chicago, Illinois. Identified November 18th, 1979 as Daryl Sampson, age 18. Terry placed Daryl Sampson's picture into the slots that secured it to the board. "If you do not find him guilty, do so in spite of body number 6. Medical examiner number 1274, male, white, 5'6", 145 pounds. Last seen alive May 14th, 1976, Chicago, Illinois. Identified November 14th, 1979, Sam Stapleton, 14. Again, Terry placed the picture in the slot. "If you find him not guilty, do so in spite of sheriff's body number 7, medical examiner number 1277, cloth-like material and throat, male, white, 5'9", 145 pounds. Last seen alive May 14th, 1976, in Chicago. Identified in the spring of 1979 as Randall Reffitt, aged 15, student." Again, the picture went up. "If you find him not guilty, do so in spite of body number 18. Medical examiner number 1379, ligature around the neck, male, white, 5'7", 150 pounds. Last seen alive June 3rd, 1976 in Chicago. Identified January 6, 1979 as Michael Bonin, 17. The picture went up. "If you find John Gacy not guilty, do so in spite of sheriff's body number 23. Medical examiner number 1452, male, white, 5'6" tall, 130 pounds. Last seen alive August 6th, 1976, Chicago, Illinois. Identified December 29th, 1978 as Rick Johnston, 17, student." Picture added. "If you find John Gacy not guilty, do so in spite of body number 22. Medical examiner number 1439, cloth-like material on throat, male, white, 5'8" tall, 160 pounds. Last seen alive June 13th, 1976 in Chicago. Identified March 17th, 1979. That's William Carroll, 16. A student." William's picture went up. "If you find him not guilty, do so in spite of body number 4. Medical examiner number 1122. Male, white, 5'9", 140 pounds. Last seen August 6, 1976 in Chicago. Identified December 29, 1979 as Gregory Godzik, 17. Student." One by one, each picture went up on the gallery of grief. Terry continued, naming and describing each victim in the same manner, giving each the full respect they deserved. When finished, their picture was reverently placed with the others. John Sink, John Prestige, Matthew Bowman, Robert Gilroy, John Mowry, Russell Nolson, Robert Winch, Tommy Bowling, 20 years old, married, wife, Jolie, and son, Timmy, David Talsma, William Kindred, Timothy O'Rourke, Frank Landingen, and James Mazzara. Finally, Terry was holding one last picture. "And, ladies and gentlemen, if you find him not guilty, do so over the body number 30. Medical examiner number April 231. Paper-like material in the throat. Male. White. 5 foot 8 inches tall. 140 pounds. Last seen alive December 11th, 1978, in Des Plaines, Illinois. Identified April 9th, 1979, as Robert Piest. Student. Birthday is Sunday. Terry put Robert's picture up on the board. He addressed the jury from in front of the gallery of grief. He spoke softly at first, then his voice rose in volume. Ladies and gentlemen of the jury, we have proven John Gacy to be criminally responsible. We have proven that he has committed the crimes charged. And we have proven this beyond a reasonable doubt. Justice is the very reason we're here. They deserve justice, he pleaded, pointing at the board. That gallery of grief deserves justice. Society deserves justice. John Gacy deserves justice. Sullivan approached the easel. He pointed to each picture as he spoke. Each point was a poke that landed with a quiet thud on the board. He bellowed, "This was murder. This was murder. This was murder. This was murder. Murder, 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 murder. This was murder. So was this. Murder. This was murder. This was murder. This was murder. Murder, 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 and this was murder." Sullivan faced the jury, and in a controlled but shaking voice he said, "Justice implores you to find John Gacy guilty of murder in the worst degree. Thank you." Terry Sullivan took his seat. The air had been sucked from the room. It was like a vacuum. Not a sound, not a peep, no movement. People felt exhausted. Even the judge could only muster a quick statement. "Ladies and gentlemen, we will now recess and resume at 3 o'clock. Chapter 35. After Terry Sullivan's closing argument, Mata and I let the courtroom empty out before we stood and headed toward the doors. As we walked, I looked at Bob. He knew me. He immediately said that he was going to go get a sandwich, which was his way of saying that he was going to leave me alone to get ready. He knew that was exactly what I needed just then. I was going to have to walk back into that courtroom in an hour and a half, give my closing argument. No problem. Welcome to the private practice of law, Sam. I pushed past screaming reporters poking microphones and scribbling furiously on notepads, back to the little office that they had provided us during the trial, and shut the door. I was surrounded by boxes and files and pictures and exhibits, by chalkboards and dry erase boards and cork boards. On those boards were notes and strategies, lines and arrows, pictures and plans that had accumulated over the protracted weeks of trial. It was all a bit of a blur. I thought about the buffoonery that my client had displayed time and again during the long days and nights of the cockeyed, erratic course of this crazy trial. I thought about the insanity that I had witnessed over the past year, beginning with that night just before Christmas in my office. What a heart-stopping memory. I was preoccupied by the illness of my son, distracted by the Christmas season, pissed off about the fact that I had to waste time talking to this weirdo. But he was my client, my very first client, and I felt I had to do it. There I was, waiting patiently for this nut job, making small talk with Leroy Stevens. Then he walked into the office with all of his apologies and his bullshit. I just wanted this silly, unnecessary little meeting to be over so I could go home to my wife and kids. Then he opened his mouth. I got the chills just thinking about that night. Never in my life had I seen, or would I even have believed that there could exist, such a deranged individual. There have been few like him in all of human history. He was in a very small club, the members of which make our skin crawl. I saw the whole scene replayed in my mind, the insanity of it all. This human being, this man, my client, right in front of me, right before my eyes, pacing, grunting, sweating, spewing pure horror. I was in a small room with pure evil. I was looking at it. I had met the true life incarnation of Mr. Hyde. I knew at that moment that my life had changed forever. The Christmas season disappeared. My petty worries dissolved. I suddenly had a purpose that few men could claim. I chuckled to myself, thinking about the two sworn officers of the law, Albrecht and Hackmeister, 30 feet away behind a plate of glass, one trying to catch a quick nap on the floor of my reception area. Who would believe it? What a ride this had all been. I looked at the clock. It was almost time. I had given this closing argument to the walls of my bedroom, to the shower head in my bath, and to the windshield of my car at least 100 times. Now, it was time to give it for the jury. I walked into the courtroom and was immediately struck by the fact that the lunch break had not cured the quiet that followed Terry's closing argument. There was a perceptible hush in the overpacked gallery. I felt the eyes of everyone in the room on my back. I walked up to my partner, who looked me in the eye and simply said, "You good?" I smiled a quick, serious smile at him, sat down next to our client, leaned back in my chair, and crossed my legs. "All rise," the bailiff called. Judge Garippo swept into the room and up the steps to the bench. "Court is in session," he said as soon as he was seated. "All right, you may call the jury." The jury filed in. It was as quiet as an empty church. The judge looked at me. "You may proceed, Mr. Amarante." I stood up and approached the jury box. I had lived with this case every single day and night for 13 long months. It was in me. I had no notes in my hands. I didn't need any. What needed to be said was etched in my psyche. As I approached the lectern, I began. "May it please the court, distinguished gentlemen of the prosecution, Mr. Mata, Mr. Gacy, ladies and gentlemen of the jury." I pulled the lectern backward from where Terry Sullivan had left it. "Excuse me while I pull this back. People tell me I look too short here if I stand right up in front there." The muffled sound of its bass dragging across the carpet cut through the stillness. It was the only sound in the overpacked, standing room only courtroom. Then, when I stopped, incredible silence. The expression, "You could hear a pin drop," was created for that moment in time. I smiled a grim, serious, but still pleasant smile at the jury, taking in the faces of each and every member. "First thing I would like to do is thank you. Thank you for, first of all the time, the listening, the patience you have had with us, especially during, as Judge Garippo said, 4:30 lawyer talk and 4:30 arguments. I want to thank you for listening to that, and I want to thank you for listening to all the evidence. I also want to commend and congratulate Mr. Sullivan for giving all the people in this courtroom a fantastic and brilliant, persuasive closing argument. But I must remind you, ladies and gentlemen of the jury, that that's what that was, a closing argument. It is not evidence. That is the way Mr. Sullivan, that is the way the prosecution sees the evidence in this case." I cleared my throat a little. I felt myself settling in. I was beginning to catch my stride. I continued. "He made a number of inferences. He speculated a lot. As a matter of fact, he very rarely talked about the evidence. Think about it. Think about his argument. He told you how manipulative Mr. Gacy was. He told you how Mr. Gacy planned the insanity defense. He told you how he fakes heart attacks. Did he plan the insanity defense all the way back in Iowa when he attacked Lynch back then? Did he plan to call himself Jack Hanley for this purpose in 1980? When he told Mike Reed that his portrait on the wall was his twin brother Jack, was he planning that far ahead? But I can tell by the way you look. I could feel the tension in the courtroom in the last part of Mr. Sullivan's argument. He pointed to all the pictures. He slowly went through them. Murder, 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 murder. All that is to arouse your sympathy. And what did Mr. Mata ask you way back in the beginning of this case? Please, ladies and gentlemen, you must not, you should not, you must not consider sympathy in making your verdict. He attempted to arouse your emotions. That is manipulation. He didn't talk about the evidence. He tried to get your emotions aroused, your basic emotions, your sympathy, and your anger. I felt anger and tension in this whole courtroom. This whole courtroom. I swept my arm across the room, casting my gaze around. My assertion was verified in the eyes of many. There was anger in that room. I walked away from the lectern and never returned to it. I have been told that because of my size, when I stand behind a lectern, it looks like just a head is talking, no body attached. I began to pace, to prowl. I was in my element. He tried to get you to really hate my client. He tried to make him into an evil, vile, premeditating, rational, evil man. I thought I saw at least one of the jurors nod ever so slightly, as if to tell me she agreed with Terry. Mr. Gacy is not an evil man. He has done some evil things. He has done some incredibly horrible things. But he tries so hard. So hard from when he was a little kid. He tried so hard to be good. He tried to please his father. And he kept doing it throughout the course of his life. He kept trying and trying and trying. He became a clown. He became precinct captain. He became a good husband and a good daddy. He tried so hard to be good, but he could not be good. There was a bad side to him, an uncontrollable side. He was caged in his own flesh. He was eaten up by this raving or raging disease in his mind. He just could not control that. He just could not control that. He, I said, pointing at Terry Sullivan, talks about temporary insanity. He talks about temporary or episodic psychotic states. That's not the case here. You didn't hear the psychiatrist talk about temporary. They came up here and told you he was a sick man. He's psychotic all the time. Dr. Reifman himself told you. About the only good in this, he said, was that a psychotic person could plan. A psychotic person remembers his acting out, remembers his overt psychotic episodes like a normal person remembers a dream. Mr. Sullivan talked about Mr. Gacy's memory, how good his memory was. How many cases did he talk about? He kept going over the same 3 or 4 cases all the time. He did have a good memory, I pointed at Gacy. The man does have a good memory. His wife told you that. He is intelligent. The psychiatrist told you that. So when he can't remember the kind of details that the police were looking for, when he can't remember the kind of details that would help out, there's something wrong somewhere. He's remembering it like a dream. Think about the statements he gave to the police. He told them things as if they were coming out of a dream. Some things of the cases he remembered vividly, just like if you have a dream. Sometimes you remember it vividly, sometimes you have a dream and you only remember parts of it. Other times you have a dream and you don't remember it at all. That's exactly the way Mr. Gacy related the story to the police, to the psychiatrists, to everybody. Mr. Sullivan didn't talk about these things. All he talked about is sympathy, anger, hate Mr. Gacy, hate him, hate him, hate him, put him to death. I had to take these good people to a different place. They could still hear Terry Sullivan's murder, murder, murder tirade ringing in their ears. I had a plan, though. I would take them to a place where injustice reigned as the result of groupthink, as a result of fiery speeches, as a result of hateful rhetoric. Well, you know, back in 1692, in Salem, Massachusetts, it was July of 1692, that a lady named Sarah Good went to trial. She went to trial accused of being a witch. And when she went to trial, after the evidence was heard, and the judge's name was Nathaniel Corwin. Now, Magistrate Corwin, or Judge Corwin, sat over the evidence. Sarah Good sat at her trial, and the evidence went in. And after the jury deliberated on that evidence, they came back with a finding of not guilty. When Judge Corwin heard that, he became enraged. This was the first of the Salem witch trials. He became enraged. The courtroom became enraged. People were shouting, "Put her to death! Put her to death!" The jurors became frightened. Judge Corwin had no other choice but to send the jury back into the deliberation room. "Send them back in there." He said, "Please reconsider your verdict, ladies and gentlemen of the jury." They went back in there. They reconsidered based on all of that anger, based on all of that witch hysteria, then came back out. They did not decide that case on the evidence. They decided it on emotion. And they found that lady, Sarah Good, guilty, and they hung her 3 weeks later, and everybody was pleased. I noticed that this analogy was getting through to a couple of jury members. I could see them thinking, contemplating. This was a witch hunt after all, wasn't it? This was an emotional exercise. When all was said and done, who in that courtroom was actually listening to the evidence unaffected by the overall horrific nature of the case? The gruesome pictures of all those boys. I had to try to get the members of the jury to focus on the testimony, the evidence. I wondered, was that possible? Well, we have come a long way in this country since 1692. It is now 1980, and we don't have judges or magistrates of the caliber of Jonathan Corwin. We have fine judges, like Judge Louis Garippo. We have judges like Judge Garippo who can control and guide the attorneys through the mass of evidence that you ladies and gentlemen have to picture when you go into the deliberation room. And we also have what we call now, we would hope, impartial juries. And we selected you way back in the beginning of this case. We asked each and every one of you if you could put aside the emotion, if you could put aside your bias, your prejudice, if you could listen to all the evidence and give both the state and my client, Mr. Gacy, a fair trial. That's all we ask. And when you say that, and when you are selected as jurors, you then take an oath, and that oath swears you to the duty of being a fair and impartial juror. Now, that concept of duty and impartial jury did not develop overnight, because less than a century, or a little more than a century, after that travesty in Salem, Massachusetts, the United States government passed the Constitution of the United States. And that was in 1787. And just 4 years later, the government added to the Constitution the first 14 amendments. And those amendments are commonly referred to as the Bill of Rights. Among the first 14 amendments, we find the Fifth and Sixth Amendments. The Fifth Amendment guarantees my client, and every man in this country, whoever stands accused of a criminal act of any sort, guarantees him a fair trial, guarantees him not to have to take the stand and testify against himself. Terry Sullivan had given a very powerful closing argument. It is common during trials that after one lawyer has completed a strong, persuasive close, the jury is predisposed to his or her point of view. It is the job of the opposing attorney to remind the jurors that there are two sides to every story. I could feel that happening. I could see it in the eyes of many of the jurors seated in front of me. Not all of them, but many of them. An almost imperceptible subtle shift. At least a few of these fine men and women had decided to listen to another point of view. I walked toward where John Gacy was sitting at our defense table, pointing at him. The Sixth Amendment guarantees him the right to a fair and impartial jury, and it also guarantees him the right to be represented by counsel. Now, those two amendments have been in our laws now for over 200 years, and they have not stood up easily. It's been tough. It's been tough to keep the ideals, the American ideals, going. Now, in how many countries in the world can a man charged with 33 murders stand before a jury and get a fair trial? Not many. I'd go so far as to say this might be the only country where he can. In Iran, he probably would have been beheaded already. In many countries, he would have been strung up as soon as it happened. But here, he has an opportunity to tell his side of the story. One of your fellow citizens way back in the beginning of jury selection told His Honor, Judge Garippo, "I have a philosophy that will straighten you out. Don't judge a man unless you have walked a mile in his moccasins." And that's really what we're doing here. You have to sit back and listen to all the evidence and reach a fair and impartial decision based on the evidence. With regard to that concept of duty, I said it hasn't been easy. There have been wars. Wars with England, the Spanish War, the Civil War, the Great World Wars, Korea, Vietnam, an unpopular war. But the men and the boys, the women who were over in Vietnam, did those people who died, did the people who became maimed, did they worry that it was an unpopular cause when they were there? They might have thought about it, but they did it. And they did it out of a sense of duty. They were there. They were there fighting for the ideals. No matter how unpopular the war itself was, they were fighting for the ideals in the body of the Constitution and in the amendments to that Constitution. And I'll tell you, I never really felt that sense of duty until about 10 years ago. 10 years ago, I stood on these yellow footprints over in a place called MCRD, and you stand there shivering and shaking and scared to death, and the drill instructors are yelling in your ear, and you see a sign above you. There's a big red sign with yellow letters on it, and that sign says, "Duty to my God, duty to my country, duty to my Corps." And I'll tell you, scared as you are, you get that sense. And you feel the sense of duty that men and boys and women have felt for 200 years now. Again, it is something that has not come easy, and the duty that you have in the courtroom right now as jurors is no less serious than the duty that every Marine or every sailor or every person that ever served in the armed forces of this country ever had. It's no less serious because you are keeping the ideals of the country going. And you have to keep that sense of duty in mind all the time. That's why you have to wipe passion, wipe hatred, wipe emotion as best you can out of your minds. Because the men and the boys and the women who have died over the last 200 years, as Mr. Sullivan has said, these boys shall not have died in vain. Well, all those thousands of people shall not have died in vain either. And we're here to see that they should not. And referring to these boys, they should not have died in vain. And if you do what Mr. Sullivan wants you to do, if you use your anger, if you use your vengeance, if you take it out on John Gacy, if you bury your head in the sand, if you blind yourself to the facts, if you don't want to find out what makes this man tick, if you don't want to study him, if you don't want to prevent something like this from happening again in the future, then you will do what Mr. Sullivan asks. You will find him guilty. You either trundle him off to the side and forget about him, or you will later have him put to death and forget about him. And you never, ever will find out what makes a mind like that work, what makes it tick. Then, if you trundle him off to the side, then these boys shall have died in vain. Because the next Robert Piest, or the next Gregory Godzik, or the next boy or girl, or anybody who falls prey to a mass murderer, whether they be my children, your grandchildren, if we don't do something about it now, God help us, we can hang our heads in shame. I was pacing now, pointing at my client when appropriate, walking over to him, then pointing at Sullivan and the prosecution team when necessary. Occasionally, I would walk right up to the jury box and lean in to make a point. I wanted these selected, dedicated people in front of me to feel the passion that I felt. Killing this man was not the answer. He had to be studied, probed by the greatest minds in psychiatry and psychology in an effort to learn how to recognize a damaged mind such as his in the future. Perhaps, armed with the knowledge that could be gained from such study, a tragedy like this one could be avoided in the future. We have an opportunity here in this court. We have an opportunity to learn what this man is all about, to find out why, to find out how. I walked over to the prosecution's gallery of grief. Standing to the side of that tragic depiction of faces, I pointed to each person to whom I referred. Believe me, if vengeance, if passion, if sympathy would bring back any of those boys, if it would bring back John Butkovich or Darrell Sampson or Randall Reffert or Sam Stapleton or Michael Bonin or William Carroll or Rick Johnston or Gregory Godzik or John Sink or John Prestige or Matt Bowman or Robert Winch, Tommy Bowling, David Talsma, William Kindred, Timothy O'Rourke, Frank Landingen, James Mazzara, and Robert Piest. You see them up there. If revenge, if sympathy would bring back one of those boys. I walked the full length of the courtroom, past the faces of the jurors, past the overpacked, crammed gallery, and stopped in front of the doors in the rear of the courtroom. I grabbed the brass handle on that huge oak door. If one of them could come and walk through the back door of this courtroom right now, this minute, or if they could ever come back to life, Mr. Mata and I would join hands with you. We would join hands with you in putting Mr. Gacy to death or trundling him off to the side, if we could exchange it. But we're not here to exchange. I returned to the well of the court. As Mr. Mata told you in his opening statement, unfortunately for all of us, the fact of death is a final one. No man is an island. And we all feel it. But again, we are here to decide the case based on the evidence, based on the facts as presented to you through the testimony from that witness stand. I reminded the jury again that all of the arguments that they were hearing were just that, arguments. The lawyers were arguing, trying to persuade, but the evidence had already been heard. The arguments did not constitute evidence. Now, what about the evidence? How do you take apart a case like this? In 5 weeks, you have heard a lot of testimony. You have seen some witnesses for the prosecution that very well could have been witnesses for the defense. You have seen witnesses for the defense that very well could have been witnesses for the prosecution. You have seen a lot of doctors. You have seen psychologists, psychiatrists, all kinds of people. How do you take the evidence apart? Well, the way I have done it is, I have divided the case in 7 parts. I began to take the jury through the evidence in an organized, systematic way. Step by step, we would begin to look at the case together. We would review the testimony regarding the following: death witnesses, police investigation, confessions, medical examiners, family and friends, modus operandi, and the psychologists and psychiatrists. Life and death witnesses are called to elicit evidence that a victim lived and then died. The testimony is normally limited to dry statements in support of that premise. However, over our repeated objections, the prosecution used this opportunity to tug relentlessly at the heartstrings of the jurors. These witnesses were primarily the relatives and friends of the various deceased boys, a very tough part of the case. These were mothers, fathers, brothers and sisters, friends, and relatives in the throes of indefinable grief. There is nothing harder than listening to the grieving relatives of the departed in any situation, but it is excruciating beyond description when the departed are the young victims of indefensible foul play. Now, the first part, the life and death witnesses, well, you know that the state started this case the same way they ended it. Sympathy, passion, prejudice, hate Mr. Gacy. There are 22 identified victims. 22. They put more than 22 life and death witnesses on that stand. A life and death witness is put on the stand for the purpose of telling you, of putting into evidence that somebody lived and somebody died. That's the purpose. Do you think that was their purpose? No. Their purpose was to make you cry. Their purpose was to arouse your sympathy. That's what their purpose was. You think it's easy to sit here and watch mothers cry up there? It's just as hard for us as it is for you. Nobody likes to see it. Do you think it's easy to see friends and family crying up there? It's not easy. But it's not evidence. An example is, at that moment, Judge Garippo stopped me. If I can interrupt 1 minute, we'll take a brief recess. I wish I could tell you that the interruption was for something profound. However, the judge just wanted to give everyone a pee break, including himself, I'm guessing. I suppose he had come to know me over the last 6 weeks, and he figured that I'd be up there for a while. May I proceed? I asked after we had reconvened. Yes, said the judge. Okay, I believe I left off where I was talking about the beginning of the state's case, the life and death witnesses. They put more than 22 on there, and I was going to give you an example of the way in which the state attempts to arouse your sympathy without going into the facts. First, let's look at Mary Jo Paulus. Remember her? A little girl with a brace on her neck. This girl was straight from the hospital. No pain medication. Mr. Mata asked her about it. She said, "No, I didn't take any medication." In pain. She sat up there. In pain. Mr. Mata also asked her, "Were you the last person to see William Kindred alive?" She says, "No. A guy named Weedle saw him last." Where was Weedle? How come Weedle didn't come in here and testify? Did he get in an automobile accident too? Or was it better to see this poor girl suffering, in pain, so your hearts could go out to her? What about Donita Gannon? Remember Donita Gannon? That's the little Asian registered nurse. Now you think the state came out and told you that Miss Gannon was really Mr. Ganzon? Oh no. No. They left that up to the defense. Let the defense lawyer be the bad guy. We'll put this poor little girl up there, say she's a registered nurse, talk about how much she misses Timothy O'Rourke, but don't say anything else. So then, we have to get up there and expose this poor person to the whole world. Why do we have to do that? Why did we have to look like the bad guys? Because we are concerned with the facts. The facts, the evidence. Talking about Miss Gannon, now here's a person who actually is having a sex change operation. She shouldn't have any fear, any worry, or anxiety about people thinking anything about her. Maybe she was intended to be that way. She was intended to be a female. So she's having a sex change operation. That's what she wants to do? Fine. But she should not have to be afraid of it. She should not have to not want to say it on the stand there. Another person, Roger Saz. I asked him, where did you meet the person you dropped off at Bughouse Square? Did you meet him in a gay bar? Wouldn't admit that. Wouldn't admit he met him in a gay bar. These are examples of the way people feel about homosexuals. Now this girl, Miss Gannon, I guess you can say, is a blatant homosexual or whatever, transvestite, whatever you want to call it. Objection, Judge. It was Kunkel. The judge never bothered to respond or rule. I elicited the exact reaction out of Kunkel that I wanted, the visceral reaction that still existed at the time in opposition to the very mention of gay or transsexual persons. I let that reaction hang in the air for a beat. Then I continued. Well, whatever it is, you could imagine the torment, the torture that goes on in the mind of a man like John Gacy. A man whose father was a real man, his mother said. A man whose father was a good provider, a tough man. John Gacy wanted to be like his dad. John Gacy slowly found himself going more and more and more the other way. He did not want to. He hated the whole idea of homosexuality. He hated himself for being a homosexual. And he still does. He still does. As Dr. Reifman said, he is a homosexual, but he won't admit that to himself. Why? Because he does not want to. The torture, the pain. In the voir dire, a few of you indicated that you were repulsed by the idea of homosexual conduct. Picture yourself. Use your common sense. What if you suddenly found yourself going the other way, becoming a homosexual? Becoming a homosexual, becoming something that repulses you, something that you do not want. Think about the confusion of identity. Think about the inner conflict you have. That's what the doctors were talking about up there. And I want you to keep that in mind. Keep in mind the evidence. Think in your mind the kind of person John Gacy was. A construction worker. A guy who wanted to make his marriage succeed. A good daddy. Yet he caught himself going farther and farther the other way. Mr. Sullivan said it's by choice. In May of 1975, he cut off his wife. He said no more. Then, why was it later on he buried his head in her lap when he could not have sexual relations with her? He cried, and he said, I'm afraid I have gone the other way completely. He did not want that. It was a horrible, horrible thing for him. The conflict that raged internally in this sad specimen of a human being, our client, had to be brought home to this jury. Gacy was the poster boy for the argument that homosexuality is not a choice. He was raised by a rough, tough, hard-to-deal-with tool-and-die man, a man's man, a guy who hated homosexuals, the classic homophobic. Gacy was raised to do the same, to be the same. When John Gacy acted in any other way, if he cried or played with the dolls or girls, his father called him a sissy, a fruit picker. He was teased relentlessly, often shunned entirely. This by the one man from whom Gacy most wanted acceptance and love. Gacy fought desperately against this predisposition toward homosexuality with every fiber of his being, and lost that battle. This conflict was basic to his psychosis, to his derangement. I hope the jury understood this essential fact. I wasn't getting a lot of confirmation in the faces that I saw in front of me. I plodded on. Anyway, beyond those types of witnesses, there were some other interesting facts brought out by the life and death witnesses about John Gacy. Mr. Marko Butkovich said, "Well, when I met John Gacy, when I talked to him, he seemed like a good man. A good man. He didn't say he was evil. He seemed like a good man." Mr. Butkovich also begged and pleaded with the police to investigate John Gacy. "My son worked for him. Find out, please, find out for me," he pleaded. Did the police do anything for him? No. Had they done something, we would not be here today. But they did not want to investigate John Gacy. Gregory Godzik's sister said that John Gacy used to make my brother laugh. Her brother enjoyed working for John Gacy. And then Gregory Godzik's girlfriend said, John Gacy said he was in the syndicate. This is way back when. Was John Gacy planning the insanity defense? Was John Gacy planning and having these ideas and feelings of grandeur, or, as the doctors called it, grandiosity? Was he in the syndicate? Of course, John Gacy was not in the syndicate. I wondered if these fine men and women could see how crazy that was, how telling. Gacy was a pudgy, sickly cream puff that desperately needed acceptance. Did they see that? I took in their faces one at a time. I searched. I wished that for just 1 second I could read minds. After the life and death witnesses, we go into the police investigation. And the police investigation starts off with Officer Pickle, I believe, and Lieutenant Kozenzak. And there was a man named Kirkpatrick from Kirk's Towing in LaGrange, and another officer named Loconsole. And it started with Pickle and Kozenzak going over. After we see in the reports on the missing boy, Robert Piest, they went over to John Gacy's house after hearing that he had been at Nissan Pharmacy. I described in some detail the events that occurred the night Kozenzak and Pickle visited Gacy's house the very first time, while young Rob Piest's body was hidden in the attic. It was impossible, in my view, to interpret this any other way. Our client was insane. Think about it. His house was a ghoulish, gruesome, illegal morgue, and he was inviting the cops in for a chat. Then, as Lieutenant Kozenzak and Officer Pickle are walking out the door, he gets a dislike for Kozenzak. And the reason he got a dislike for Kozenzak, which he carried on all the way through his statements, he did not like Kozenzak, and that was because he said Kozenzak did not show any respect for his uncle who died. He's sitting there with 29 bodies, 30 bodies in that house with no emotion, but yet he's worried that Kozenzak did not show any respect for his uncle. Is that the act of a sane man? Of a normal man? Does a rational man let the police into his house with all those bodies? He may have appeared rational on the outside to his neighbors. A rational man would not do that. An intelligent, rational man would not do that. Then he got stuck. Well, apparently. He said that he took the body of the Piest boy out to the Des Plaines River, and again, by the way, that was supposed to be the 5th body he threw in that river, all in the same place. Patterned, obsessive-compulsive pattern. The crawl space is full. I'll have to find another space. Pattern. That's not plan. Pattern is not plan. Pattern is sick, and the pattern was sick. And it was based on an obsession. Why at the same point? Why did he drop them off at that same point? He rode out there, and on the way back, this alert, awake man goes off the road. He gets stuck in a ditch. What did he look like at that time? Kirkpatrick couldn't even recognize him in the courtroom. He's looking around, looking around. He looked at me for a little while, and finally he said, I'm sorry, I cannot positively identify him. Why not? Well, he looked different that night. He looked different. When I went up to the car, he was slumped over at the wheel. He was groggy. He looked like he had been under the influence of something. Time and time again, people had seen and then later testified to the transformation that took place in John Gacy. 1 minute John was congenial, with an ear-to-ear smile that would light a room. The next minute, he would turn dark-hearted, evil, scary. Rob Piest had seen this transformation just before he died. Stevens and I saw it that night in my office when John confessed his dastardly deeds. The flutter in the eyes, the apparent switch from Jekyll to Hyde that made John Gacy unrecognizable, that turned him into a different person. When asked on redirect examination, well, was he under the influence? Was he drinking? He said, "I didn't smell anything." Why did he look so groggy? Why did he look like he was under the influence? Beats me. I don't think the state has the answer, but he certainly did look different. And that's when he disposed of that body of Robert Piest. Now, he was supposed to have gone on to the police station at 11 o'clock. He disposes of the body of Robert Piest, and on the way back, he gets stuck. And as soon as he gets pulled out, he remembers, "I had an appointment with Lieutenant Kozenzak. I better get to the Des Plaines police station." Rational? Walking into the Des Plaines police station at 3 o'clock in the morning, covered with mud, when you are under the investigation of a missing boy? You are under suspicion for kidnapping and possibly murder. Do you do that? Do you walk in a police station at 3 o'clock in the morning and say, "I'm here. I'm going to talk to you"? That is not the act of a rational man, as Mr. Sullivan would have you believe. If anything, it's that act of a man who wants to get caught. A man who is reaching out saying, "Stop me before I kill again." It's a man who wanted to be stopped but could not control himself to stop himself. He was reaching out at that point. Sure, he was caught in a web. Mr. Sullivan said he was in a web. He wasn't in any police web. He was in his own web. He was tangled in that web of his mind, encased in his flesh for so many years, and the killing had to stop. It became more and more frequent all the time. The reason it had to stop was because, by his own statement, John Gacy said Robert Piest was different. He did not fit the mold. He did not fit the pattern. He wasn't picked up in Bughouse Square. He wasn't picked up on Clark Street somewhere. He was snatched out of a drugstore where he worked. He's a boy who John Gacy never saw before. You tell me that's planned? You tell me that's premeditation? That he went there purposely to get Robert Piest? He didn't even know his name. That is the drive of a madman, a driven man, driven by perverted obsessions and compulsions, by perverted obsessions and compulsions that he could not control. Why Robert Piest? So, it went on. He was sent home from the police station at 3 o'clock in the morning. He then returned at 11:40 the next day. Again now, this is a man under suspicion of kidnapping. He voluntarily goes into the police station and says, "I'll give you the statement now." He talks to Officer Pickle again, gives him a statement exactly the way Officer Pickle wanted him to do it. He not only gave the statement, but I'll show you the exhibit. I don't know which one it is. He signed his name in the wrong place. I found the exhibit and showed it to the jury. In the statement he gave, the first statement, he said he could account for just about every minute of his time. Maybe he was lying. Maybe he was lying at that time. He signed his name in the wrong place, and he also signed PDM Contractors. You tell me why. For what purpose the man would sign his name and put PDM Contractors? When you sign your name to something, do you put the name of your job or your company below your name? It makes no sense. In addition to doing that, Officer Pickle said, "Well, Mr. Gacy, write in here that you used to hire young people for summer help. Mr. Gacy said, fine. I used to hire young people for summer help, and signs his name again. Again, this is a man under suspicion for kidnapping. He's in there cooperating. He stays in there. While he's in there, Lieutenant Kozenzak has a warrant to issue. When a warrant is issued, they say, John, we're going to go over to your house. Could we have your keys? Fine. Take my keys. Go to the house. He stays at the station. He's not under arrest. Maybe he was being detained, but he did not have to give them the keys. But he did voluntarily give them the keys to his house, that house where those bodies were. Is that the act of a rational man? Is that the act of a professional or intelligent criminal? Go look at my house, see what you find. He was calm and cooperative. He wasn't at all nervous, and he bragged. He bragged about his connections. He bragged about his running the National Polish Day Parade in Washington. He bragged he was a precinct captain. He bragged about this and he bragged about that. Why brag? What does that show? Anyway, after that initial search, certain things were found in his house. Lieutenant Kozenzak ordered surveillance. He put Officer Hackmeister and he put Detective Schultz on the surveillance. Now the man is being tailed. He's being tailed. They are watching him constantly. Does he run? Does this evil man run? No. He enjoys the tail. He plays games with them. He plays hide and seek. But does he try to leave the jurisdiction? Oh no. Here guys, I might lose you because I'm a fast driver, so here's where I'm going. I'm going to tell you where I am going. Meet me there. He became friendly with them, and he invited them in his house. He cooked for them. He gave them a tour of his house. He showed them photo albums. One of the officers' cars was broken down, and when the car broke down, you think he kept going? Do you think he ran? No way. He stopped his car. He went back and gave the officer a ride. He gave him a ride and put him in his car and said, "Come on, I'll take you along with me." He offered to take a polygraph. As a matter of fact, there was testimony that when they were on the elevated train, on the L, going downtown, his lawyer at that time, Leroy Stevens, told him, "Leave the country." Did he do that? No. When they went to look for him at the airport, was he at the airport? No. He was at a Christmas tree lot, 2 blocks away from his house. Is that the act of a man who is running scared? Is that the act of a man who is tied up in a web, in a police web? No. Those are the acts of an irrational man, or a man who wants to get caught. He was speeding. 60, 70 miles an hour down side streets, erratic driving. They had to tell him to slow down. Did he want to get taken into custody? He introduced them as his bodyguards. He told them he had a bodyguard with a .357 Magnum that would not hesitate to waste them. They never saw a bodyguard. They never saw anybody with a .357 Magnum. He told them that other people were following him. He said they must have others working with them because he thought he saw somebody following him. The detective said nobody else was following him. Only we were following him. He felt the cars were bugged. He told them that he worked hand in hand with Mayor Daley running the city of Chicago. He joked. He laughed. They said he didn't have a harsh word to them. He just went right along with their surveillance. Did he want to stop the killing? Did he want to get arrested? He drove fast and erratic. He told them he couldn't look at clowns as people. Guys, because clowns could get away with murder. Now this is a man under suspicion of murder. He's under suspicion of kidnapping, and that's what he told them. He passed the morning he got arrested. He pulled into the gas station and passed marijuana cigarettes into some kid's pocket in the gas station right in front of the policeman. Then he tried to take off. He left the gas station. Did he keep going? No way. He came right back. He came right back into the station and says, "Come on, Dave, let's get going." He wanted to get arrested. And they gave no indication, even up to that time, with the marijuana, with the speeding, and with everything. They never gave any indication of arresting him. Now, when he did get arrested, he went on that morning and finally got arrested. They took him to the station, and he was there all day. And Mr. Sullivan says he got one of his famous heart attacks, implying he got a fake heart attack. This man had a whole history of fainting, of heart attacks. No medical basis, no physical basis, but that was the history. He had this throughout his whole life when he was a child. Mr. Sullivan calls it a fake heart attack. On the way back from the hospital, after he had his seizure or collapse, whatever it was. He then confesses, now he has lawyers. His lawyers aren't there at that time. He went to the hospital and voluntarily says, "I want to clear the air. I want to clear the air. I want to talk to you." Finally, he was there. He finally talked. He got arrested. The killing could finally stop. And how did he talk? He gave a very rambling, disjointed statement. They only asked him 1 or 2 questions. This was at 3:30. The first thing he told them was, he told Officer Albrecht that he was not a homosexual, and he had a strong fear of being a homosexual. He said, a man is a man, and he should stay that way. There's something wrong with a man if he's gay. Then he said, Jack does not like homosexuality. Well, the state says he planned this multiple personality thing. Jack, whatever Jack is, we know it's not a multiple personality, but it's something for him to get rid of that guilt. How could a man live in a house with all those bodies, all those years, with all that on his mind, if he does not have some mechanism, some relief mechanism? So he blames another part of himself. He blames a guy named Jack. They tried to make you think James Hanley up there was Jack Hanley. His name was James Hanley. He talked about Jack first to Mickle Reed in 1970, before he ever met or before James Hanley ever saw him, or John ever saw James Hanley, if he ever did. He told them at that time that he never forced sex upon anybody. It was always consensual, and he had a heart condition. He told them at that time that he slept with the Piest boy after he was dead. He told them that he did not even know Piest's name, and he told them they were all strangled. And I want you to keep that in mind. When I talk about the medical examiner later, he said they were all strangled. He said he put a rope around Piest's neck, and while he did that, he went and answered the phone. No feeling. No emotion. That's what the doctors are talking about. Lack of affect. Did you see what he did when Mr. Sullivan was calling him a murderer, murderer, murderer? He was laughing. Laughing. Put yourself in that chair over there. Somebody calling you a murderer. Somebody asking the jury to find you guilty of this crime. Are you going to laugh? That is what they talk about when they say lack of appropriate affect or lack of appropriate feeling. He said they killed themselves. And he wasn't blaming Jack. He was blaming the victims. He said they killed themselves because they sold their bodies for $20. He said he used a rope on every single one of them. Again, remember, when I go into the medical examiner, he said all of the killings were related to homosexuality. He said he lost count of the bodies, that the crawl space was full. He said he did not like Kozenzak because he did not have any respect that his uncle had died. And then again, at 3:30, as I indicated, he went into another rambling, a long, disjointed statement with only 1 or 2 questions. He did not like homos. He was afraid he was becoming one. He denied any encounter with Jeffrey Rignall. He said Rignall. Then he went on to tell them that when he went to court on the Jeffrey Rignall matter, Rignall was the guy who did not show up in court. Actually, Rignall testified John Gacy was the one that did not show up in court. Twisting things backwards, talking in opposites. His statement is a good example of tangential speech. He went from here to there, changing the subject back to something else again. Officer Badeau described it as Mr. Gacy skipped a lot back and forth. He freely gave his statement. There was a definite pattern involved. Now, not planned, but pattern. He could remember who many of the victims were. He rambled, skipped, went back in years, then back to the present again. And then he told them that Piest might have been dead when he was in the attic. He said he wasn't even sure if he was dead. At the house later in the morning, when he was taking them to show where the bodies were, a man who was arrested, now the man who was trapped, as Mr. Sullivan would have you believe, in his own web, takes the police to show them where Butkovich is, where he is buried. On the way there, he goes in the garage. He wants to know why his garage is so messed up. He starts closing cabinets, straightening out drawers, picking things up. He wants to know how come there's mud on his floor. Officer Pickle had to remind him 3 times why he was there. The compulsiveness of his behavior. He gave statements compulsively. He's compulsively cleaning, compulsively taking care of things all the time, nitpicking, little things. He's doing it right when he's arrested, right when he's showing where the body is. Later on that day, he called Larry Finder into his cell. He said he wanted to talk to Larry. "You have never done anything to hurt me." And he read the Miranda rights again. This is a man who has just been arrested for murder. He told him that he felt relieved, but he was unhappy. But he did feel relieved. He said he accidentally left his book at Nissan Pharmacy, and had he not left his book, he never would have killed Piest. Is that a rational, premeditated, planned act? Is that the act of a man who is planning something? He left the book somewhere. He goes back to get it, and he kills somebody. That is not premeditated. That is not planned. A week later, at Cermak, he gave the other statements. Again, Mr. Sullivan talked about memory. He remembered that. What did he remember? In all of those statements, what did he remember? He remembered Robert Piest. He remembered something about Sink, how he spelled his name. He remembered something about Gregory Godzik. He remembered the first name of Rick Johnston. That was about it. That he was from Bensonville. And he remembered one other thing about somebody. Now, Mr. Sullivan went over and over and over the rope trick and the Piest thing, over and over again. There's 33 of them. How many did he go into? He only went into a few. Again, as I told you in the beginning, a psychotic state. Either somebody remembers everything or nothing at all. That's how he told what happened, just like he was dreaming about it. Okay. Then we had the part of the case, the part of the police investigation that involved the excavating of the property. Now, the state would have you believe that the excavation, or that the burial was planned, was organized. He had holes dug down there, and they bring out these maps, and they show you, look at how nice and neat everything is. All right, down here, it looks nice and neat. It's not the way those bodies were buried. That's the way they were taken out. They were buried, the first one being buried under the cement, then out to the garage, then into the dining room, going like this, garage, dining room, and then the third one in the dining room, and the fourth and fifth over here. The sixth was way down over here, and the seventh was way back over in this corner, and so on and so forth. As Dr. Morrison said, John Gacy has somewhat normal intellectual capability, but he probably has the emotions of a baby. Somewhere, something stopped. Now why? How? Somewhere, something went wrong. Look at his medical history. His medical history that Mr. Sullivan said was average. This medical history that was totally discarded by Dr. Leonard Heston in Anamosa 12 years ago. His medical history that was totally discarded by Dr. Kavanaugh and Dr. Reifman as being average. You know it's lengthy. You know a lot of things happened to him with no physical basis. Some of the things, as indicated by Dr. Morrison, were, in 1958, he fainted. He had shortness of breath. There was a request for psychiatric consultation. In 1959, in the hospital, he was found on the floor. He was complaining of a headache. He appeared to be disoriented and confused about what happened and why he did it. He was laughing to himself, and he would not answer questions relating to any accident in the hospital. He was discharged against medical advice. Again, in 1959, he had fainting and dizziness, difficulty breathing, and a sensation of being choked. He had hysterical blackouts. In the nurse's notes in 1959, they said, "He had an acute convulsive episode last night with loss of consciousness and violent thrashing about. But later, he was talking normally." He was acting normal, and suddenly he developed extreme restlessness after complaining of chest pains. And then, he became impossible to handle. And he went berserk again yesterday, and he had to be restrained. In 1963, he had a seizure. He shouted and struggled. He gave strong resistance to ambulance personnel. He had no memory of events until after his admission in the hospital, and on, and on, and on, and on. That is an insignificant, average medical history? It goes on like that. What did his friends and business associates say about him? You saw Rich Dolke, who said from even when he was a kid, he was friendly. You saw Ken Dunkel, friendly, easygoing, happy-go-lucky person, a sincere and warm person as he grew up. The only time they ever saw him get violent was when he had these fits or seizures, whatever they were. Otherwise, he was fine. He was nonviolent. They used to have to protect him. They thought he was a sickly boy. It was Rich Dolke who said he used to protect John because he thought he was sickly. Nothing was wrong with him physically. His cellmate, the person he knew at Anamosa, said Gacy was a cream puff, but he was a leader. And he always thought Gacy always gave the impression that any time anyone wanted to fight with him, what he would do is he'd have one of his, as Mr. Sullivan calls them, famous heart attacks. They weren't faked. He would get ashen gray. He would pass out. He'd have shortness of breath. He wasn't faking it. It was something that was happening with his mind even back then and throughout his life. It's like Dr. Morrison used the example of your palm sweating or the heart palpitating. You don't tell your palms to sweat. You know they are doing it. You don't tell your heart to palpitate, but you know it's happening. These are things that are caused by some kind of emotional stress. The other day I was sitting here, and I had a little red blotch on my cheek. And it was there, and I knew it was there. And I kept trying to hide it like this, or sitting over by the table. It was like a blotch with a white spot, a hive. I kept trying to hide it. My instinct was, I knew it was there. I knew I had no control over it, and my instinct was to hide it. I continued, pointing out the crazy person that was my client, painting a picture, asking the questions, reminding the members of the jury that this guy was crazy long before he ever killed anyone. He had left the rails as a little boy, developed fetishes, developed defense mechanisms, passed out for unexplained reasons, was in and out of hospitals. The life of a one-day serial killer. Why not study a guy like this? We study everything from insects to elephants. Why don't we study these guys? Maybe they are savable. Maybe their victims are savable. We study microscopic organisms that can kill us. Why don't we study people that can kill us? Instead, we continue to act like we did when we were carrying spears or when we were carrying pitchforks and torches. We haven't changed a bit. Kill the bad guy. Don't try to figure out why he is a bad guy. Just kill him. Emotion is a powerful thing, isn't it? Funny though, if you ask anyone, anywhere, they will tell you the same thing. No one acts rationally when they act upon their emotions. I spoke for hours. I tried to cover everything. I was fighting for a man's life. Finally, I said, "Now, bear with me. I will be done in just a few minutes. Go back to 1886, right around the time of that thing they were talking about, dementia praecox, paranoid schizophrenia. Well, in 1886, an author by the name of Robert Louis Stevenson wrote a novel. You can still read it today. I am going to read you some excerpts from that novel. While I am doing that, I am also going to quote some of the testimony in this case. I'd like you to see the similarities. I am sure that you will recognize the novel when I start reading it." I walked over to our defense table and picked up Stevenson's timeless novel. I had previously marked certain passages. I moved away from the table slightly, but stayed close by. I had other items that I needed on the table. I was farther away from the jury, so I raised my voice a bit. I read directly from the book in my hands. "All at once, I saw two figures. One, a little man who was stumping along eastward at a good walk, and the other a girl of maybe 8 or 10 who was running, as hard as she was able, down a cross street. Well, sir, the two ran into one another naturally enough at the corner. And then came the horrible part of the thing. For the man trampled calmly over the child's body and left her screaming on the ground. It sounds nothing to hear, but it was hellish to see. It wasn't like a man. It was like some damned juggernaut. It was a man of the name of Hyde. What sort of a man is he to see? He is not easy to describe. There is something wrong with his appearance. Something displeasing, something downright detestable. I never saw a man I so disliked, and yet I scarce know why. He must be deformed somewhere. He gives a strong feeling of deformity, although I couldn't specify the point. He's an extraordinary-looking man, and yet I really can name nothing out of the way. No, sir, I can make no hand of it. I can't describe him. And it's not want of memory, for I declare I can see him this moment." I looked up from the book and let the passage linger in the air. I looked at each member of the jury while I did this. I set the book down on the table and picked up a transcript of testimony previously given in our case. "And then you remember the testimony of Jeffrey Rignall," I continued. "Nothing ever showed on that guy's face. He just went around torturing me like it was something that happened every day. My assailant was an oddity, a person so evil, so vile, so malicious, and cruel that he was almost inhuman." Now the novel goes on. There is something more. If I could find a name for it, God bless me, the man seems hardly human. Back to Rignall. It was another case of somebody wanting control of another person who loathed himself for having those desires. His sexual desires must have been so disgusting, he had to punish that stranger, the other person involved in the act. He himself detested, a way of purging the demons from one's soul. punishing someone for the crime you yourself were committing. He was incapable of registering the same kind of emotion as other people. Back to Hyde. This Master Hyde, if he were studied, must have secrets of his own. Black secrets, by the look of him. Secrets compared to which poor Jekyll's worst would be like sunshine. In describing his Jekyll, the other part of Hyde, a large, well-made, smooth-faced man of 50, with something of a stylish cast, perhaps, but with every mark of capacity and kindness. You could see by his looks that he cherished, for Mr. Utterson, a sincere and warm affection. He became once more their familiar guest and entertainer, and whilst he had always been known for charities, he was now no less distinguished for religion. He was busy. He was much in the open air. He did good. His face seemed to open and brighten, as if with an inward consciousness of service. And, for more than 2 months, Dr. Jekyll as at peace. He writes of himself, "If I am the chief of sinners, I am the chief of sufferers also. Both sides of me were in dead earnest. I have been doomed to such a dreadful shipwreck that man is not truly one but truly two. I say two, because the state of my own knowledge does not pass beyond that point. I saw that of the two natures that contended in the field of my consciousness, even if I could rightly be said to be either, it was only because I was radically both. Hence, although I had now 2 characters as well as 2 appearances, one was wholly evil, and the other was still the old Henry Jekyll, that incongruous compound of whose reformation and improvement I have already learned to despair. The movement was thus wholly toward the worse. Henry Jekyll stood at times aghast before the acts of Howard Hyde. It goes on and on and on. I am sure you know the story, the Jekyll and Hyde story, the words that were used so often in John Gacy's house as a child. You heard how Geoffrey Rignall described him. You heard how Lynch described him. You heard how Cram described him when he was attacking Cram. You heard how Donnelly described him. You heard what McKell Reed said about the hammer, the strange look in his eyes, the bizarre behavior. The man who lived with bodies underneath him. Here is what his friends and neighbors, his family, said. John Gacy was a very nice person. He was jovial, kind, genuinely happy. He enjoyed people. He was always busy. He was a good daddy. He seemed to show deep and sincere affection. He was generous. He was not selfish. When he would smile, his smile would light up his whole face. He was not a vile, evil person. His house was open to people all the time. He engaged in charitable activities. He was warm and considerate. He was a good man, a nice man, a friend. I can't fathom that the John Gacy I knew would have done what he's accused of. But his hours were irregular, and his wife, his ex-wife, said, "And now I feel sorry for him." And Rignall said of him, again, at another time, his voice was demanding and demeaning. It was not like a common person talking back and forth, but his voice was like a giggly type thing. Gentleman. And then he became totally violent. And again, when Jeff Rignall was asked, "What is your opinion?" he said, "My opinion is that at the time John Gacy could not conform his conduct to the requirements of the law because he was so beastly and animalistic." That is the same John Gacy, supposedly, that his neighbors and family and friends talked about. My opinion is that John Gacy could not appreciate the criminality of his acts because of the way he attacked me, the beastly manner that he did it. McKell Reed said that when he hit him over the head with that hammer, he had a strange look in his eye. He could feel the tension. He changed. He was out of character, and he did not know what he was doing. John Gacy is truly a Jekyll and Hyde. Despite what psychiatric terms you put on it, despite what labels you put on it, he is the personification of this novel, which was written in 1886. He was so good, and he was so bad. And the bad side of him is the personification of evil. I'd agree with the state that he is evil. Now, whether it is premeditated, planned, and so forth, I don't know. Killing 33 people is bad. It is evil. The man is insanely evil. He did not want to do it. He could not control himself. What do? Do you hold him responsible for that? Or do you take the first step of having him studied to at least try to prevent something like this from happening again in the future? My God, take that first step, ladies and gentlemen of the jury. Do it. Mr. Mata and I have tried to present you with an open, straightforward case. We put Rignall on. We put Reed on. We put his family on. We tried to tell you what John Gacy was all about. We also put his friends on. We put 4 independently retained psychiatrists and psychologists on the stand. We wanted to show you the different sides of John Gacy. We wanted to show you that he was acting under constant, raging mental illness. We wanted to show you that this man should be studied. The most frightening, the most horrible kind of mental illness, the kind of thing you would not recognize. The fact that John Gacy, 2 years ago, could have been your neighbor. He could have been your friend. He could have been on this jury. He could have been the foreman of this jury. It isn't that. That alone. Isn't that, if you use your common sense, enough indication, enough motive to have this man studied? Bob Egan ended his opening statement with the words, "God help all of us if another man like John Gacy walks among us." Well, if you don't want to find out, if you don't want to have him studied, if you don't want to learn why, God help all of us, because there probably is going to be more John Gacys walking among us. Putting him away won't prevent anything. Punishment won't deter a madman. The next mass murderer out there, do you think that John Gacy setting an example with John Gacy would help? It wouldn't deter him. It didn't deter John Gacy. He couldn't control his conduct. He couldn't control his evil conduct, just like Jekyll could not control Hyde. And eventually, Hyde took over. Jekyll lost it more and more and more, and then eventually, the evil side of Jekyll's personality took over beyond the control of the good side. Beyond the control of the good side. I stole a glance at the clock. It was time to finish up. I took a quick second or two as I silently reviewed what I had said. Had I left anything out? One final item came to mind. By the way, Mr. Sullivan mentioned that our doctor testified that John Gacy was unconscious. They never said he was unconscious. We said he was reacting to unconscious stimuli. He was awake. He was walking around. He wasn't unconscious. His drive was in his unconscious. He is a danger to himself. He definitely is a danger to others. Remember, he began serving that 10-year sentence December 11th, 1968, and he ended it on December 11th, 1978. Do the right thing, ladies and gentlemen of the jury. Don't decide this case with hate, with revenge, with passion and fear. Commit yourselves to our laws. Perform your duty well as jurors. Look at all the evidence, and when you look at the whole picture, you will find that the state has not met their burden of proving Mr. Gacy sane beyond a reasonable doubt. We expect you to return a verdict of not guilty by reason of insanity. On behalf of Mr. Mata and Mr. Gacy and myself, I would like to thank you again for being such an attentive jury. I would indicate that our work is now on the verge of being over, and your work is just beginning. Thank you, ladies and gentlemen. I turned and walked quietly to our table. The only sound in the room was the muffled sound of my footsteps on the carpeting. I realized that we were done. No more evidence, no more arguments. The case was coming to a close. Memories of the previous 15 long months cascaded and crashed into one another like in a dream. The courtroom was a blur. Faces were unidentifiable. Adrenaline still coursed through me. My heart thumped. For me, it was over. As I sat down, Judge Garippo's voice resonated and reverberated throughout the room, snapping me back from my rushing memories, back to reality. Ladies and gentlemen, this concludes the arguments that you will hear tonight. The schedule of the events would be that tomorrow the state will have the opportunity to give a rebuttal argument. After the rebuttal argument, I will instruct you as to the law, and then you will begin your deliberations. Again, as each day goes by, it becomes easier and the temptation is deeper to begin making judgments in your own mind about the believability of witnesses as to what your verdict will be. It would not be fair to either side to do this at this time. Because you have not at this time heard all of the arguments, and you haven't formally been instructed as to the law. Further, I just want to correct one thing, a mistake that I made during the course of Mr. Amarante's argument. I sustained an objection relative to testimony of Dr. Kavanaugh relating to suicide. I sustained the objection of the state, and I erroneously sustained that objection. There was testimony relative to that subject. You have heard the evidence, and you are the judges of the evidence. We will resume tomorrow at 10 o'clock. Please do not discuss this case in any way. Thank you. Chapter 36. Bill Kunkel stood well over 6 feet tall, and his bathroom scale bumped up against 250 pounds when he stood on it, maybe even a little more. In summer, when it was warm enough, he arrived to work on a big old Harley-Davidson, with chrome gleaming and the deafening blast from hot pipes reverberating against the Chicago skyline. It's a hog on which any denim-jacketed Hell's Angel would ride his colors proud. He considered himself his own man, and the deep, stern creases etched by time into his bulbous, ruddy face dared anyone on the planet to say otherwise. A serious man. One only needed to be in his presence for a very short time to learn his personal views on a myriad of subjects. Strongly held opinions that he would share without much provocation. He was an imposing figure, not a man who fit the cookie-cutter image of what a prosecutor looks like. Nonetheless, it was Kunkel that had been chosen by the other members of the prosecution team to present the final word on behalf of the state of Illinois regarding the matter of People versus John Wayne Gacy. At 10 a.m. on Wednesday, March 12, 1980, as the players reconvened and the onlookers assembled themselves into the limited seating and the standing room only spots, filling every square inch of available space, the cramped courtroom looked noticeably more cluttered than it usually did because of the addition of the huge, irregular chunk of hardwood flooring, which included the gaping trapdoor that once peered down into the crawlspace at John Wayne Gacy's house. It had been dragged to a point of prominence before the bench and in full view of the jury box, as had the infamous gallery of grief. It, too, had been hauled to a place where all jurors could clearly see each and every identified victim's picture. Kunkel ambled up to the podium, like the original John Wayne, the Duke, quietly cleared his throat, and began. Judge Garippo. Gentlemen, he said with a nearly imperceptible nod to Bob and me. Ladies and gentlemen of the jury, I'll be the last one to speak to you before you get your instructions on the law from the judge and retire to the jury room to deliberate this case. I'll make you only 2 promises about my remarks. The first is, I won't speak as long as Mr. Sullivan, perhaps not as well either. Hopefully, I won't be as loud as Mr. Amirante. Mr. Amirante asked you not to consider sympathy. You should not consider sympathy. Don't consider sympathy for this defendant either. Some of the psychiatrists talked about having computers instead of jurors. They talked about being dispassionate. They left out something called common sense. A lot of us talked about it at the beginning of trial in the jury selection. You can't replace people with computers. You can't do psychiatric diagnosis by computers. We can't take a Minnesota multiphasic personality inventory and get a numerical score and say that a man who has killed 33 people isn't responsible for his actions. People aren't that simple. Justice isn't that easy. Mr. Amirante told you that John Gacy had an uncontrollable side, that he was encaged in his own flesh. So are we all, ladies and gentlemen. Each of us has good. Each of us has evil. Kunkel eyed each juror to bring home his point. And that which separates a social person and a human being with respect for life, with respect for the rights and properties of others, from the animals, is the ability to separate those parts yourselves. John Gacy separated those parts probably better than anyone I have ever heard of. The defense asked you to excuse John Gacy for the murder of 33 citizens of this state because he is so normal. What they are really saying to you is, here is a normal, everyday guy, and gee, why, we admit he killed 33 people, therefore, he's got to be crazy. So they put on witnesses to tell you what a great guy he is, to tell you how normal he is, just as we were putting on witnesses to tell you that, when they observed this man at important times, important dates, days of some of the crimes, even the day before some of the crimes, the day after some of the crimes. Those dates that I asked Mike Rossi about and other people about, those were specific dates. We wanted to show what John was doing on those days. How did he appear to people? They told you he was normal. They told you he was the same as he always was. As I listened to my opponent speak, as I watched him begin to pace and stalk the limited space just in front of the 12 jury members who would soon decide my client's fate, who would decide ultimately whether he would live or die, I stole a glance at the man sitting next to me, my client, the defendant. It is impossible to describe what I saw. It was as if John Gacy was watching the proceedings as a spectator, like he wasn't a party to the proceedings, like he was watching a baseball game or a Broadway play. He just didn't seem to grasp the fact that Kunkel was talking about him. He was fascinated by the drama without knowing that a very slow-moving bullet was heading directly toward his forehead. He didn't seem to get that this whole scenario was really quite permanent, quite irreversible. Half the time, he had the most ridiculous, shit-eating grin on his face, like you see on a country kid on his first visit to the big city. The rest of the time, he was mugging for the sad and the curious in the gallery. Finally, at long last, he was truly the center of attention. There have been villains throughout history, Kunkel continued. Dictators of totalitarian countries and mass murderers. All kinds of evil villains put on this earth. I think they probably all loved their children. I think they probably all formed genuine relationships with their wives. During the course of the investigation of this case, many of us that have been associated with it have experienced very strong emotions. There has been a necessity, through the presentation of the evidence in this case, for you to experience some of that emotion. As human beings, you will, I know you will, do the best you can to leave that emotion, leave sympathy and pity out of your consideration of the issues of this case. But don't for a minute feel there is something wrong with you, or you are not doing your job as a juror because you have felt these emotions, because we have all felt them. The time it came home to me in this case was very early on in the first week of the excavation on Summerdale. You have already seen this photograph, People's Exhibit 174, for identification. Bill Kunkel held up one of the hundreds of photographs that had been marked as exhibits. He showed it to each member of his captive audience. It's a photograph of grave number 8. Above the numeral in the dirt is a blue tennis shoe. On a plastic body bag to the left of the grave, on the dirt, is the other blue tennis shoe with a leg bone sticking out of that tennis shoe. I was at the house that day, and I saw it when that picture was taken. The thought that came to my mind at that time was of tying my daughter's shoes that morning before I left, and I thought, how in God's name did this man, with this tennis shoe, with those legs, with that boy in that hole in his basement, tie his children's tennis shoes? Psychoanalysts can't give you an answer to that question. Medical psychiatrists can't give you an answer to that question. The closest they can come is when Dr. Reifman told you John Gacy has no remorse because John Gacy has no remorse. If you think that you can excuse this man from these crimes because he was normal, then every hitman, every dictator, every organized criminals, every person that has learned to kill and learned to accept killing ought to be excused with him, because they are no different. They are no different. John Gacy learned to kill, and he kept on killing. And he knew he was killing. I don't doubt that he was able to show genuine love and care for both of his wives, for his original natural children, or for his stepdaughters later. All the doctors explain to you is that a sociopath or a psychopath has certain areas of certain relationships where his affect is shallow, where he doesn't form a true, loving relationship, where he doesn't really let himself be relied on by other people. In the true sense of the word, doesn't really form a lot of true relationships. But he can, still, within his own sphere, within those people that are important to his personality, his ego makeup, the way he looks at life, he can form those genuine relationships. And he did. He did. And that doesn't mean he can't tell and know that he is killing, and know that what he is doing is wrong. And those are the issues that you are here to decide. You are not here to decide why John Gacy killed. You are not here to analyze John Gacy or write a book on psychotherapy or plan a treatment plan for John Gacy. You are only here to decide the question of whether or not he was legally responsible for his actions at the time of these crimes and nothing else. If you want to restructure our society based on the psychoanalytical theories of Dr. Morrison, Dr. Broker, Dr. Friedman, and Dr. Rappaport, You know, the psychoanalysts, number 1, very seldom cure anyone. Number 2, their statistical percentage of predicting human behavior is less than a random guess. And yet they come here, on this witness stand, and, based on their own high-blown theories, ask you to excuse this man for murder. What would they have us do if we are to run our society the way they ask you to? Are we to seek out and find all the 3 to 5-year-olds that hide silk panties under the front porch and incarcerate them somewhere? Because if we don't, certainly they are going to become murderers. I'm guessing here, but I don't think there really are a great number of kids that would fit into that group. Maybe it wouldn't be too much trouble to keep a watchful eye on a kid that masturbates into his mother's underwear and then buries them under the house. Just saying. Kunkel continued in a discourse attacking the credibility of the defense's doctors. To listen to him, there were no insane people, only good people and evil ones. There were no gray areas, no nuances, no broken, damaged, or tragic individuals that were incapable of controlling themselves. Certainly there were no doctors that were able to determine such a malady. The bottom line problem with psychodynamic or psychoanalytic theories as it relates to the criminal justice system goes right to the core of their theories. And that is the predetermination. Because when you turn that around, what it really means is that no one is responsible for their actions. That is really what they are saying to you. We can't run society that way. The laws don't say that. Common sense doesn't say that. We must be responsible for our actions. We talk about some of them individually. Dr. Alicio. First, let me say that in no way am I blaming Dr. Alicio or inferring anything improper on his part, in terms of the way that he chose to base his testimony solely on psychological testing, not knowing any of the facts of the case. Now, he testified, based on what was given to him, on one day of testing, January 13th, 1980, after the court has ordered that the jury for this trial will be selected in Rockford, Illinois. Suddenly, out of the blue, never having appeared before on any discovery materials or any reports tendered or anything else, we suddenly get a report from a Rockford psychologist. But based on his one day of psychological testing, he tells you that he is able to look back in history, in his crystal ball, and tell you that John Gacy was a paranoid schizophrenia continually for at least an 8-year period of time from 1972 through 1980. I suggest to you that that opinion is patently ridiculous. It is a wonder why anyone would spend all those years, all that effort and time, studying the human mind, pursuing a PhD, when, according to Mr. Kunkel, it was a worthless exercise. It was patently ridiculous. One of the hardest things to do in a courtroom is to sit and keep your mouth shut while the other side attempts to take your case apart. At least in a bar, a tavern, or at the dining room table, you can interrupt the son of a bitch that you are arguing with. You can wave your arms around, show your dismay with poignant, well-placed sighs and grunts. A huge roll of the eyes and a disgusted shake of the head always come in handy. In court, however, these antics are frowned upon. They are a good way to wind up being held in contempt. Who writes these rules anyway? Certainly not an Italian. Mr. Kunkel went on. He was nowhere near done. He continued to rail against the defense's expert witnesses and their theories with reference to Mr. Gacy. He was fully convinced that this case was a classic struggle between good and evil. He seemed blinded to the possibility that there are damaged and broken brains in people, which cause them to act in ways contrary to their will. I always believed that this was actually helpful to our case. I believed, and still do, that it is easier for people to accept that an individual is either all bad or all good. The kid that pulls the wings off of butterflies for fun is never the kid that helps little old ladies across the street, and vice versa. However, when someone is capable of great good, but still commits unspeakable wrongs, there must be a reason. Something must be broken. Something deep inside that person is not working properly. It was my contention that further study was an absolute imperative if we, as a people, were ever to understand this dilemma. Evidently, Kunkel disagreed. What makes the defendant tick? Let's study him. Let's find out. Psychiatrists have been at it for 90 years now, since Freud, and man has been at it since the beginning of recorded history, and there have always been murderers. And, unfortunately, there will probably always be murderers. Now, I would like to know just how much time Dr. Friedman, in between testimonials, and Dr. Rappaport from Highland Park spend down in Stateville interviewing Richard Speck. Or how much time they spend going around the country talking to Charles Manson or whoever. What kind of nonsense is this? Decide your verdict so we can study the defendant? That's not an issue in this case. That's not an issue. It's a red herring. It's a phony. As he continued, Bill shifted his focus from the psychiatrists and physiologists and on to some of my specific arguments. Counsel talked about the Des Plaines police investigation. How can the defendant eat in the dining room with a body under the floor? Well, how do the guys at the morgue have lunch every day? One of the psychiatrists told you, how did the medical students chew on a sandwich that came out of the refrigerator with a cadaver? They get used to it. John Gacy got used to bodies. He was used to killing. He was comfortable with both. Why would he invite the cops in without a warrant? He knew they didn't have a warrant. He knew they weren't going to go down into the basement and start digging, or go up in the attic and start chopping. The same bravado, the same con man that he was always. Come on in the kitchen, let's talk. That's not out of character for John Gacy in the least. The concern for the uncle. His program wasn't working. He was being his charming self, and they were still hanging around. They weren't leaving. Let's get them out of here, get this over with. I've played enough. Now let's go on to something else. That is not inconsistent with his character. Remember that sociopath, that narcissist that is worried about his own hurts. He was worried about his own hurts, like in the comic record, The 2,000-Year-Old Man. He was asked, a 2,000-year-old man was asked to define tragedy and comedy. He said, tragedy is when I cut my finger, and comedy is when you fall into a manhole and die. Well, that's the way a narcissist thinks. That's the way John Gacy thought. When it is his relative that is dead, when it is his wife that is involved in sexual problems, then it matters. Kunkel continued to attempt to refute specific aspects of my closing argument. He was standing directly in front of the jury, making his claims, selling his side of the story. It was when he moved toward the easel with the pictures, the gallery of grief, that the courtroom and everybody in it found out what his plan was with reference to that little piece of demonstrative evidence. Bill began to speak specifically about individual victims. He proceeded to give his theory of the case with reference to how he and the rest of the prosecution viewed the evidence, specifically as it pertained to how each victim died and in what order. He used a map of Gacy's property to show where and when bodies were found by police investigators. The defendant, Kunkel asserted, tells us that on January 3rd, 1972, he picked up a young man in a Greyhound bus station and took him home. And through guile and cunning and talking about sexual acts and let's have a good time and let's party. And he remembers all of these conversations with details. He takes the young man back to his house on Summerdale, and they perform different homosexual acts. His recollection is that in the morning, the young man comes at him with a knife as he is waking up. He takes the knife away from him and stabs him to death. Now, body number 9, stab wounds of the ribs, verified by the radiologist. That's the first victim. He tells us he buried him under the house. Remember the testimony of his wife, Carol? Carol said when she moved in, there was an odor in the house. It came from the sub part of the house, this area. Bill Kunkel was pointing his finger and speaking his words with great emphasis. His passion was welling up. She complained about it. She kept complaining about it. There was some line mentioned, and then she said, "I want you to take care of it. I want something to be done." And while she was away, I believe she was in Minneapolis, the defendant poured some concrete in the crawl space. He puts the concrete over body number 9 to get rid of the smell. The only body in the crawl space with concrete over it. That confirms or corroborates his statement that the killing was on or about January 3rd, 1972, before Carol moved into the house. He began to become more and more animated. He was speaking faster, moving back and forth between the map and the easel. That easel bearing all those pictures. As he finished speaking about a particular victim, he would remove their picture from the easel. Later, at her request, he pours the concrete, and for a while, the smell gets better. In his statements, he talked about a second victim before John Butkovich, the next known victim. He said that he had that victim standing up on his head in the closet, and the blood drained out and got on his carpet. And he didn't make that mistake again. And that's when he started stuffing rags in their throats, because he didn't want to mess up his carpets. At one time, in one of his statements, he referred to one of the small maps that the police officers had and said he thought the second one was number 8. I think he was wrong in that statement. I think the second one was number 28. And I will tell you why. 28 is under the asphalt, out in the garage. Put in about 1976. 28 also under a couple of layers of concrete. 28 also out in the back, out by John's private domain, the garage. If number 28 was killed any time between the time that Carol moved into the house and the time that she moved out, well before Butkovich was killed, wouldn't it be logical for the defendant, at 3 o'clock in the morning, protected from view by his 10-foot hedges and the neighbor's garage and so on, to come out here in the back, in his private area, and bury that body in the yard that he knew was going to be asphalted over? You see, there are only 3 bodies with concrete over them. As John was learning, and as John was practicing, John got rid of the smell here on number 9 with some concrete. Put Butkovich under concrete. I think it's likely to assume that the one in between, also under concrete, also in back in his private domain, was number 28. Third, John Butkovich, July 31st, 1975. Keep in mind, the defendant has supposedly killed unknown body number 9. And possibly, at that time, unknown body number 28, as a result of this snowballing compulsion, this building terror, this conflict within himself over his homosexuality. Well, that's back in 1972, before 1975. And then, on July 31st, 1975, he kills John Butkovich. And what does he say about killing John Butkovich? He wanted to quit. He came over to my house and said I should give him his check. He wanted me to give him the money for the work he did for me. He threatened me, and I threatened to call the police, and he left. Later on, I went cruising, I found Butkovich and took him back to the house. I managed to get the handcuffs on him. He threatens to kill me if he ever got loose, so I killed him by strangulation. I tied a rope around his neck with 2 knots, placed a stick as a tourniquet behind his neck, and as he struggled or hyperventilated, he strangled himself. Now, that's what he said about killing John Butkovich on July 31st, 1975. Does that sound like a brief psychotic episode to you? Does that sound like an uncontrollable rage attack? He needed a piece of rope in the house. His tools and his other stuff were out in the garage. But he had a 2 or 3 foot length of rope ready in the house. Butkovich wanted to quit him. He wanted money. He wasn't about to give it to him. He went out and found him. Remember the testimony of Mr. Butkovich? When John Butkovich first went to Gacy's house to tell him he was quitting and asked for his paycheck, he went with 2 friends. Witnesses. He told him at that time he wanted his money. He wanted to quit. Well, Gacy must have had the compulsion. This is what triggered the rage attack, the brief psychotic episode. He must have killed him right there in front of the witnesses. He didn't do that? No. He went out in the dead of night at 2 or 3 in the morning, midnight, whatever, found him, took him back to the house alone. I got him into the handcuffs. He didn't say he wrestled him down to the ground and put the handcuffs on him. He did it the same way he always did it. The way the living victims on the stand told you he did it. The way that Eddie Lynch told you he did it, with a chain all the way back in Iowa in 1967. With talk, with con, with guile, with cunning. Put the cuffs on him. And Butkovich said, "If you let me out of these cuffs, you are a dead man." And John Gacy killed him. It's not a rage attack. It's not a rage attack. It's not a brief psychotic episode. It's not a product of a mental disease or defect. It's murder. Buried him. Number 2, under concrete, out by the shed. Kunkel snatched the picture of John Butkovich off the easel and added it to the others he was holding. He was beginning a pattern, very deliberate. As he finished speaking about a victim, the picture came off. Next, April 1976. Sampson, number 29. Look on the map for 29, under the dining room. The skilled prosecutor was leading the jury through the house, discovering each and every single body, one at a time. And with each discovery, another picture was added to the stack in his hand. After the time Carol was out of the house, the children were out of the house, John was in the house alone. Remember that dining room and the den, the family room addition, was on the house when John bought it. You remember the testimony of the investigators about recovering that body. Do you realize the work that was required to bury that body under that dining room, which was already there? Through the carpet, or whatever the top floor surface was, through the flooring, the subfloor, digging in between 2 floor joists to dig out that grave. Put the body into it, cover it up. They told you there was some ceramic tile over the top of the earth when they got to it, and it gave way. Well, which one of John's remodeling projects was that? Was the tile from the kitchen? Tile from the bathroom remodeling? Working on the dining room? Do you rip up all those materials and replace them in such a way that no one ever notices anything wrong with the dining room floor? Do you do that while you are having a rage attack? Do you do that while you are having a brief psychotic episode? Do you do that when your underlying paranoid schizophrenia erupts. May 14th, 1976. Samuel Stapleton, number 6. Again, Kunkel was pointing, telling a gruesome story, telling his version of the story. Mr. Kunkel was slowly getting louder and more emphatic. He was on the verge of breaking his promise to the jury that he would not be as loud as I was. Almost in the same grave. Bones intermingled with each other. Randall Reffett, May 14th, 1976. June 3rd, 1976. Michael Bonin, number 18, right here. June 8th, 1976. Michael Rick Johnston, number 23. Then, bear in mind, 23, 24, 26, 22, 21, all in the same trench. He ripped picture after picture from the easel. The number of pictures of dead teens and young men was growing in his left hand. He clutched them, waved them around. He moved between exhibits, the members of the jury gawking. Bear in mind that the numbering system used by the sheriff indicates the order of recovery, so that a higher numbered in relation to a lower numbered body means the higher number was underneath. Okay? So, we have Johnston, number 23. We have 26, 22, 21, and 24. 22 is William Carroll, June 13, 1976. 24, 26, and number 21, all in the same grave. Picture after picture came down as he spoke their name, or, in some cases, their number. Soon, he was holding them all in his left hand, waving them as he continued. Now the easel was empty, and the victims were all together. At the beginning of my remarks, as some of the other attorneys have said before, we are not asking you to show sympathy. You cannot. No matter what you do, you can't bring back these lives. Kunkel raised the stack of victims' pictures high over his head as he shook them for emphasis. The passion in his voice was apparent. He held them there for a beat. Then he held them out and showed them, as a group, one last time to the transfixed members of his jury. Don't show sympathy, he bellowed, raising the pictures again. Don't show sympathy. Show justice. Show justice. Bill's voice was reaching a crescendo. Show the same sympathy and pity that this man, he spat out his words while pointing at John Gacy, showed when he took these lives and put them there. While speaking, Kunkel swept his arm and his accusatory finger away from Gacy and across the courtroom. He was pointing directly at the horrific, gaping trapdoor to the crawl space with a shaking, fat index finger. The pictures of the dead victims raised high over his head. He took 2 short steps toward the crawl space and unleashed the entire stack of pictures into that dreadful, horrifying, ominous, cavernous black hole. I gulped. I heard various muted gasps from behind me, then silence. I think I lied before. That expression, "you could hear a pin drop," was actually created for this moment in time. No one talked or budged. Kunkel silently repositioned himself back in front of the jury. His voice returned to conversational tones. Mr. Egan told you at the close of his remarks, if there walks on this earth a man as evil as John Wayne Gacy, then God help us all. Well, you don't have the power to change the past, the villains and the fiends that have walked this earth before him, and there is no doubt that there will be some that will walk after. But you can control the future for this fellow. You can affect the present. You can do justice for all the people of the state of Illinois. You are their conscience. You are the people of Illinois now, and you must fulfill the oath that you gave as jurors. You must not allow John Gacy to use you. If you allow this evil man to walk this earth, this man, then indeed, God help us all." The silence in the courtroom was fading. People started shifting and whispering. Not a man to stand on ceremony, and, in an effort to move things along, Judge Garippo broke the silence and launched into the next order of business. He explained to the jury that he was about to instruct them as to the law. Without a lunch or a break, Garippo began reading the jury instructions. He figured that they would all have a nice long lunch while they began their deliberations. The jury instruction phase of the case was tedious but necessary. The judge read from printed sheets with one instruction per sheet. It took what seemed like forever. And then, as quickly as it began, it was over. Then the judge simply excused the jury to go deliberate. Chapter 37. There is a secret that has been passed down from lawyer to young lawyer for over a half of a century. The secret is kept from even the young lawyer until he or she is deemed ready, deemed worthy. It is the secret of genes. Only after a young lawyer has been bloodied in battle is the secret revealed. Then, and only then, will the young upstart truly appreciate the secret that has been shared by criminal defense lawyers that practice in the hallowed halls of the Criminal Courts Building at 26th and California, and now it has been passed down to him or to her. It is a time-honored tradition, a rite of passage, and when the secret is passed on, it signifies the official acceptance into the small club of courtroom brawlers that prowl the dark wooden churches where criminal justice lives and breathes. Gene's is a bar, a dark tavern where battle-scarred warriors wait for their juries to return. They wait with glasses full for the thumbs up or the thumbs down. They sit in relative quiet, licking wounds and second-guessing their opponents and themselves, under a picture of Clarence Darrow and others who have honored the tradition before them. Why is Gene's such a well-kept secret? Well, it is a 20-foot wide by 35-foot long, dark, wood-paneled room without a front door. Its only entrance, its only access, is off an alley a block away from the towering courthouse. It is the antithesis of the courthouse, a place to relax, a clubhouse where ties are loosened and wounded opponents sit together, drink together, and wait together. When you enter Gene's for the very first time, you know that you are a lawyer. On the way to Gene's, we were all laughing and trading Gacy stories, the prosecution team and the defense team, both prepared to wait, both prepared to console the other when the other received the bad news. Only one side could win the trial of the century. I bought a round as soon as we walked in the door. Kunkel promised that the next round was his. He never got to buy it. The jury was back. 1 hour and 50 minutes after they had been charged, they were ready. This was not good. Judge Louis B. Garippo addressed the court. "All right, before bringing the jury out, I have to announce that this jury, depending on the verdict, may not be finished with its duty. Therefore, it is possible, depending on their verdict, that they may be called upon to deliberate again on this case. Therefore, any visible reaction from the audience could impair and could prevent an orderly hearing. If this jury is called upon to deliberate at any future time." His eyes peered across the entire length and breadth of his personal domain with a look that said, "Everybody got that? Then call the jury." The jury filed in. Nobody looked at the defendant. "Mr. Foreman, has the jury signed 35 verdicts?" "Yes, we have." Will you pass them to the bailiff, who will pass them to the clerk? Each verdict is in order. Will you read them, please? We, the jury, find the defendant John Wayne Gacy guilty of the murder of Robert Piest. I was thunderstruck. The room was thunderstruck. Emotions poured silently out and turned into electric energy. The collective gasp was respectfully silent, but as heavy as a sledgehammer. Some of the relatives held hands, and tears began to flow. Over the loud silence, the clerk continued. We, the jury, find the defendant John Wayne Gacy guilty of indecent liberties with a child upon Robert Piest. We, the jury, find the defendant John Wayne Gacy guilty of the murder of John Bukovich. We, the jury, find the defendant John Wayne Gacy guilty of deviant sexual assault upon Robert Piest. We, the jury, find the defendant John Wayne Gacy guilty of the murder of Darrell Sampson. We, the jury, find the defendant John Wayne Gacy guilty of the murder of Samuel Stapleton. And so it went on. Each of 35 verdicts were read in full, with furtive shrieks and silent sobs accompanying the drone of the clerk. When the clerk finished, the judge went on. The attorneys will be seated, please. We all sat. Gacy remained standing. The judge continued. Ronald Geaver, did you hear all the verdicts as read by the clerk? Yes. Were they your verdicts? Yes. Are they now your verdicts? Yes. Mabel Loudenbach, did you hear the verdicts as read by the clerk? Yes. Were they your verdicts? Yes. Are they now your verdicts? Yes. Dean, what is the last name? Johnson. Dean Johnson, did you hear the verdicts as read by the clerk? Yes. Were they your verdicts? Yes. Are they now your verdicts? Yes. Again, the drone of the voice of the judge continued like that of the clerks before him, and the continuing recitation of name after name only served to heighten the drama and the sheer emotion. Then, the judge abruptly stopped the repetition. He said, All right, ladies and gentlemen, this concludes this portion of the trial. You will be returned to your quarters. You will be returned to this courtroom at 1:30 tomorrow afternoon. You are not free to answer any inquiries at this time from anyone making any inquiries relative to your deliberations. You understand that? See you tomorrow at 1:30. This case is adjourned until 10 a.m. tomorrow. The lawyers are expected to be in court at 10 tomorrow for the purpose of preparing for the subsequent hearings. I blinked my eyes, and I was back, standing next to my client. I really cannot tell you what happened during that blink. It all runs together as a continuous memory. The judge was talking again. Call the jury. Mr. Foreman, has the jury reached and signed a verdict? Yes, Your Honor, we have. If you will pass it to the bailiff to pass it to the clerk will read the verdict if it's in order. We, the jury, unanimously conclude that the defendant, John Wayne Gacy, attained the age of 18 years at the time of the murders and has been convicted of intentionally murdering the following individuals: Matthew H. Bowman, Robert Gilroy, John Mowry, Russell O. Nelson, Robert Winch, Tommy Bowling, David Paul Talsma, William Kindred, Timothy O'Rourke, Frank Landingen, James Mazzara, and Robert Piest. That these murders occurred after June 21st, 1977. We, the jury, unanimously conclude that the court shall sentence the defendant, John Wayne Gacy, to death. The judge looked solemn. This was not his favorite part of the job. He began to poll the jury. Ronald Geaver? Yes. Did you hear the verdicts? Yes. Were these your verdicts? Yes. Are they now your verdicts? Yes. David Osborne? Yes. Did you hear the verdicts? Yes. Were these your verdicts? Yes. Are they now your verdicts? Yes. Ross Putman? Yes. And so it went. Tears flowed from every eye in that courtroom. Tears of sadness, tears of defeat, tears of triumph, tears of joy, tears of satisfaction. Mothers and fathers, sisters and brothers looked up at the high ceiling, then through it toward the sky. Tears of relief cascaded down their faces. But most of all, there were tears of pride. Every person in that room had witnessed our system of justice at its finest. Everyone knew that they had witnessed a fair and just trial. Justice had spoken. Justice had won. The Constitution had won, just as its writers, our founding fathers, had envisioned it. I looked at Bob. We both had tears streaking down our faces. The flood of emotion was incredible. Every person in the room had shared the experience. It was not an easy moment. It was an overwhelming moment. People looked at the defendant. There he stood, right there, 20 feet away. We had condemned him, everyone in the room. We all had acquiesced. Did we have that right? The judge spoke. "Ladies and gentlemen," he said, "this concludes your jury duty. I spoke with the alternates before you. I spoke to them privately because I could not speak to them in open court. But on behalf of the Circuit Court of Cook County, I wish to first commend you for what you have contributed by your service." The judge had removed his trademark gold-rimmed glasses. He was wiping his eyes. Only one person in the room was dry-eyed. Only one. John Wayne Gacy stood at the defense table, bewildered and lost. The amount of emotion that flowed forth was like a flood that washed over one and all, even the strong. The ones that thought they would enjoy this could not escape it. The judge continued, his voice cracking, clearly moved. "A couple of months ago," he said, removing his glasses once again, "a group of prosecutors from another country came and couldn't understand how in the United States you could try a person who was arrested of this type of situation. A lot has been said about how much this case has cost, and I don't know what it cost. I don't know if anyone could put together the cost. But whatever the cost was, it's a small price. My voice is cracking because I really, truly feel it's a small price that we paid for our freedom. What we do for the John Gacys, we'll do for everyone. I thank you. You are now excused." The judge wiped his eyes one last time. His job was not over. He had a task yet to perform. The hardest task of all. He looked at Gacy. "Step forward," he said. "Under the laws, as I interpret the law, this jury verdict, I have interpreted it as not binding on the court. The statute is written in such a way as to indicate that it is binding on the court, but I find it is not binding on the court. Does anyone have anything to say before I impose sentence?" Bob was the first to speak. "Judge, at this point, I'd ask make a motion, just perfunctorily, for judgment notwithstanding the verdict by the jury, based on what I consider to be mitigating circumstances that exist in the record." I was next. "Just all over the record, Your Honor, there is no question. If anybody ever fit the extreme emotional or mental disturbance in this statute, it's John Gacy. We'd implore Your Honor to give a judgment notwithstanding the verdict of this jury." Judge Garippo looked at us. He was resolved. He had no choice. He looked at John Wayne Gacy, who stood before him. "On the 12 indictments, 79-2382, I sentence the defendant to death. 79-2399, I sentence the defendant to death. 79-2393, I sentence the defendant to death. 2391, I sentence the defendant to death. On all other indictments, I impose a sentence of natural life. I set an execution date of July 1st, 1980. There was a quick discussion about the date. A statute required the date to be in excess of 90 days. Oh yes, I have the wrong date. I have the wrong month. June 2nd. I set the execution date on June 2nd, 1980. Execution is stayed automatically. Minimus to issue. Are there any other motions? Bill Kunkel moved to dismiss 3 lingering misdemeanor cases that had been filed against the defendant. It seemed silly. Garippo said, "Allowed." And that, as they say, was that. Gacy was taken from the room. Chapter 38. John Wayne Gacy died on May 10, 1994, as a result of a lethal injection administered on behalf of the people of the state of Illinois at Stateville Correctional Center, Crest Hill, Illinois. It has been reported that his last words were, "Kiss my ass." Sounds like him, doesn't it? I don't know if those were his last words. I wasn't there. By the time he died, Gacy had repudiated everything that Bob and I did on his behalf and in his defense. He used ineffective assistance of counsel as one of his many issues on appeal. By the time he shuffled loose this mortal coil, he was not only claiming that he never killed anybody, but I am pretty sure he believed that claim. Crazy people firmly believe their delusions. There are certain individuals that have lived throughout history that elicit an immediately negative and profoundly visceral response in everyone who hears their names spoken. Just the mention of the name will often launch an argument. John Wayne Gacy has most certainly joined the ranks of these individuals. For a time, Gacy was the most hated man in America. He has since been replaced many times over. America has plenty of most hateds to go around. Thousands of people attended parties celebrating his death all across the nation on the night that he died. You've heard of the Macy's Day Parade? Well, on that day in May, there were Gacy's Day parades all over America. For me, I didn't celebrate, as you might imagine. Neither was I sad, exactly. It's a hard emotion to describe, actually. I certainly wasn't losing a friend. I never considered John a friend, although I did spend more time with him during the year 1979 than I spent with my wife and kids. I never really even liked him much. He was too much of a braggart and too goddamn weird for me. But John Wayne Gacy did grow on people over time, in spite of his foibles and peccadillos. Just ask the guys that followed him around the city of Chicago for weeks. If you focused on what he did, of course, he was the worst human being on the planet, no question. But if you actually knew him, it was somehow different. It was oddly possible to look past the monster that the world saw and see the sad excuse for a human being inside. The damaged, broken individual that spent most of his waking hours on earth confused, ashamed, bewildered, totally lost, and still trying to please a father that was both long gone and not able to be pleased in the first place. Because he, too, was a waste of human space. John's aura, if he had one, was not evil. It was pathetic and sad. Most of all, and in spite of everything else, John Wayne Gacy was my client. When someone hires you to be his lawyer, he or she puts total faith in you. It is a very special and complicated relationship, somewhere between a doctor and a priest. Certainly not one to be taken lightly. It is a privilege to have a person seek counsel from you, to put unconditional trust in you. That is no simple thing. You owe that person a duty that is higher than most, and yes, a bond is formed. So I guess I had a bond with John. A singular and convoluted bond, but a bond nonetheless. I fought for that man's life for over a year, like a medic on the battlefield, knowing full well that the effort would not likely be rewarded. And like that medic on that battlefield, I didn't stop to judge him. I just fought with everything that I had in me. Did John Wayne Gacy deserve my efforts? Yeah, he did. Every human being deserves counsel in a free society, no matter what the charge, no matter what the cost, no matter what. That was his right, and he had acquired that right from a place far above my pay grade and yours. Only one other person on this planet could share the once-in-a-lifetime emotion that was haunting that day. Bob Motta. Like me, he fought tooth and nail for the life of a hated man. Like me, today he too had finally lost that battle. So, no, I wasn't celebrating. Not today. I called Bob. I hadn't seen him very much during the ensuing 14 years since the jury's verdict. Oh, I'd bump into him from time to time, of course. We were both lawyers, and there are always functions and chance meetings in courthouses. But we had both moved on. Him with his practice and me with mine. I had partnered with Jim Etchingham and had a thriving practice for a time. Still in Park Ridge, 200 South Prospect, right next door to my first office in the 222 building, where Gacy had first confessed his nightmare. Then, in 1985, I was appointed to the bench as an associate judge of the Circuit Court of Cook County. I was now dispensing justice instead of fighting for it. It was good to hear his voice. We made plans to meet at a local bar, a bar where many of my old Marine buddies sometimes hung out. The bar, the Northwood, was tucked into the corner of a tiny strip mall where Summerdale Street meets Cumberland Avenue, just a block and a half from where Gacy's house once stood. I walked into the bar around 7 o'clock and looked around. This was a place where men drank draft beer or shots of whiskey and watched sports. A tavern. There were no disco balls or bright lights. The primary color scheme was brown. There they were, many of my closest friends. They were all smiling, but not really. Etchingham, Hussey, Joey Etch, Kinahan. What a motley crew. If you knew me, you knew this was no celebration. Of course, it was no wake either. Bob Motta was sitting at the bar eating a beef sandwich. I walked over to him. I gotta go pick up Sammy in a little while. How are you doing? I think you know, he said. We talked for a while. I talked to everybody there. When I left to pick up my son from a school function, I really intended to come back to the bar. Somehow, that idea left me once I got home with my family. My wife was surprised. I was usually the center of attention. I usually liked crowds. We all just went for a hot dog. I didn't feel like doing much else. When I walked into the Plush Pup, a local hot dog stand, the guy behind the counter was smiling at me. "How are you going to celebrate the Gacy execution?" he asked, slapping onions on the dogs. I chuckled a little. "I am probably one of the only people in this town that is not celebrating," I said, thinking of Bob. I was the guy who defended him in court. I was his lawyer. The guy's swarthy ethnic face went blank. He almost dropped his onion spoon. "You're kidding." No, I'm not. When I got home, my wife and I turned on the TV. There was Bill Kunkel arguing with Walter Jacobson, Chicago's answer to Walter Cronkite. They were in the throes of an earnest discussion about whether Gacy had been given drugs to ease the tension before he was taken to the gurney. Jacobson was sure he had taken some kind of drug because he had seen a flutter in Gacy's eye. A flutter in his eye. A flutter in his eye. I had seen that flutter before. If they only knew, I thought. Gacy wasn't even there. He wasn't even present. He had already gone to that dark place he had been so many times before. Gacy didn't need drugs. His brain was broken. I thought about the guy at the hot dog stand. I was his lawyer, I had said. I thought about a telephone call that I received 15 years ago. Sam, could you do me a favor? Epilogue. 13 psychologists and psychiatrists testified during the trial of John Wayne Gacy. Each was a noted expert. Most were published authors and professors at this country's most prestigious institutions of higher learning. Yet, after hours of interviews, study, and contemplation, none of these learned men and women diagnosed Mr. Gacy in exactly the same manner. Gacy was an enigma. After reading the Gacy story, it doesn't take a psychologist or a psychiatrist to see the tormented soul that haunted Gacy's sickly frame. Once he confessed his crimes on that eerie night in Sam's office, he began admitting his horrific deeds to almost anyone who asked. But there was one thing that he would never admit. This one perceived transgression he took with him to his grave. He would admit to the most heinous string of brutal murders the world had ever seen, but he would never admit that which he considered his most horrendous and well-guarded secret. He was homosexual. Gacy grew up with a father who berated him daily for not living up to preconceived notions of what a man should be. School kids and neighbors who bullied and tormented him, and a society that struggled with acceptance of a lifestyle it did not understand. As a result, no one hated John Gacy more than John Gacy. During the trial, we had a discussion in Judge Garippo's chamber. The issue was whether or not a witness would be allowed to take the Fifth Amendment if he were asked if he had engaged in homosexual acts with John Gacy. The judge never had to rule on the issue. The question was never posed. But the fact that the issue had been debated at all, even for a minute, says something about the attitude of the time. Homosexuality is not a crime. The Fifth Amendment to the Constitution protects against self-incrimination, not self-embarrassment. Therefore, the issue should never have come up. Nonetheless, it was the subject of some debate and consideration. Thankfully, times have changed somewhat. A lawyer concerned with such a question would get laughed out of most judges' chambers. This country has taken great strides to eradicate the scourge of the many misplaced prejudices from which we have suffered as a nation over the years. The sad results of some of our history's mistakes, slavery, racism, sexism, McCarthyism, are slowly becoming memories of troubled days gone by. Isn't it finally time to assign our most glaring leftover active prejudice, homophobia, to the pages of a history book? Are you good with dates? There is one date in this book that kind of jumps off the page. December 11th, 1978. Do you remember what happened on that date? John Wayne Gacy brutally murdered Rob Piest, his last victim, on that date. What was supposed to happen on that very same date, in that very same year? John Wayne Gacy was supposed to be released from the Iowa Men's Reformatory in Anamosa. John Wayne Gacy was sentenced to 10 years in prison by the state of Iowa, pursuant to an order signed by Judge Peter Van Metry on December 11, 1968. If he had served his full term, if he had stayed in that prison for his full sentence, Mr. Gacy's release date would have been December 11, 1978. Maybe we should stop putting pot smokers, prostitutes, and petty thieves in prison and leave some room for the John Wayne Gacys of the world. Enough said. It is hard to imagine that this story could ever have anything akin to a silver lining. However, you know what they say. Whenever a door is closed, a window opens. Sam L. Amarante, my co-author and friend, may have done the one thing that could possibly qualify as a right to this terrible wrong, as something good coming from this horrible tragedy. In 1984, inspired by his involvement in the Gacy case, he personally authored procedures adopted by the Illinois General Assembly as the Missing Child Recovery Act of 1984, iSearch, which eliminated the 72-hour waiting period to initiate a search for lost children. And he is credited with helping to locate countless thousands of missing children in our state and reuniting them with their parents. For the first time in Illinois history, the report of a missing child immediately triggered a statewide search, incorporating the resources of local and municipal police forces all across the state, in cooperation with the Illinois State Police. As other states adopted similar laws and similar sensibilities with reference to missing children, it became possible to create the national network now known as a Child Abduction Emergency, or CAE, commonly referred to as an Amber Alert. Therefore, these boys: John Butkovich, 18; Daryl Sampson, 18; Samuel Stapleton, 14; Randall Reffett, 15; John Prestige, 20; Matthew Bowman, 19; Robert Gilroy, 19; John Mowry, 19; Timothy O'Rourke, 21; Frank Landigan, 19; James Mazzara, 20; Robert Piest, 15; Michael Bonin, 17; Rick Johnston, 17; Gregory Godzik, 17; William Carroll, 16; John Sink, 19; Russell Nelson, 21; Robert Winch, 16; Tommy Bowling, 20; David Talsma, 19; William Kindred, 19; and 11 more did not die in vain. Author's note: one of the cornerstones of an attorney-client relationship is the privilege of confidential communication between an attorney and his or her client. That privilege is time-honored and sacred, and should not be broken, even after death. However, it was John Gacy's desire to have the true story known even after his death. I have labored over the issue of privilege in this matter for many years. Although John Gacy was perceived as a monster, he was, in fact, a human being who, like any other, deserves to have the historical record set straight. He always wanted his story told and the truth known, as evidenced by a general release and waiver of the privilege given to Bob Motta and me long before Gacy's death. There have been numerous rumors and much speculation which have embellished the true facts of this case. For instance, there were rumors of cannibalism, mutilation, freezing of body parts, other murders, and bodies being hidden in other parts of the country, all of which are untrue. We write this book to set the historical record straight. Furthermore, all of Gacy's statements contained in this book were also made by him in numerous other and disjointed ways over the years, and all have been a matter of public record prior to the writing of this book. The defense of John Gacy had little or nothing to do with privileged communications. From the beginning, and against my advice, he fully confessed to the police, in his words, to give his victims a proper burial. The basis of our defense was to save his life and allow him to stay in a structured environment where he could be studied and hopefully prevent a repeat of such horrific crimes. This book continues that fight for knowledge, preventive intervention, and human dignity. Sam L. Amarante. This has been an Audible Inc. production of John Wayne Gacy, Defending a Monster, written by Judge Sam L. Amarante and Danny Broderick. Narrated by Robin Bloodworth. Producer Mike Charzik. Copyright 2012 by Sam L. Amarante and Danny Broderick. Production copyright 2012 by Audible Inc.
Audible hopes you have enjoyed this program.